This writ petition was pending, correct?
Yes, yes, my lord.
Same would apply. 38893. 38893. ಅದು ತೆಗಿರಿ ಅದು ಗಾಟ್ ಇಟ್ ಅನ್ನೋದು ಅಥವಾ ಆ ಮೇಲ್ಗಡೆ ಆ ಎಕ್ಸ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಮೇಲ್ಗಡೆ ಹಾ
My lordship, am I audible?
ಕೋರ್ಟ್ ಡಿಸ್ಕನೆಕ್ಟ್ ಆಯ್ತು ಅಂತ ಹೇಳ್ಸುತ್ತೆ. ಅದು ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಏನೋ ಬಂತು ಅವಾಗ ಏನೋ.
ಅದೇ ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಬಂತು, ಕೋರ್ಟ್ ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗಿದೆ ಅಲ್ವಾ?
ಹೌದೌದು.
ಶ್ರೀನಿವಾಸ್ ಗೌಡ್ರೆ
ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗಿದೆ, ಕೋರ್ಟ್ ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗಿದೆ.
ಗೊತ್ತಾಯ್ತು ಶ್ರೀನಿವಾಸ್ ಗೌಡ್ರೆ.
ಗವರ್ಮೆಂಟ್ ಏನ್ ಟಾಪ್ ಆಯ್ತಲ್ಲ ವಿಡಿಯೋ?
ಇಲ್ಲಿ ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗಿದೆ. ಓಕೆ, ಆಯ್ತು. ಓಡ್ಲಾ ಸರ್? ನಾನೇ ಫಿಕ್ಸ್ ಎತ್ಕೊಂಡು
ಯಾವ್ದ್ರಿ? ಸೀರಿಯಲ್ ನಂಬರ್ 16. ಸೀರಿಯಲ್ ನಂಬರ್ 16. AGA ಶ್ರೀನಿವಾಸ್.
AGA ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗಿದೆ ಅಂತ ಕೋರ್ಟ್ ಅಲ್ಲಿಗೆ ಹೊರಟ್ರು ಸ್ವಾಮಿ.
ಇಲ್ಲೇ ಬರ್ತಾರೆ.
ಇದು ನಮ್ಮ ಕೊಲಿಗ್ ಬರ್ತಾ ಇದ್ದಾರೆ ಸರ್, ಕೋರ್ಟ್ಗೆ ಬರ್ತಾ ಇದ್ದಾರೆ. ನೆಟ್ವರ್ಕ್ ಸರಿ ಇಲ್ಲ.
ಆಲ್ ರೈಟ್.
ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ ನೋಡ್ರೆ ಇದನ್ನ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡೋ ಕಾಣಿಸ್ತಿಲ್ಲ. ನೀವು ಯು ಆರ್ ನಾಟ್ ರಿಯಲೈಸಿಂಗ್ ದಿ ಕಾನ್ಸಿಕ್ವೆನ್ಸಸ್ ಆಫ್ ದಿಸ್ ಡಿಗ್ರಿ.
ರಾಮ್ ಭಟ್. ಶ್ರೀನಿವಾಸ್ ಬಂದ್ರು. ಯಾರು ಇರ್ಲಿಲ್ವಾ ಪ್ಯೂನ್ಗಳು? ಈಗ 15 ವರೆಗೂ ನೀವ್ ಹೇಳಿದ್ರಿ, 15 ವರೆಗೂ ಆಗಿದೆ ಇದುವರೆಗೂ. when did the ordinance come into force? 13th July 2020. ಈಗ ಸೀರಿಯಲ್ ನಂಬರ್ 16 ಏನ್ ಹೇಳ್ತೀರಾ? ಅಲ್ಲ, ಒಂದ್ ನಿಮಿಷ. This writ petition is filed after 13/7/2020. When was the order of the KAT passed? It was passed on 27th of April 2018. Andre no proceedings were pending as on the date of the ordinance. Mr. Rambhat. In ಮಿಕ್ಕಿದ ಮ್ಯಾಟರ್ಗಳೆಲ್ಲ ಹಂಗೇನಾ? In all other matters. Next, they were filed after the ordinance was passed. But ಇದರಲ್ಲಿ 16 ಅಲ್ಲಿ till 15 you have correctly stated that it was pending. Correct ಆಗಿದೆಯಾ? ಚೆಕ್ ಮಾಡಿದೀರಾ? So ಇದು serial number 16 will have to be heard. Will have to be heard. Serial number 16 ಅಲ್ಲಿ list this matter on 7th of February 2022 in a separate list. Yes.
Appear for the petitioner, my lord. The assistant appear for the petitioner, my lord. May audible, my lord.
No, same as 24309.
Assistant may audible, my lord.
Yes, yes.
The
Disposed
assistant
of,
commissioner pass it.
remanded back to the assistant commissioner.
Please, my lord.
18 Amrut. Appearing for the petition. So this the order passed by the commissioner. I prepared this.
ಇದ್ರಲ್ಲ ನೋಟಿಸ್ ತಗೊಂಡಿದ್ರಾ ನೀವು ಮುಂಚೆನೆ? ತಗೊಂಡಿದ್ದೀರಾ?
ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ?
Serial number 18.
I am appearing for petition.
So same as 24309. Yes.
Same as
309.
Number 20. Next week.
24309. Yes.
Number 21. Kumara KG. This matter, income excess and that is the reason for protection.
Sorry.
It has to be considered.
It
has to be considered. Petitioner had appeared and.
ಅಲ್ಲ ಅದು ಸರಿ. ಆದ್ರೆ when was that order passed?
Order was passed on 24/1/20.
Order of the assistant commissioner.
Yes, sir. 24th January 20.
24th January 2020.
Yes.
Then why have you not Mr. Kumara KG? Mr. Kumara KG?
Number 21 Kumar KG.
They should have filed a appeal before the KAT. They have not filed.
They have directly approved since the
You have taken notice.
Yes, ma'am. Yes, please.
Matter on 11th of February 2022 in a separate.
Blood agenda.
Serial number 22.
Mr. Manjunath ND. File ಇಲ್ಲ ಕೊಡ್ರಿ ಅವ್ರಿಗೆ. Mr. Manjunath ND.
Has to be back to
24309. 24309. Yes.
23. Girish D. Torre.
For petitioner, my lords. In this case, notice not
ಯಾವಾಗ
given.
ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿರೋದು?
22/12/2018, my lords.
So same as 24309. Yes.
Remitted to the assistant commissioner or
Yes, assistant commissioner.
much obliged, my lords.
Yes.
24. Emana Siddhaya HK. This was to have to go before the KAT.
KAT. They have not filed an appeal.
Not present.
When was that order passed?
28 February 2020.
Angadre, there is one more order that we have passed, directing them to go before the KAT. So the same order will have to be passed in
6931 of.
serial number 21.
Yes, sir. Yes, sir.
Al serial number 21 ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಮ್ಮ. Matter has been remanded back to the Karnataka Appellate Tribunal by this court. ಸೇಮ್ ಆರ್ಡರ್ ಅಂತ ಬರ್ಕೊಳ್ಳಿ, ಅವ್ರನ್ನ ಕೇಳಿ ಯಾವ್ದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದೀವಿ. ರಿಮಾಂಡಿಂಗ್, ಡೈರೆಕ್ಟಿಂಗ್ ದಿ ಪೆಟಿಷನರ್ ಟು ಅಪ್ರೋಚ್ ದಿ Karnataka Appellate Tribunal by filing an appeal, and the tribunal was directed to consider the appeal. Same order. Serial number 21. ಮತ್ತೆ 24. 24 ಅಲ್ಲಿ ಇನ್ನೊಂದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇದೆಯಲ್ಲ.
That is on merits by the KAT, and it holds that there is excess of income. It has to be heard separately.
ಅಲ್ಲ. When was that order passed?
Yes. It was passed on 6th September 2019.
2019.
Yes, sir. KAT passed on 6th September 2019, holding that there is excess of income.
This was filed on 15th of July or 2021.
Yes, sir. After
2020.
1 year of the audience.
List this matter on 11th of February in a separate list.
Please.
ಮೇನ್ ಮ್ಯಾಟರ್ ಅಂತಲ್ಲ, ಅದು ಕನೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ಅದು ಡಿಸ್ಪೋಸ್ ಆಯ್ತು, ಇವಾಗ ಇದು ಸಪರೇಟ್ ಆಗಿದೆ.
In this matter, the order of ACR, which is passed in the year 1996, is on the challenge.
1996.
Nearly after 17.
ಆಯ್ತು. ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆಯಾ ನಿಮ್ಗೆ?
Yes.
ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 11th of February. ನೀವು ಇದರಲ್ಲೆಲ್ಲ you will have to collect information. See, after the order has been passed by the competent authority and it has reached finality, what should happen to the land that has been declared as and forfeited to the government? Ado that was supposed to be re-granted to some other person. Alva? So their argument will be that it is not re-granted. It is still available in the hands of the government, and therefore give it back to us. So you will have to verify whether it has been re-granted. Adunnu one order pass ಮಾಡಿದೀವಿ ನಾವು, directing you to find out. So the same thing will apply in these matters. If the land is already re-granted to some other persons, that is the end of the matter. Illa antandre the proceedings are still pending because it is not re-granted to anyone anta our argument tar. Of course it will be heard, but basically you will have to get information as to whether it has been re-granted or not. Yes. Yes. Mr. Ram Bhatt.
In this matter, the appeal came to be dismissed by the KAT. Then they file a review petition, and the review petition also came to be dismissed.
ಆಯ್ತು.
That is under challenge.
Correct. ಯಾವಾಗ? When was that order passed?
Because the dismissal order was passed in the year 2019.
19. And this is filed after the ordinances. Notice order ಆಗಿದೆಯಲ್ಲ?
Yes.
The 11th of February.
Swami P. 27. This is also regarding the excess and after ordinance they have applied this.
Allah, but when was the order passed? 2019. 11th of February.
P8, Raghu Prakash, Babu D. P8.
ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ ನಿಮ್ಗೆ? ಯಾವಾಗ ಆರ್ಡರ್ ಪಾಸ್ ಆಗಿರೋದು?
ಇವಾಗ ನಡೀತಾರೆ ನಿಮ್ಗೆ ಇವಾಗ ಜಸ್ಟ್ ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರ್ ಕರೆದ್ರು ನೋಡಿ.
ಅದು ಎಸಿನಾ?
ಸರ್ ಒಂದು ನಿಮಿಷ, ನಂದು ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಚ್ ಅದ
2017. But where do we draw the line? ಇವಾಗ 2018 ಎಲ್ಲ we have remanded. 2011 we said we will hear. ಇವಾಗ 2017 ಇದು ಏನ್ ಮಾಡ್ಬೇಕು? Why not an order of 2011 then? Where do we draw the line then? Huh? The idea is ultimately that after the forfeiture order is passed, if the land is re-granted to some other person, that is the end of the matter. Hang nodre 2011 matter also same, we could have disposed of remanding it to the assistant commissioner. Huh? ಇದು ಅಷ್ಟೇ, ಇವು ಅಷ್ಟೇ. All these matters are same. Whether it is 17, 18, 19, ಯಾವ್ದಾದ್ರು ಅಷ್ಟೇನೆ. They are all filed after the ordinance is passed to get the benefit of the deletion of the provision. But where do we draw the line anta? Why it should be remanded or why it should not be remanded? ಅವ್ರು ಹೇಳೋದು provisionally it is very clear. In subsection 1 of section 20, it says this would not apply to all proceedings which have attained finality. Now what is finality? Whether it is only the order that is passed which has not been challenged, or would it continue till the land is re-granted to some person? ಈ ಪ್ರಶ್ನೆ ಬರುತ್ತೆ ಇದರಲ್ಲೆಲ್ಲ. But the intention of the government is to see that these proceedings are not initiated any further. It's a policy matter, of course. Earlier, when the provision was brought, it was said the lands have to be given only to agriculturists who are going to cultivate the lands. Now that policy itself has changed, the government is of the opinion that anyone can purchase agricultural lands. If that is so, if the lands have not been re-granted to any other person, so even if the order is passed in the year 2011 or in the year 1997, 98, in some of these matters that have come up, what will be your stand? Adene. ಹೌದು. ಹೌದು. ಅಲ್ಲಿ ಕೆಲವು ಮ್ಯಾಟರ್ಗಳಲ್ಲಿ ವೈ ವಿ ಆರ್ ರಿಮಾಂಡಿಂಗ್ ದಿ ಮ್ಯಾಟರ್ ಬ್ಯಾಕ್ ಟು ದಿ ಟ್ರೈಬ್ಯುನಲ್ ಈಸ್ ಬಿಕಾಸ್ ಅಲ್ಲ it is only a few months after the order was passed that the ordinance has come in. There was always an opportunity to the petitioner to file an appeal. Even if there is a delay, application will be filed seeking condonation of delay. Alva. So that is why we have remanded the matter back. Illi, this order is passed in the year 2017. Now, where do we draw the line as to why it has to be, when it has to be remanded back to the assistant commissioner, or it requires a hearing? Then where do we draw the line?
In these matters, what has happened is, before the assistant commissioner, the petitioner did not have opportunity to represent their case and file the documents. As such, they came to the past without providing them any opportunity to present their case. It is in view of violation of principles of natural justice, these matters are being remanded.
What is it?
The respondent.
The notice of inquiry into allegation of violations duly served on the respondent. The authority proposed to conduct inquiry into the above said allegation, and the respondent is under obligation to satisfy the authority. The respondent did not appear. We will remand this matter. Same as 24309. Yes. Order ಯಾವಾಗ ಪಾಸ್ ಮಾಡಿರೋದು?
Passed on 21/4/2014.
ಏನಪ್ಪ? ಆಯ್ತು. Same as 24309.
Yes. Sampath.
My lord, sir, serial number 27, my lord, sir. I appear for the petitioner. I'm sorry, my lord, sir.
That will be relisted. That will be relisted. Yes.
Please, my lord.
30. Apat Sampath. Serial number 30.
File ಕೊಡಪ್ಪ ಅವರು.
This order is 2018.
No notice. ಆಯ್ತು ಅಮ್ಮ
Chandrasekhar Patil.
ಫೈಲ್ ಇಲ್ವಾ?
Water passed in 1990 and KT crossed the water in the year 2013.
2013.
It has to be answered. Cannot get the benefit of water.
11th of February.
32, Raghu Babu here. 32.
No, it's water taken 31 in 2004.
Right. Same as 24309.
Yes, Ram.
No notice. 24309.
Number 34.
This has to be word separation.
Sukumarappa.
Yes, demand was explanation before the assistant.
It means he was heard. He was heard. When was the order passed?
27 January 2020.
2020.
6 months before the audit.
Then he had to file an appeal before the tribunal. Wow. Same order. KAT-ಗೆ ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿ ಅಂತ ಅವಾಗಲೇ ಹೇಳಿದ್ವಲ್ಲ.
17 ವರ್ಷ ಗೊತ್ತಾ ನಿಮ್ಗೆ?
35. Ajunatha JV.
2014 order. He appeared, but he did not file the documents.
ಅಪಿಯರ್ಡ್ ಅಂತ ಹೇಳ್ತಾರೆ, ಅವ್ರು ಹೇಳ್ತಾರೆ ಅಪಿಯರ್ಡ್ ಅಂತ. Even in the other matters also we have recorded your submission that it shows that he has appeared ಅಂತ. But he has not. ಯಾವಾಗ ಆಗಿರೋದು ಆರ್ಡರ್ ಅದು?
2nd April 2016.
2016. ಹಂಗಾದ್ರೆ 2430.
Number 36. Srinivasa. Mumbai. 36.
Water came to be passed.
2309.
Number 37. Nitin here.
This preparing for the respondent.
Preparing for petitioner in this matter, my lord.
Not.
My lord, what is happening, my lord? Notice ಆಗಿದೆ sir.
ಇದು LR ಅಲ್ಲ, ಇದು ಆಕ್ಚುಲಿ KLR ಅಲ್ವಾ ಇದು?
ಹೌದು ಸ್ವಾಮಿ.
Nitin, this is a KLR matter, not
KLR
LR
matter, my lord. Yes, it has to be KLR, my lord.
Office is directed to reclassify this matter as a KLR. Notice order ಆಗಿದೆಯಾ? Release this matter on 10th of February.
With your lordships, kindly leave, my lords.
ಫೋನ್ ಮಾಡಿದ್ರೆ ಕಾಫಿ ಬೇಕಾ ಅಂತ.
My lords, in serial number 10 to 12, there was some connectivity problem. AC order is of 15, my lords.
ಯಾವುದು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್?
Yes, my lords, 10 to 12. AC order is of the year 2015, my lords, and tribunal order is of the year 2017.
ಆಯ್ತು, it's all disposed of. It's all disposed of.
My lords, please, my lord.
It is disposed of in your favor.
Please, my lord. Is it remanded, my lord?
Remanded ಅಲ್ವಾ? Yes.
ಇಲ್ಲಿ ಬಂದು ಕುತ್ಕೊಂಡು ಕಾಯ್ಕೊಂಡು
Yes.
ಗ್ಯಾಲಕ್ಸಿ M12 ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಟೈಮ್ ಪಾಸ್ ಹೋದಂಗ ಆಗುತ್ತೆ, ಒಂಥರ ಬೋರ್ನೆಸ್ ಇರಲ್ಲ ಆಗ.
Serial number 1, list number 1.
My lord, I am appearing for petitioner, my lord. Matter pertaining to Tasdik, my lord. First respondent has rejected the application filed before him for revision of the stick, my lord. My lord, one submission, my lord, it has to be classified as GM res, but register has classified
GM?
as LR res. GM res.
GM res ಇದು
Yes, my lord.
GM res
ಹೌದು my lord. ರಿಟ್ ಪಿಟಿಷನ್ 8 ರಿಟ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದ್ರಿ, ಅದೆಲ್ಲ GM res ಅಲ್ಲೇ ಫೈಲ್ ಆಗಿದೆ, ಇದೊಂದು ಮಾತ್ರ LR res ಫೈಲ್ ಆಗಿದೆ.
Learned counsel submits that this matter is required to be classified as GM res. Stop. Office to take note and list this matter before the roster bench.
Much obliged, my
Case number 2. Sharat S. Gowda.
Lord, pray to appear for the petitioner, my lord. My lord, the regularization.
Yes.
My lord, pray to appear for the petitioner, my lord.
Yes.
My lords, the regularization committee, my lords, resolved to regularize the occupation of the petitioner. Void order dated 4/10/2007, that is at Annexure C. The name of the petitioner, my lord, is at serial number 72, page 95. This regularization committee's order is set aside by the assistant commissioner by the impugned order at Annexure A. The operative portion of the order is at page 71. It says under 108K, the resolution has been set aside. Well, that's under 108K of the Karnataka land revenue rules. No order can be passed without giving a notice to the grantee. I am not a party at all to these proceedings. And I was not aware of this order also.
732 persons have been cancelled.
Cancelled without giving notice to the grantees. If your lordship is kind enough to see 108K.
On what grounds has it has been cancelled, sir?
Lord, on the irregularities of the committee, my lords. On the ground of irregularities by the committee, my lords, it is noticed and therefore, but of course, my lord, they are entitled for the notice. And my lord, a series of
irregularity andrenu?
Within the period of 3 months, my lord, 700 persons have been granted without following the procedure contemplated under the act and the rules, my lords.
108D nalli there is a procedure contemplated, my lords. They themselves, the order says that this procedure has not been followed. 108D of the Karnataka land revenue rules. Be that as it may, my lords, I am entitled for a notice. Once the resolution is passed under 108K, no such cancellation shall be made without giving the grantee an opportunity of being heard. That is, our rule itself says that I am entitled for an opportunity of being heard. I was not aware of this order also. And when I was pursuing for issuance of Sagoli chit based on the resolution at Annexure C, I received this endorsement at Annexure B saying that your resolution has been cancelled by Annexure A. It is only then I come to know about this order at Annexure A. Therefore, my lords, impugning both the orders, I have filed this writ petition. May I respond, my lords?
Mr. Srinivas, you have gone through the order.
Yes, ma'am. Yes, ma'am. Lord, similarly situated persons have been filed the writ petition in the year 2020 and so, my lords. The Sound Court is directed the Assistant Commissioner to provide an opportunity to the petitioners and thereafter proceed to pass order.
Same, same order of the same committee, na?
Yes, same order. Same impugned order is one and the same, my lords.
ಯಾವ್ದು ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ ಕೊಡಿ.
ಅದು ತುಂಬಾ ಲಾಂಗ್ ಬ್ಯಾಕ್ ಆಗಿದೆ. Kindly out, my lords.
No, it's all right. We will have it listed next week.
Please.
You please get that copy.
Please,
so that similar order.
Yes, my lords. Certainly.
Learned AGA takes notice for all the respondents. The contention of the learned counsel for petitioner is that similar orders which were passed by the committee for regularization.
Same order, Lord. Same order, Lord.
Same order dated 27/2007 passed by the Committee for Regularization of Unauthorized Occupation.
The order is 25/8/2012, my lords. A result. 25/8/2012 ನಲ್ಲಿ ಇಂದಿನ ರೆಸಲ್ಯೂಷನಲ್ಸ್ ಮಾಡಿರೋ ಆರ್ಡರ್ ಗಳನ್ನ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ದಾರೆ. ದಿ ಆರ್ಡರ್ ವಿಚ್ ಇಸ್ ಇಂಪ್ಯೂನ್ಡ್ ಇಸ್ 25/8/2012, my lords. Page 71 ನಲ್ಲಿ at the bottom.
ಅದಲ್ಲಪ್ಪ, ಅದಲ್ಲ. Please see in page number 22. The decision of the committee was taken on 27/2007.
Decision. My case, my lords, it is 4/10/2007.
Three dates, my lords. 3 dates: 27/2007, 4/10/2007, 8/10/2007, my lords. 3 dates, my lords.
Page 71 ಅಲ್ಲಿ ಇದೆ.
Page number 71 may kindly be seen.
ಆದೇಶ ಅಂತ
ಏನ್ ಹೇಳಿದಮ್ಮ?
The contention of the counsel for the petitioner is that similar orders which were passed by the committee for regularization
on 27/2007, 4/10/2007, and 8/10/2007 were sought to be cancelled by the Assistant Commissioner, invoking the powers conferred under Rule 108K of the Karnataka Land Revenue Rules, 1966, with a order dated 25/8/2012. Stop. The same was called in question in several other writ petitions, and this court has set aside the said order, the impugned order dated 25/8/2012, and remanded the matter back to the Assistant Commissioner.
Insofar as the petitioners therein, my lords.
ಅದು ಹೆಂಗಪ್ಪ? ಅದು ಯಾವ ತರ ಆರ್ಡರ್ ಮಾಡಕ್ಕಾಗತ್ತಪ್ಪ?
ಯಾರು ಕೋರ್ಟ್ ಬಂದಿದ್ದಾರೆ?
Does it not apply to all the persons?
ಅಲ್ಲ, ಏನಾಗುತ್ತೆ?
Why should it be said it only in respect of the petitioners?
ಅಲ್ಲ, ಯಾಕಂದ್ರೆ ನೋಟಿಸ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಅವರು ಇದ್ ಮಾಡಿದ್ದಾರೆ. ಅದು
ಹೌದು, it is a common order.
Yes, yes.
It is found that no notice is issued to the persons. Will it not apply to all the persons?
Yes, certainly, my lord, certainly.
Why should it be said that only in respect of the petitioners?
ಅಲ್ಲ, ಆ ಕೇಸ್ಗಳಲ್ಲಿ ಅಲ್ವಾ ಹಂಗ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ
ತಪ್ಪಲ್ವಾ? ಅಲ್ಲ, ಅದಾದ್ಮೇಲೆ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ has he not issued notice to all the persons?
ಅದು ಇಂಡಿವಿಜುವಲ್ ಅಡ್ರೆಸ್ ಮಾಡಿರ್ತಾರೆ ಸರ್.
ತಪ್ಪಾಗತ್ತಲ್ಲಪ್ಪ.
ಅದು ಇಂಡಿವಿಜುವಲ್ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಕ ಆಗುತ್ತೆ ಅವಾಗ.
Again the same problem will arise.
ಅವಾಗ ಇಂಡಿವಿಜುವಲ್ ಆಗಿ ಈಚ್ ಅಂಡ್ ಎವರಿ ಪರ್ಸನ್ಸ್ ಕೇಸ್ ನ ಯು ವಿಲ್ ಅಡ್ಜುಡಿಕೇಟ್ ಲಾಸ್. Our merits of that particular person's case will be adjudicated by the Assistant Commissioner.
the impugned order dated 25/8/2012.
Anyways, my lord, my contention is 108K ನಲ್ಲಿ rule itself provides that no, it cannot be cancelled without being heard.
Right. See, if I can pass an order which would inure to the benefit of all the persons, I will do
please,
it.
My lords. Please, my lords. That will benefit one and all, my lords. ಇಲ್ಲಾಂದ್ರೆ ಪ್ರತಿಯೊಬ್ರು ಬರಂಗಿಲ್ಲ, ಪ್ರತಿಯೊಬ್ರುನು ಬರ್ತಾ ಇರಬೇಕಿದು.
Release this matter on 7th of February 2022 to enable the learned counsel for the petitioner and the learned AGA to place on record the order passed by this court, setting aside the impugned order.
Number 3, Jairus DS.
Serial number 3, I appear for the petitioner.
Yes.
Please. Lord, I am in possession of the scheduled land from past more than 25 years. And subsequently, my lords, I have made an application to regularize my unauthorized occupation pertaining to the scheduled land. Lords, now by virtue of Annexure A, page 39, which is challenged in this petition, my lords, my entire agricultural land is brought at stake. Kindly see page 39, Annexure A. This is the impugned endorsement that is challenged. Bengaluru, may I read, my lords? ಬೆಂಗಳೂರು ಗ್ರಾಮಾಂತರ ಜಿಲ್ಲೆಯ ನೆಲಮಂಗಲ ತಾಲೂಕ್ ಸೋಂಪುರ ಹೋಬಳಿ ಎಡೆಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 61ರಲ್ಲಿ 6 ಎಕರೆ 10 ಗುಂಟೆ ಸರ್ಕಾರಿ
This
ಗೋಮಾಳ
is granted to, it is granted to some other person. Yes?
it is granted to official respondent number 3, who is none other than APMC.
APMC.
APMC. There is absolutely no show cause notice. I am in possession. My application seeking grant is pending. I have sought to, my lords, issue a Sagovali chit. Subsequently, I have made several correspondences. All of a sudden, my lords, kindly see annexure R. The manner in which my scheduled property is destroyed. Kindly see annexure R is the photograph. Pursuant to, my lords, the impugned reminder, annexure R1 and R2, R3 and R4 at page 68.
Adhyana, what is that building?
That belongs to some other factory, which is adjacent to my property. That is not pertaining to this schedule land. And subsequently also, my lords, in the very same survey number, which is challenged, that the very same impugned annexure A was challenged by the adjacent landowners who have obtained Akkupatras. Kindly see annexure yes, page 71.
What
My
is
lords,
this annexure? Yes.
Annexure yes.
What?
This is, my lords, all these petitioners challenge the very same impugned endorsement who have already obtained Akkupatras, and by virtue of this annexure A, having brought their property into threat, I was constrained to approach this honorable court. Kindly see page 74. This is the order passed by this honorable court. My lords, surprisingly, now in spite of this order, they have, my lords,
Any of the petitioners in the sites allotted to them
as per annexure
even and to R10
shall not be disturbed. They have
What is this
disturbed.
allotment of sites?
Lords, the allotment agittu pursuant to which Akkupatras were granted in the name of these petitioners, several petitioners. 10 to 15 petitioners.
That stands on a different footing.
That stands on a different note. Now, very same subject land in which the Akkupatras in this petition and the petition at annexure S, my lords, the very same survey land has brought into dispute. They have, my lords, in spite of this order, they have gone and, my lords, they have acted as per their whims and fancies and have destroyed the possession. They have destroyed the walls.
You are saying
yes,
these sites were also carved out of survey number 61.
Absolutely.
Of
For which, my lords,
Edehalli,
ಹೌದು
Sompura, Nelmangla
ತಾಲೂಕ್ ಹೌದು. ಇದರಲ್ಲಿ, my lords,
ನಿಮ್ದು ಸರ್ವೆ ನಂಬರ್ 61
ಹೌದು, ನಂದು ಸರ್ವೆ ನಂಬರ್ 61. Kindly see page number 37. That is the scheduled property belonging to this petitioner. Also, my lords, I have initiated contempt proceedings for the manner in which these respondents have precipitated the matter. Insofar as this petitioner is concerned, also, by virtue of this endorsement, they are precipitating the matter.
Learned AGA takes notice for response number 1, 2, and 4. Issue notice to respond number 3. Learned counsel for the petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA. Next para. Learned counsel for the petitioner submits that the petitioner herein made an application on 16/1/1999, as found at annexure B in form number
53 and 57. 53 ಅಲ್ಲಿ ಫಸ್ಟ್ ಮಾಡಿದ್ರು, ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಫಾರ್ಮ್ ನಂಬರ್ 57 ಅಲ್ಲೂ ಮಾಡಿದ್ದಾರೆ. His wife, because he passed away.
Form number 53, seeking regularization of unauthorized occupation. ಏನ್ ಹೇಳ್ದ?
unconscious of the petitioner submits that the petitioner herein made an
The
application.
petitioner's husband.
Yes.
Petitioner's husband. ಇವಾಗ ಓದಿ.
Petitioner's husband herein made an application on 16/1/1999 as found at Annexure B in form number 53 seeking regularization of unauthorized occupation.
In respect of 3 acres of land in survey number 61 of Yedehalli, Sompura, Hobli, Nelmangla Taluk.
And our husband filed for 1 acre, my lords. Annexure D, page number 45.
1 acre. Subsequently, I have presented
3 acres ಅಂತ ಇದೆಯಲ್ರಿ ಇಲ್ಲಿ.
ಇಲ್ಲ annexure D ಅಲ್ಲಿ our representation ಇದೆ lordship mechanism. Page number 40.
Annexure B. Annexure B I am talking of. Page number 41.
My lords, it is 3 acres only. Our registry
3 acres ಇದೆ. 3 acres ಇದೆಯಪ್ಪ. Thereafter. Form number ಇವ್ರದಲ್ಲಿ
Annexure M, page 59.
Thereafter, the petitioner also filed an application in form number 57. Seeking regularization of the unauthorized occupation, since the petitioner's husband passed away in the due course. Full stop. Nevertheless, without considering the applications for regularization, the respondent, deputy commissioner, second respondent, deputy commissioner, has passed the impugned official memorandum dated 30/7/2019, granting 6 acres and 10 kuntas in survey number 61 in favor of the third respondent, APMC. Full stop. Consequent to the said grant, the respondent authorities have high-handedly bulldozed the crops, the standing crops, even as the petitioner protested. Full stop. Learned counsel would also draw the attention of this court to an interim order dated 25th of November 2021, passed by a coordinate bench of this court in WP number 21054 of 2021. In respect of the very same survey number. Where it was alleged that the petitioners were allotted residential sites carved out of survey number 61 of Yedehalli village, and in spite of the grant made in their favor, a subsequent grant has been made in favor of the third respondent herein, vide the impugned official memorandum. Full stop. This court directed that the possession of the petitioners therein shall not be disturbed. Next para. Consequently, there shall be an interim direction.
Lord, may I make one submission, Lord? Page number 54 my lord, sketch is prepared. 54 ಅದರಲ್ಲಿ ಇವರು 1 ಎಕರೆ ಮಾತ್ರ ಪೊಸೆಷನ್ ಇದ್ದಾರೆ ಅಂತ they themselves have produced document.
But I have sought for 3 acres. They also not disputed. They have acknowledged the receipt.
Their application also says my lords 1 ಎಕರೆ ಅಲ್ಲಿ ಸ್ವಾಧೀನದಲ್ಲಿ ಇದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. The representation is at page number
whatever it is, their application for regularization is not considered.
ಅದೇ ಈ 1 ಎಕರೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಏನೋ ಗೊತ್ತಿಲ್ಲ ಮೇಡಮ್.
ಅಲ್ಲಿ ಏನೇ ಆಗ್ಲಿಪ್ಪ, it is for the committee to have first considered the application.
ಅಲ್ಲ ನಾನು ಏನ್ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅಂತಂದ್ರೆ, ಈಗ 1 ಎಕರೆ ಕೊಟ್ಬಿಟ್ಟು ಆದ್ಮೇಲೆ ಖಾಲಿ ಇದ್ದು ಜಾಗ ಇದ್ಮೇಲೆ ಅಕ್ವೈರ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟು ನಾನು 3 ಎಕರೆ ಅಂತ ಹೇಳಿದ್ರೆ ಅದು ಪ್ರಾಬ್ಲಮ್. ದಟ್ಸ್ ವೈ ಐ ಆಮ್ ಸೇಯಿಂಗ್
ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ 3 ಎಕರೆ ಅನ್ಬಿಟ್ಟು
ಅದು ಇವ್ರು ಅವರೇ ಹಾಕಿರೋ ಸ್ಕೆಚ್ 1 ಎಕರೆ ಸ್ವಾಧೀನದಲ್ಲಿ ಇದ್ದಾರೆ ಅಂತ ಅವ್ರು
ಏನ್ ಹೇಳಿದೆ.
Consequently, there shall be an interim direction.
To the respondents not to disturb the possession of the petitioner in respect of the petition schedule property, comma, until further orders. Full stop. Yes.
Grateful, my lord.
Number 4.
Appeal for the petitioner, madam.
Yes.
The writ of mandamus direct the respondent to consider the annexures H, my lord. Page number 27. Page number 20. Page number 27, my lord. See what happened, my lord.
ಹೆಸರನ್ನು ತೆಗೆದು ಹಾಕಿರುವುದನ್ನು ಪುನಃ ಇಂದಿನ ದಾಖಲಾತಿಯಂತೆ ದಾಖಲು ಮಾಡಲು ಕೋರಿ ಮನವಿ.
What happened was land was granted in the year 1958. My father name is entered into the candidate in the RTC, my lord. Thereafter, computerized RTC. My father name is not known, not entry into the RTC. Therefore, without initiate any proceedings, my father name is not entered into the computerized, my lord. Therefore, made application for change of Poti Tata without entering the
ಆರ್ಡರ್ಸ್ ಪಾಸ್ ಮಾಡಿದ್ದೇವಲ್ಲ ಶ್ರೀನಿವಾಸ್, ಅಥವಾ ಬರೀ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿರೋದು? ಅದರಲ್ಲಿ ಕಂಪ್ಯೂಟರೈಸ್ಡ್ ಖಾತಾ ಅಲ್ಲಿ ಇವ್ರ ಹೆಸರು ಕಂಟಿನ್ಯೂ ಮಾಡಿಲ್ಲ ಅಂದ್ಬಿಟ್ಟು ಇದೇ ತರ ಇನ್ನೊಂದು ಪಿಟಿಷನ್ ಬಂದಿತ್ತು. We have only issued notice ಅದರಲ್ಲಿ.
Yes, only issued notice.
ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ ಮಾಡಿಲ್ಲ ಸರ್, ಮಾಡಿಲ್ಲ. I have to secure instructions, please.
Learned AGA takes notice for all the respondents. Learned counsel petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Next para. The grievance of the petitioner is that his name,
father name.
Yeah, his father's name has not been continued in the revenue records consequent to the computerization. Full stop. It is contended that in the year 1958-59, 10 acres of land in survey number 1 of Kalguni village, Sakleshpura Taluk, was granted in favor of Sri D.S. Shantamallappa, the father of the petitioner, and his name was entered in the revenue records. Stop. However, after computerization, the name of Sri D.S. Shantamallappa has not been continued in the revenue record. Next para. Learned AGA is directed to secure instructions and make a submission.
Date may be given, madam. Date may be given.
Matter on. Release this matter on 10th of February.
Number 5. Siddhalappa.
Please, my lord.
Simalappa.
Please, my lord.
Yes.
This petition, Lord, seeking writ of mandamus, Lord, as that, Lord, the petitioner, husband, executed a registered gift deed, Lord, based on which, Lord, she acquires title. Lord, annexure B is the document, Lord, registered gift deed dated 6/9/2030. Lord, her representation, Lord, repeatedly
Annexure A1 is the RTC.
RTC, Lord, annexures A, Lord, 1 to 3 are, Lord, the RTC where it finds, Lord, the name of petitioner's husband with respect to the property which, Lord, he executed, Lord, registered gift deed as per annexure B, Lord, dated 6/9/2013.
HR Rajendra Swami.
Rajendra Swami, Lord, the husband of the petitioner executes the gift deed.
15 acres.
Lord, totally that comes around 40 acres of land, Lord, in 3 survey numbers.
How did he acquire title over these lands?
Lord, he purchased the land, Lord. There is a mutation, Lord, stands in the name of the husband. Lord, your Lordship may kindly see, Lord, annexure A1. There is a reference with respect to, Lord, mutation accepted during 2002-2003. The mutation order was, Lord, on 24/1/2003.
Lord, initially it is a government land.
Your husband purchased these properties under registered documents.
Please. Lord, there is no dispute with respect to, Lord, holding of, Lord, the husband. Lord, holding physical position and title, Lord, over this property all along. Lord, till his death. Lord,
Sir, how did he acquire title?
By purchase only.
How did he acquire title?
By purchase only. There is no dispute with the to that extent is not regarding holding of the husband.
In your memorandum of writ petition, where have you stated so?
Lord, as because that there was no dispute, Lord, I have not referred to that. As because that, Lord, more than 20 years, Lord, his name not find in the revenue record.
Even in the sale deed, the gift deed, my lord, there is no reference about how he got the title, my lords.
Lord, these questions, my lord, request to him, let the Tahsildar conduct an inquiry and to find out whether there is any defective title or I have got a valid title. He has to take decision, Lord. You can't keep pending, Lord, the application for longer period. The registered gift deed is dated, my lord, 6/9/2013. It is mandatory, my lord, once, my lord, a document registered and check slip is referred to the Tahsildar, is bound to accept mutation. Or he must, Lord, if he finds, Lord, any Lord, lacuna in the title, Lord, he must have an inquiry and to pass an order. Section 129 is very clear.
Yes.
You can't escape it.
Yes.
It's a mandatory, my lord.
All right. Learned AGA takes notice for both the respondents. Next para. The petitioner contends that she has acquired ownership in respect of 2 acres of land, 2 acres 13 guntas of land in survey number 83/2, 15 acres in survey number 86/2 and 24 acres 33 guntas in survey number 88 of Panna Samudra village, Kasaba Hobli, Arsikere Taluk, Hassan district, under a registered gift deed dated 6/9/2013, executed by her husband, Shri HR Rajendra Swami. Full stop. it is contended that the name of Sri H.R. Rajendra Swamy is entered in the revenue records.
In respect of server number 86, my lord, note, it is not coded as bar 2, my lords. Our
OD is whether it is statutory.
As could be seen from the RTCs produced at annexures A1 to A3. Stop. The grievance of the petitioner is that in spite of the checklist having been forwarded from the office of the sub-registrar and applications being made by the petitioner for mutating her name in the revenue records, the second respondent Tahsildar has not passed any order. Stop. Learned, next para. Learned counsel submits that in terms of
Section 129 of Lord Karnataka Land Revenue Act, it is mandatory.
In terms of subsection 1 of section 128, any acquisition made by any person under a registered instrument is required to be entered in the revenue records. Stop. Next para. Learned AGA seeks to contend that it is not clear from the RTCs produced at annexures A1 to A3 as to how the petitioner's husband acquired ownership over the property in question. Stop. Next para. The submission of the learned AGA cannot be accepted. With the material available on record, it is clear that the name of the petitioner's husband is entered in the revenue records in respect of the properties in question. Stop. Consequently, in terms of subsection 1 of section 128, if there is a registered instrument executed by the khatedar, the person in whose favor the rights are passed on under a registered instrument, mutation is required to be carried out in the land revenue records. Next para. At any rate, the second respondent Tahsildar could not have kept quiet without passing any order. Full stop. Next para. Consequently, this writ petition stands disposed of with a direction to the second respondent Tahsildar to pass necessary orders on the checklist forwarded to the Tahsildar consequent to the registered instrument dated 6/9/2013 and the applications made by the petitioner seeking mutation of her name in the revenue record. Full stop. The entire exercise shall be completed as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of a certified copy of this order.
Great respect, please.
Yes. Yes.
Mahesh, yes. So Mahesh, yes.
Mahesh ಅದಾದ್ಮೇಲೆ ನಮ್ಮದು.
ಮಹೇಶ್ ಅವರೇ ಮ್ಯೂಟ್ ಆಗಿದೆ, ಕೇಳಿಸ್ತಾ ಇಲ್ಲ, ಮ್ಯೂಟ್ ಆಗಿದೆ.
I appear
Ah,
for
ಹೇಳಿ.
the Milord, in fact, I am seeking issue a Sagoli stick. Milord, the petitioner hearing seeking for regularization of unauthorized occupation of land. The committee has passed an order for an annexed scheme. Thereafterwards, Milord, they have not issued a Sagoli stick by the Tahsildar. Then I gave several representations to the authority concerned Tahsildar. Not issued a Sagoli stick, Milord, I am seeking this honorable court to issue a directive to Tahsildar to consider my petition as per the committee passed an order to utilize the issue as I will take the land in question. Milord.
When was the decision taken by the committee?
The committee has taken a decision on 27/1/2004 as per annexed D-mail. Annexed D-mail. Annexed D-mail in page 19, Milord. Page 19, Milord. Ramachandrappa Nussamappa. Guntha's plan. Annexed D-mail in page 19, Milord. Trappa bin Nussamappa. 27/1/2004.
Worker. Learned AGA takes notice for both the respondent. Learned counsel for the petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA. Next para. The grievance of the petitioner is that in spite of a decision taken by the Committee for Regularization of Unauthorized Occupation on
27/1/2004. 27/1/2004.
27/1
mentioned only
27/1/2004, comma, as found at annexure D, comma, granting
Guntha's land.
Ramachandrappa. ರಾಮಚಂದ್ರಪ್ಪ ಎಲ್ಲಿದೆ ಹೆಸರು?
Number 3, Milord, you are asking me. Number 3, Milord, you are asking me kindly see number 2, Milord. Ramachandrappa then Nussamappa, Milord.
ಏನಿದೆ?
The grievance of the petitioner that in spite of a decision taken by a committee for regulation of occupation on 27/1/2004 as found at annexure 1.
Annexure D,
granting
13 guntas of land.
Sorry, Milord, that is
of Lingadira Gollalli, Devanalli Taluku, Bangalore Rural District, in favor of the petitioner, comma, the Tahsildar has not issued grant certificate. Stop. Next para. Learned AGA is directed to secure instructions from the second respondent Tahsildar as to why grant certificate are not issued. Release this matter on 10th of February.
Petitioner, please, Madam.
Yes.
Matter is disqualification matter. The respondent number 1 has initiated proceedings under section 29C 8B C D. And the proceedings are transferred by the government to the respondent number 2. Respondent number 2. The respondent number 1 and 2 wants to disqualify the petitioner, who is the president of the respondent 3 society, on the ground that the president of the society did not initiate proceedings under section 69 against one Mahesh Mahesh, who was the ex-secretary who misappropriated the amount and also not filed criminal case against him. President of the society warned the respondent number 1 and 2 pressurizing president of the society. It is the duty of the CEO of the society to initiate and initiated proceedings as per Annexure H, page number 69. 69 case is filed. Charge list is at Annexure J. Straight away, section 29C notice was issued. And under the provisions of section 69 of Karnataka Cooperative Societies Act, the assistant registrar is having suo powers to file case under section 69, to direct his subordinate to file criminal case also, and to take action against the society, including petitioner.
Let us see 29C.
29C, please. (29C) 8B. 29C 8B.
If a member of a board of a cooperative society during the term of his office has acted or has been acting fraudulently or with gross negligence or in contravention of the provisions of this act, the rules or the bylaws of the cooperative society, or without sanction of the board, Mr. What do you say, Mr. AGA? Srinivas.
Yes, Lord.
The action is supposed to be taken by the board.
Yes, Lord.
The president is not the only person.
Yes, Lord.
How can the president be sought to be disqualified? Because it is not the president alone who is to act as the board.
What is the allegation? What is the allegation against the president is to be seen, my lords.
ಅದೇನೆ ಅವರು ಇನ್ನೊಬ್ಬರ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೊಂಡಿಲ್ಲ ಅಂತ.
Ex-secretary
criminal proceedings. That decision has to be taken by the board. It is not left with the president alone.
Lord, I'll check your instructions, my lord. Fail illa.
Yes. Perfect. Learned AGA takes notice for response number 1 and 2. Issue notice to respond number 3. Learned counsel for the petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA. Full stop. Next para. Learned counsel for the petitioner submits that the impugned order dated 3/12/2021 at annexure N is issued by the second respondent, Assistant Registrar of Cooperative Societies, Mysore Subdivision. No, this is only a notice, Alva.
Yes,
only a notice.
Please, my lord. For that, we have failed. For that, we have failed reply. Accepting my reply ought to have been dropped the proceedings, though conducting proceedings. The jurisdiction of the respondent 1 and 2 I am questioning. Jurisdiction I am questioning.
Order alla.
Learned counsel for the petitioner submit that the impugned order dated 3/12
notice.
impugned notice dated 3/12/21 at annexure N is issued by the second respondent ARCS Mysore subdivision.
Calling upon the petitioner, who is the president of the third respondent society, to answer why he should not be disqualified from the primary membership of the society for not having taken action against the then chief executive officer of the society, Shri S.T. Mahesh, who has embezzled a sum of rupees 1,12,63,724, by initiating civil and criminal proceedings against him. Stop. When a counsel for the petitioner submits that it is not the president alone who is to take action. Stop. It is the board that is required to take action, and therefore, at any rate, the impugned notice calling upon the petitioner to answer as to why he should not be disqualified under section 29 capital C of the Karnataka Cooperative Societies Act, 1959, is without authority and jurisdiction. Stop. There is substance in the contention of the learned counsel for the petitioner. Stop. Consequently, there shall be an ad interim order of stay of all further proceedings consequent to the impugned notice dated 3/12/2021 at annexure M N, until further orders.
I appear for the petitioner in this matter, my lord. Matter
Yes.
pertains to 79A and B. My lord, the order is of the year 6/3/2017. The reason is, my lord, the petitioner has got the right under the partition deed. However, my lord, the Tahsildar, considering this as a sale, my lord, has passed the impugned order. My lord, the notice was not served upon the petitioner, and she could not appear. Kindly see, my lord, page number 19, the reason that it is a sale.
Learned AGA takes notice for all the respondents. Same order as in 24309 of 2021. The matters, they are remitted back to the Assistant Commissioner.
Please, my lord. Thank you.
Lord, I beg to appear for the learned counsel for the petitioner in this case, my lord.
Yes.
And my lord, the notice, the initiation of the proceedings by the Tahsildar and section 104 of the Karnataka Land Revenue Act is challenged. The ground is this, my lord, the petitioner has purchased the property in question as per the sale deed, which I have produced at annexure A. This is a house list number 489 from the previous owner in year 1996. A typed copy of annexure A is at page 18.
Summary
page
eviction
12.
of person unauthorizedly occupying land. Not anything contained in the Karnataka public premises eviction. Any person
not public
or wrongfully in possession of any land which is not transferable by virtue of any condition lawfully annexed to the tenure under the provisions of section 91, 98 or 99 may be summarily evicted by the Tahsildar, and any crop including
this is in the village. My lord, Lord, the case of the petitioner is he has purchased this property in question, that is house list number 489, as per the sale deed annexure A in the year 1996 from the previous owner, one Venkateshappa. So the measurement as per the sale deed is 50 by 100. Annexure A may kindly be perused. The typed copy of Annexure A is at page 18.
Yes.
Lord,
what is this date?
1996ನೇ ಇಸ್ವಿ ಮಾಹೆ 18 ತಾರೀಕಿನಲ್ಲಿ ಆದಿನಾರಾಯಣ ಅವರಿಗೆ ವೆಂಕಟೇಶಪ್ಪ ಆದಿನಾರಾಯಣ ಬರೆಸಿಕೊಟ್ಟ ಖಾಲಿ ನಿವೇಶನ ಪರಿಶುದ್ಧ ಕ್ರಯಪತ್ರ. Lord, this is house list number 1996. Yes, Lord. Now Annexure B may kindly be looked into. Page 20. So Venkateshappa, my vendor, his name is found in the assessment list for year 95-96. So measurement is shown as 50 by 100. Lord, after I purchased Annexure C.
Residential site is
ಹೌದು 489. Lord, Annexure C, house list ನನ್ನ ಹೆಸರಿಗೆ ಆಗಿದೆ 489. ಸೊ ವೆಂಕಟೇಶಪ್ಪನ ಹೆಸರು ಬ್ರಾಕೆಟ್ ಮಾಡಿ ನನ್ನ ಹೆಸರು ಬದಿ ಆದಿನಾರಾಯಣಪ್ಪ ಬರೆದಿದ್ದಾರೆ 50 by 100. ಆಮೇಲೆ I have been paying the taxes to the panchayat. All the tax paid receipts I have produced. Lord, what happened was, Lord, your lordship may kindly take Annexure E.
This tax is collected by whom?
Collected by the panchayat, village panchayat.
ಯಾವ village panchayat?
ಮಿಟ್ಟೆಮರಿ, ಗ್ರಾಮ ಪಂಚಾಯತಿ ಮಿಟ್ಟೆಮರಿ, ಬಾಗೇಪಲ್ಲಿ ತಾಲೂಕು.
Why have you not implemented the gram panchayat?
Lord, gram panchayat is not questioning my
for you to contend that this is a property falling within the jurisdiction of the gram panchayat.
Yes.
And you have been paying taxes to the gram panchayat. Should you not implement it as a party?
Lord, because of the arbitrary action on the part of the Tahsildar, I have come before you.
Sir, but your whole contention is that this is not a revenue land. It is a land falling within the jurisdiction of the gram panchayat. Gram Dana limits. Should you not make them party then?
I'll make them party, my lord. I'll make them party. But you, for a moment, kindly take Annexure E, page 40.
What is the impugned order you are questioning or your notice?
Impugned notice nalle avaru order madodu. Notice nalle order. So page 40. Annexure E. Lord, mail ಬಾಗೇಪಲ್ಲಿ ಮಿಟ್ಟೆಮರಿ ಹೋಬಳಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 491 ಸರ್ಕಾರಿ ಜಾಗವನ್ನು ಆಕ್ರಮಿಸಿರುವ ಬಗ್ಗೆ. ಸೊ ಮಿಟ್ಟೆಮರಿ ಹೋಬಳಿ ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರ ವರದಿ ಡೇಟ್
29/1/2022 at 3 p.m.
29/1 I appear before the authority.
ನಿಮಗೆ ಸೇರಿದ್ದು ಅಲ್ಲ ಎಂಬುದರ ಬಗ್ಗೆ ದಾಖಲೆ ಇಲ್ಲದೆ ಇದ್ದಲ್ಲಿ ನೀವೇ ಅನಧಿಕೃತ ಇಲ್ಲದಿದ್ದರೆ ಸರ್ಕಾರದ ವತಿಯಿಂದ ದಿನಾಂಕ 3/2/22 ಒತ್ತುವರಿಯನ್ನು
ತೆರವುಗೊಳಿಸುವ ಬಗ್ಗೆ ಕ್ರಮ ಜರುಗಿಸಲಾಗುವುದು.
ಆಯ್ತು, ಬರ್ಕೊಳ್ಳಿ. Learned AG takes notice of the response. Learned counsel for the petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA. Full stop. Next para. Learned counsel for the petitioner submits that the petitioner purchased the land in question, which is a residential property measuring
house list number 489.
50 into 100 feet, bearing
house list number 489.
House is number 489.
Of Mittamari village.
Situated within the jurisdiction of the Gram Thana. Of Mittamari.
Mittamari village.
Mittamari Gram Panchayat.
Yes, ma'am.
Under a registered sale deed. Dated
18/1/1996.
At annexure A. Full stop. Thereafter, the name of the petitioner is entered in the records of the Gram Panchayat, and the petitioner is in peaceful possession of the same. ನಿಮ್ದು ಹಳೆ ಮನೆ ಐತಾ ಇದ್ರಲ್ಲಿ?
ಮನೆ ಇದೆ, ಕಾಂಪೌಂಡ್ ಇದೆ. ಆಮೇಲೆ ಇನ್ನೊಂದು Rosh may kindly peruse the photographs which are produced. Annexure F.
ಇದೇನು ಇದು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ತಾರೆ?
ಬಿಲ್ಡಿಂಗ್ ಕಟ್ತಾ ಇದೀನಿ. ಹೌದು, ಅದೇ ಸೈಟ್ ನಲ್ಲೇ.
ಅಲ್ಲ, ಇದಕ್ಕಿಂತ ಮುಂಚೆ ಬಿಲ್ಡಿಂಗ್ ಇತ್ತಾ ಅಂತ ಕೇಳಿದ್ ನಾನು.
ಹೌದು, ನಾನ್ ಪರ್ಚೇಸ್ ಮಾಡ್ದಾಗ ಇರ್ಲಿಲ್ಲ. I purchased in the year 96. In 2000, I constructed one portion. In 2010, I constructed another house, another portion. Now I am trying to put up construction. The photographs I have produced, mane irodanna torsidini nodi. Page 43 may kindly be taken. Page 42 and 43. 43 ನಲ್ಲಿ ಮನೆ ಇದೆ, 2010 ನಲ್ಲಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿದೆ. 2000 ಅಲ್ಲಿ ಒಂದು ಸಣ್ಣ ಮನೆ ಕಟ್ಟಿದೆ.
Further submits that after the petitioner purchased the property in question, he has put up a residential building in 2 portions of the property, and recently he has taken up construction work in the remaining portion of the property. Stop. That being the situation, the second respondent Tahsildar has issued the impugned notice dated 27/1/2022, calling upon the petitioner to furnish documents to show that he is the owner of the property. Stop. It is stated in the notice that the land in question is a government land, and therefore action is sought to be taken against the petitioner for encroachment on government land. Full stop. Next para.
Annexure G may kindly be please. We appeared before the Tahsildar. He has directed us to remove the compound wall before 5 o'clock on 2/2/22. Otherwise, action will be taken for demolition of the compound.
Before the Tahsildar and submitted the document to prove his title over the property. Full stop. Nevertheless, the Tahsildar has passed an order dated 31/1/2022 for evicting the petitioner from the land in question and to demolish the structures. Stop. Compound wall. Stop.
Yes,
there shall be an ad interim order directing stay of all further proceedings pursuant to the impugned notice dated 27/1/2022 and order dated 31/1/2022 at annexures E and G respectively, until further orders.
Much obliged.
Tell.
Lord,
For the petitioners in this case, my lord.
Yes.
My lord, the petitioner filed this writ petition seeking writ of mandamus directing the respondents to implement the order passed by this honorable court in writ petition number 42647 of 2012 wide order dated 28/2/2013 wide annexure A, my lord. A is the order passed by this honorable court. Madam, kindly see the page number 32, my lord. Portion of the para number 12, madam. In the circumstances, the impugned order of the deputy commissioner and the resolution of the regularization committee are to be set aside. Consequently, annex J1 2 dated 1st September 2012 are set aside. The case of the petitioner stand remitted to the committee, and parties are directed to appear before the regularization committee without awaiting any notice. 15 September 2013, my lord.
See, your application was initially rejected on the ground that
yes, my lord,
it falls within the distance of 18 kilometers.
Yes, my lord. We have against that order, my lord, we have preferred an appeal before the second respondent. Second respondent also confirmed the order. Subsequently, my lord, we have filed this writ petition before this honorable court. My lord, this honorable court has set aside the order passed by the deputy commissioner and also, my lord, regularization committee. Subsequently, my lord, after disposing the writ petition, my lord, we have submitted a representation to the third respondent to implement the order passed by this honorable court in the writ petition wide annexure A, my lord. On 22/11/2013 also we have submitted a representation. Several representation petitions have made and several representation to implement the order, but my lord, still they have not considered our representation, my lord.
ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ 2013 ಇಂದ?
My lord, 2013 ಇಂದ we have submitted a representation. 2018 they have issued an endorsement. Your lordship, kindly see annexure C is the endorsement issued by the respondent on 6/8/2018. That is only the endorsement issued by the respondent. Still they have not issued any endorsement or not implement the order.
ಏನಂತ ಹೇಳಿದಾರೆ annexure C ಅಲ್ಲಿ?
Annexure C ನಲ್ಲಿ ತತ್ಸಂಬಂಧ ಪೇಜ್ ನಂಬರ್ 39, my lord.
Yes.
ತತ್ಸಂಬಂಧವಾಗಿ ಪರಿಶೀಲಿಸಲಾಗಿ ಸದರಿ ವಿಚಾರವಾಗಿ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ನಿರ್ದೇಶನದಂತೆ ಪರಿಶೀಲಿಸಿ ಹಾಲಿ ಸಕ್ರಮೀಕರಣ ಸಮಿತಿ ಅಸ್ತಿತ್ವದಲ್ಲಿ ಇಲ್ಲದೆ ಇರುವುದರಿಂದ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ಅರ್ಜಿಯನ್ನು ಸಮಿತಿಯ ಮುಂದೆ ಮಂಡಿಸಲು ರಹ ಇರುವುದಿಲ್ಲವೆಂದು, ಸಕ್ರಮೀಕರಣ ಸಮಿತಿ ರಚನೆಯಾದ ಕೂಡಲೇ ಅರ್ಜಿಯ ಬಗ್ಗೆ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ಕ್ರಮ ವಹಿಸಲಾಗುವುದು ಎಂದು ಈ ಕಚೇರಿಯಿಂದ ಉಲ್ಲೇಖ 2 ನಿಮಗೆ ಈಗಾಗಲೇ ಇಂಬರವನ್ನು ನೀಡಲಾಗಿರುತ್ತದೆ ಎಂಬ ಅಂಶವನ್ನು ನಿಮಗೆ ಈ ಮೂಲಕ ತಿಳಿಯಪಡಿಸಲಾಗುತ್ತಿದೆ. Since from 2013 made the issued in same endorsement. Subsequently, my lord, kindly see annexure E, my lord. Annexure E, page number 49, my lord. In the representation, we have requested the respondent. They have considered similar application in the same land survey numbers, but still they have not considered our representation or not implement the order passed by this honorable court, my lord.
ಎಲ್ಲಿದೆ?
My lord, para number 12 ಅಲ್ಲಿ ಹೇಳಿದೀನಿ ಸರ್. Page number 49, para number 12.
ಏನಂತ?
As on today, I am cultivating the said land by granting Ragi.
Already, where is that order passed in respect of other property?
My lord, your last condition annexure F. RTC, my lord, we have produced the RTC showing that, my lord, page number 55. They have granted some other persons to the in similar circumstances, my lord. Entering the name of the NB Suresh being N Basoraju.
Survey number 1.
Survey number 1. We are also cultivating survey number 1.
Muddenahalli.
Muddenahalli, total, my lord, 29 acres, 15 guntas are there, my lord. Total extent we are cultivating. Each petitioner is cultivating 1 acre, 20 guntas, my lord.
Yes, Mr. AGA. Take notice for all the respondents. Hello, response number 1 to 4. ಇವ್ರು ಯಾಕ್ರಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 5?
ಅವ್ರಿಗೆ ಮಾಡಿದಾರೆ ಅಂತ ಅವ್ರನ್ನ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಿದೀನಿ ಸ್ವಾಮಿ. ಅವ್ರದ್ದು ಇಲ್ಲ, ಅವ್ರದ್ದು RTC ನಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದಾರಲ್ಲ, ಅದನ್ನ ಡಿಲೀಟ್ ಮಾಡಿ ಅಂತ representation ಕೊಟ್ಟಿದ್ದೆ, ಅದನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. ಅದಕ್ಕೋಸ್ಕರ ಡೈರೆಕ್ಟಿಂಗ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಟು ಕನ್ಸಿಡರ್ ದಿ representation submitted by the petitioner wide annexure F and F1, E and E1, page number 45 and 48, 50.
issue notice to respond number 5. Learned counsel for the petitioner is directed to serve copies of the writ petition along with annexures on the learned AGA. Full stop. Next para. Learned counsel for the petitioner submits that earlier the petitioners were before this court in WP number 41647-41652 of 2012. And this court, by order dated 28/2/2013, set aside the earlier orders passed by the Committee for Regularization and the Deputy Commissioner, who had rejected the applications filed by the petitioners on the ground that the lands fall within the prohibited distance as provided under subsection 4 of section 94 capital A of the Karnataka Land Revenue Act, and remitted the matter back to the committee, and the parties were directed to appear before the committee on 15th of September 2013. Stop. However, it is submitted that the committee never heard the petitioners, and on the contrary, the respondent Tahsildar issued an endorsement dated 6/8/2018 stating that the committee has not been constituted and therefore no orders could be passed as directed by this court till the committee is constituted. Full stop. The learned counsel further contends that in the very same survey number, that is survey number 1 of Muddenahalli village, Yalanka Hobli, Bangalore North Taluk, additional grants have been made in favor of certain other persons. Stop. To prove this point, the petitioners have produced copies of the RTCs. Next para. Learned AGA is directed to secure instructions from the second respondent Deputy Commissioner as to whether a committee has been constituted for regularization, and if not, why it should not be constituted, to hear the case of the applicants as was directed by this court earlier. Stop. Release this matter on 14th of February.
Number 11.
Lords, I beg to appear for petition notes.
Yes.
Lords, my father purchased several properties in and around Nagaruru village, Dasanpura, Hubli, Narmangala. Subsequently, my lord, I got to know that there were unauthorized occupants in the respective places, and thereafter, my father and others have made a claim before the Assistant Commissioner for the regrant of the land. As per Annexure B, my lord, I was regranted. My father was regranted the land, though I had already purchased it. My lord, subsequently, my lord, DHS Rao and Krishnamurthy and others had also made a claim before the Assistant Commissioner that they were not given an opportunity, and they consequently had been put before the district court for their grievance in that particular point of time. And my lord, district court, my lord, by virtue of an order dated in MS 7 of 1972, Annexure C, my lord, the district judge remanded the matter back to Assistant Commissioner. Thereafter, my lord, the assistant commissioner also was considered the plea of the petitioners and others in respect of the claim. Annex E, my lord, of page number 33, my lord. After the grant, my lord, I filed an application for seeking correction in the RTC, my lord.
Allah, that grant made in your favor was set aside
and remanded.
Amele.
Thereafter, my lord, there was subsequent remand was there.
Remand
And
ಆದ್ಮೇಲೆ ಏನಾಯ್ತು?
The assistant commissioner, my lord, Annex E, page 33. In order portion, page 34, order, consider the appeal made by the appellant for incorporating his name in RTC to extent of 11.
Sir, what about the proceedings under the Inams Abolition Act?
Village Officers Abolition Act.
Village Officers Abolition Act. ಏನಾಯ್ತು ಅದು?
Because
thereafter no order is passed, my lord.
ಮತ್ತೆ what is this annex? What is annexure D?
D is the proceedings of the Tahsildar and was before the Tahsildar.
Because what proceedings is this?
On the basis of the report of Deputy Tahsildar Nad Kechari, my lord, a proceedings was initiated.
Yengappa, see, on your own showing, you are saying that the earlier order of regrant has been set aside by the district judge.
No, it was remanded back.
Remanded back after the earlier order was set aside. In the result, both the appeals are allowed.
Yes, ma'am. Yes,
the order under appeal is set aside.
The case is remanded back to assistant commissioner.
Then where is the decision?
The decision of assistant commissioner in respect to this proceedings is not forthcoming, but I had approached.
Then how can you ask for maintenance if your name in the revenue records?
Subsequent in the proceedings, I had approached again Tahsildar and assistant
sir,
commissioner.
how can you approach the Tahsildar, sir? If there is no regrant in your favor, where is the question of maintaining your name in the revenue records?
But subsequent in order, my lord, annexure F, my lord, Tahsildar makes an order. Considering all aspects, my lord, his detailed order has been passed by the Tahsildar. Page 38, my lord. Then after this order was passed, my lord, I went before the village accountant. I submitted my order of the Tahsildar. Now the village accountant, my lord, says that after all the perusal, I have suppressed the various material factor and he has reported that he cannot consider the order of the Tahsildar.
Unless there is a order of regrant in your favor. Learned ATA takes notice for all the respondents. Learned counsel for the petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Next para. Learned counsel for the petitioner is requested to furnish any information regarding orders passed under the provisions of the Village Officers Abolition Act consequent to the order of remand passed by the additional district judge in MA number 7 and 8 of 1972. Full stop. Please furnish information if you have.
Please.
Lords, I appear for the petitioner, Lords.
Yes.
Lords, petitioners, Lords, claiming to be unauthorized occupant in land bearing survey number 72, Lords, to the extent of 9 acre 20 kuntas. Lords, filed an application on section 50 and 53, Lords. Lords, in response to this, Lords, they have filed, Lords, earlier, Lords, they have filed another writ petition. Lords, coordinate bench of this court, Lords, kindly see at Annexure F, page 25, Lords.
Yes.
Lords, Lords, the government advocate has said, Lords, to the court, Lord, that the committee has not yet constituted. Lord, the moment the committee is constituted, Lord, kindly see page number 28, Lords. Lords, para number 2. It is submitted to the land.
The order was passed in the year 2008.
Yes, Lords. Till today, Lords, Lords, they have not, Lords, considered this order. Lords, I have given several representations to the respondents, Lords. No consideration, Lords. Kindly see that the annexures A to C series. Lords, Lords, it is situated at Lords, survey number 72, Huttenhalli village, Jala Hobli, Bangalore North Taluk, Lords.
Lord, I have to secure instructions from the Tahsildar. Lord, Tahsildar is not made party to this proceedings, Lord.
Not necessary. Deputy Commissioner idaralla.
ಅಲ್ಲ ತಹಸೀಲ್ದಾರಿಂದ ಬರ್ಬೇಕು ಸ್ವಾಮಿ ಇದು ಅದಕ್ಕೆ.
ಅಲ್ಲಪ್ಪ, the same thing as what happened in the previous matter. You have to find out whether the committee is constituted
or not.
ಅದು ಕರೆಕ್ಟ್ ಮೇಲೆ ನಾವು ಲೆಟ್ ದೆಮ್ ಕರೆಕ್ಟ್ ನಾವು ಲೆಟರ್ ಬರ್ದ್ರೆ ಡಿಸಿಗೆ ಹೋಗುತ್ತೆ ಮತ್ತೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಬರಲ್ಲ. ತಹಸೀಲ್ದಾರ್ ಪಾರ್ಟಿ ಮಾಡಿದ್ರೆ
ಡಿಸಿನೇ ಕೊಡ್ಬೇಕಾಗಿರೋದು ಇನ್ಫಾರ್ಮೇಶನ್.
ಅಲ್ಲ ರೆಸ್ಪೆಕ್ಟಿವ್ ತಹಸೀಲ್ದಾರ್
you please get information from the state revenue department.
ಅದ ಈ ಸರ್ವೆ ನಂಬರ್ ಈ ಲ್ಯಾಂಡ್ ಬಗ್ಗೆ ಪರ್ಟಿಕ್ಯುಲರ್ಸ್ ತಗೋಬೇಕಾದ್ರೆ ತಹಸೀಲ್ದಾರ್ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕು ಸ್ವಾಮಿ. ಈ ಸರ್ವೆ ನಂಬರ್ದು ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ರೆಸ್ಪೆಕ್ಟಿವ್ ತಹಸೀಲ್ದಾರ್
ಹಂಗಲ್ಲ ಅಲ್ಲ. The grievance is that the committee is not constituted. So please find out whether committee is constituted. Same ಅಂತ ಕಾಣುತ್ತೆ. ಯಲಹಂಕನೇ ಇರಬೇಕು ಇದು ಆ ಕಡೆ.
ಯಲಹಂಕ
Same, Lords. It is
Bangalore North Taluk.
ಹೌದು, Bangalore North Taluk. Lord, similar order what my Lords has passed in serial number 10, my Lords.
ಹೌದೌದು, same order.
Yes, my Lords. 2411 of 2022.
Learned AGA takes notice for all the respondents. Learned counsel for the petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Next para. The grievance of the petitioner is that in spite of an order dated 22/10/2008 passed by this court in WP number 7712 of 2007, directing the respondent authorities to ensure that the applications filed by the petitioners seeking regularization of unauthorized occupation is placed before the committee, and the committee takes a decision, the committee is not constituted and no orders are passed in respect of the application. Full stop. Next para. Learned AGA is directed to secure instructions as to whether a committee for consideration of unauthorized occupation has been formed in Bangalore North Taluk.
Yelhanka Taluk.
Additional. Bangalore North Taluk additional.
ಈಗ ಯಲಹಂಕ ತಾಲೂಕು ಆಗಿದೆ ಸರ್.
ಯಲಹಂಕ ತಾಲೂಕು ಅಂತನಾ?
ಹೌದೌದು ಸರ್.
ಹಂಗಾದ್ರೆ ಅದು 10 ಅಲ್ಲೂ ಯಲಹಂಕ ತಾಲೂಕೆ ಆಗ್ಬೋದು. 10 ಅಲ್ಲೂ ಯಲಹಂಕ ತಾಲೂಕೆ ಇರ್ಬೇಕು ಅದನ್ನು.
ಹೌದೌದು, ಆ ಕಡೆದೆಲ್ಲ ಯಲಹಂಕ ತಾಲೂಕು. ಮತ್ತೆ ಇದರಲ್ಲಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 and 4
Bangalore North Taluk or Yelahanka Taluk. Release this matter on 14th of February.
The petitioner may be directed to correct the cast title because notice blogalla ಏನೇನೋ ಬರ್ಬಿಟ್ಟಿದ್ದಾರೆ ಇಲ್ಲಿ. Respond number 3 and 4.
ಇನ್ಯಾವ್ರು ನಿಮ್ಗೆ ನೀವೇ ನೋಟಿಸ್ ತಗೊಂಡ್ರೋದು ಇನ್ನ ಅವ್ರಿಗೇನು
ಲೆಟರ್ ಬರೆದ್ರೆ ಈಗ ನಮ್ಮ ಸ್ಟೆನೋ ಸೆಕ್ಷನ್ ಅಲ್ಲಿ ಈ ತರ ಟೈಪ್ ಮಾಡ್ತಾರೆ, ಅವರು ಎಲ್ಲೆಲ್ಲೋ ಹೋಗೋದೇ ಇಲ್ಲ ಅವ್ರಿಗೆ, ಮತ್ತೆ ಅದು ಪ್ರಾಬ್ಲಮ್ಸ್ ಅದು.
ಏನಂತ ಬರಿಬೇಕು?
ಅದು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಬೆಂಗಳೂರು ನಾರ್ತ್ ಸಬ್ ಡಿವಿಷನ್ ಅಂತ ಬರಬೇಕು, ಮತ್ತೆ ತಹಸೀಲ್ದಾರ್ ಬೆಂಗಳೂರು ಇದು ಯಲಹಂಕ ತಾಲೂಕು ಅಂತ ಬರಿಬೇಕು. ಅದು ಆ ರೆಪ್ರೆಸೆಂಟೇಷನ್ಸ್ ಎಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ ಕೊಡ್ತಾರೆ. ಬಟ್ ಇಲ್ಲಿ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಬರೀಬೇಕಾದ್ರೆ ಈ ತರ ಮಾಡ್ತಾರೆ.
ಇಲ್ಲ, ಅವರು ಅಲ್ಲಿ ಪ್ರೀವಿಯಸ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಲ್ಲಿ ಹೆಂಗ್ ಬರ್ದಿದಾರೋ ಅದೇ ತರ ಬರ್ದ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲ, ಪ್ರೀವಿಯಸ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಕೋರ್ಟ್ಸ್ ಇದರಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿ ಬರೀತಾರೆ. ಯಲಹಂಕ ತಹಸೀಲ್ದಾರ್
ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಪ್ರಿವೆನ್ಷನ್ ಆಫ್ ಅನ್ಆಥರೈಸ್ಡ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಅಂಡ್ ಆಥರೈಸೇಷನ್ ಆಫೀಸರ್ ಫಾರ್ ಡಿಸ್ಪೋಸಲ್ ಆಫ್ ಲ್ಯಾಂಡ್ಸ್ ಕಾಂಪ್ಲೆಕ್ಸ್ ಬ್ಯಾಂಗ್ಳೂರ್.
ತಹಸೀಲ್ದಾರ್ ಬೆಂಗಳೂರು ನಾರ್ತ್.
Nekpara, at the oral request of the learned counsel for petitioner, the name and designation of the third and fourth respondents are permitted to be corrected as the assistant commissioner,
Bangalore North Subdivision.
North Subdivision.
Kandaya Bhavan, Bangalore.
Huh?
Kandaya Bhavana, Bangalore.
Kandaya Bhavana, Bangalore. And respondent number 4 shall be the Tahsildar.
Tahsildar Yelahanka Taluk.
Yelahanka Taluk. Ordered accordingly.
Obliged notes.
This case, my lord, I am appearing for the petitioner counsel, my lord.
Yes.
The present petition, we have questioned the correctness of the notice A and B, section 94 and 104 of the Karnataka Land Revenue Act. So, Lakshmi, this notice is contrary to the their own order page at annexure 30, my lord, annexure F. So, I may request, my lord, to kindly for a annexure F. So, Lakshmi, kindly be seen page 30, my lord. May request, my lord, kindly. Yes, Your Lakshmi, kindly. The same similar section, the 94 notice and the section 104 notice was earlier that has been issued, and the authority, after a thorough inquiry, may request, my lord, page 32 is the relevant. By going through heard the arguments and peruse the records, by going through the material documents available on record, it is evident that originally said land was acquired by one Upper Rao, and thereafter the same has been acquired by H.P. Gurappa Reddy under a registered sale deed at 24/3/1960. Further, the survey records, namely Mula Tippani and R.R. Issa Tippani and other revenue records, clearly establish the land in question is Keria and Angala. On the other hand, it is a cultivable land and the same is continuous in possession of the respondent and their predecessor in title. The report from the records, Your Lakshmi, kindly appreciate. Records also come from the ADLR, according to the report as submitted by the record room in the, that has been referred in the 16/3/2000, where it stated the original grant records and also survey number 78 are not available, but ILL are available. Further, as per the mutation entry of RTC of 67, 68, 71 in column number 9, Gurappa Reddy is mentioned in the RTC 1982-85. Rounding the
whether this order was a challenge?
Order, Your Lakshmi, this order was passed on 12/6/2020.
Whether this order was challenged?
Now, in fact, this was in fact, the similar notice was issued earlier. It is dropped. You may request the order portion may be kindly be seen. Page 36.
Sir, what I am asking is whether this order has been questioned.
No, this Your Lakshmi, the order, it is been agitated before the second respondent. He dropped the proceeding. After a changing of the officer, again they issued the notice. Your Lakshmi, may request page 33 the relevant order. In proceedings initiated against the respondent of the provisions of 94 and 104 of the 104 of the Karnataka 11 drive 78(1)(1) to an extent of 2 acres 29 guntas and 33 guntas and survey number 78/2 measuring 4 acres 5 guntas are hereby dropped. When the authority responsible changing of the officer as Tahsildar again issues a notice, this is contrary to the in fact the notice itself is bad in law. This a similar notice has been questioned before this honorable court. The coordinate bench of this honorable court stayed in WP 19745 of 2021 on 9th December 2021. I produce the copy also before my lord. You will kindly the order of the coordinate bench order.
memo along with on 18 January 2022 are produced before the service. Your Lordship, kindly, coordinate bench is already stated the matter, and also Your Lordship kindly connect to this same order may be passed. The order of say is contrary to the earlier their own order at annexure F. Lordship kindly appreciate.
ಯಾವಾಗ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀರಾ?
18th January, my lord, 18th January 2022.
ಯಾವುದು ಬಂದಿಲ್ಲ ಇಲ್ಲಿ.
ಇನ್ನು ಇದೆ 18th January. Memo along with the memo we produced it. Your Lordship kindly.
It is not come on record.
Another there is on 5th January 2000. That because that is not legible. That's why you could produce the later copy also. January 5th we have produced it. Both so last week kindly appreciate and coordinate bench in WPI refer, my lord. In fact,
WP number
19745 of 2021, my lord. Date of the order, my lord, that is on 9th December 2021. 9/12/2021, my lord.
It is in respect of the same land, sir.
Same land. With respect to the
Why
same
you
land.
have to file one more writ petition?
This is the present petition is by a landowner that has been by a developer. This the earlier notice is by a developer, Bagmane developer.
Learned AGA takes notice for all the respondents. Learned counsel for the petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA. Full stop. Next para. Learned senior counsel, Shri DL Jagdish, appearing for the petitioner, submits that the developer of the lands, who is also the power of attorney holder for the petitioner in this matter, had earlier filed WP number 19745 of 2021, and this court by order dated by interim order dated 9/12/2021 has stayed all further proceedings pursuant to the impugned notice dated 18/2/2021. 18/2/2021.
Yes, my lord.
Yes.
Initiated by second respondent.
And connection A. And therefore, praise for similar orders. Ordered accordingly. Next para. List this matter along with WP number 19745 of 2021. VB Shivkumar. Mr. VB Shivkumar.
But I appear, my lord.
Yes.
But our grievance was, my lord, this is a property under a registered sale deed which came to be purchased. But after purchase of the property, Lord, we had got the khata and other mutations done, including the inspection was conducted. Lord, two authorities, Lord, they hold that survey is to be conducted. But surveys were repeatedly conducted. Now an appeal is also pending, Lord. We have not been able to improve the property nor do anything, Lord. I want a direction to the Karnataka Appellate Tribunal to dispose of my appeal, Lord.
Issue a writ in the nature of tertiary. Quash the order dated so and so.
Yes, Lord, I have sought for those orders.
No, but you have already challenged that before the KAT.
KAT, my lord, of course, I have questioned it. At least the KAT also is not hearing us, my lord. At least if that is hard, we can be able to improve the property. My lord, it's all converted also.
But there are private respondents here.
Yes, my lord, they have to be served.
Yes.
I take notice on that.
AGA takes notice for response number 1 to 4. Issue notice to the other respondent. Learned counsel for the petitioner is directed to serve a copy of the writ petition along with the annexures on the learned AGA.
Apart from considering that they have considered do ATA because it is part of the area of our grant. That is
My lords, I appear for the KV8, my lords. May I make one submission, my lords?
Yes.
My lords, the matter would not survive for consideration since, my lords, the auction has been, my lords, cancelled for now. Since, my lords, the petitioner, my lords, has made some payment and requested, my lords, for cancellation of auction. My lords, the respondent number 2 has considered it and, my lords, has postponed, my lords, the action, my lords, and no date has been fixed. Hence, my lords, the petition may not survive, my lords, subject to what, my lords, learned counsel for the petition would say, my lords.
Yes, Mr. Rajan Kumar. Yes.
I appear for petitioner, my lord. If that is so, my lord, if that is so, my lord, this may be dismissed as infructuous. Let the record, let the statement made by the learned counsel for respondent may be recorded, my lord.
Yes. On 27/1/2022, the following order was passed. Extract ಮಾಡ್ಕೊಂಬಿಡಿ. Next para. Learned counsel Shri Anand Murthy, appearing for the second respondent, Cooperative Bank, submits that the second respondent bank has taken note of the interim order passed by this court on 27/1/2022 and has not proceeded with the auction, which was scheduled to be held on
tomorrow
4/2/2022.
ನಾಳೆ ಅಂತ ಹೇಳಿದೆ ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ.
ಏನಂತ ಹೇಳಿದೆ?
Has not proceeded with the action which is
has decided not to proceed. Has decided not to proceed with the auction. And reconsider the contentions of the petitioner, who has stated before this court that after the award was passed by the Assistant Registrar of Cooperative Societies, the petitioner has deposited a sum of rupees 9,50,000 into the account of the second respondent Cooperative Bank. Full stop. Next para. Placing the submission of the learned counsel for the contesting respondent number 2 on record, this writ petition stands disposed of.
My lords, he has not deposited the entire amount, my lords. Some partial payment.
9,50,000. 9,50,000. Specific ಆಗಿ ಹೇಳಿದೀವಿ.
Please, please.
ಏನಲ್ಲಪ್ಪ?
Placing the submission of the contesting respondent number 2 on record, this writ petition is disposed of.
Permitting the petitioner to pursue the matter before the second respondent bank, and at the same time the second respondent bank also is directed to ensure that the deposits made by the petitioner subsequent to the award being passed by the ARCS shall be taken into account before proceeding any further. Stop. Ordered accordingly.
My lords, liberty may be reserved, my lords, if any default, my lords, again, my lords, arises on the account of petitioner.
Default allappa, ಆಗ್ಲೇ ಡೆಪಾಸಿಟ್ ಮಾಡಿದಾರೆ ನಿಮ್ಮ ಅಕೌಂಟ್ ಗೆ. He has produced the statement of object, statement of your accounts.
Please,
no question of default.
Please.
Number 16, Krishnati.
I appear for the petitioner, my lord. Lord, the subject matter of the land is, my lord, the survey number 115/3 measuring 1 acre 20 guntas, my lord.
I am for the KV8 fifth respondent. Could my lords have it on Wednesday, my lord? I'll file my objections. I received the copy on Friday, my lord. So I'll have to file my objections. This day or Thursday, my lord, coming.
At the request of learned counsel Shri Abhinay Paiti, who appears for the caveator respond number 5, release this matter on 9th of February.
Great, my lord.
Published.
I appear for the petitioner's counsel.
Yes, sir.
The Annexure A at page 23 is the impugned order. The Tahsildar, my lords, hands over my land to the BMRCL, keeping it as though it is a government land. My lords, this is despite the BMRCL itself pointing out that it is in my possession and occupation, and I have rights over the property. Let's kindly see the last two lines of the impugned order, the order of the transfer order. ಭೂ ಸ್ವಾಧೀನ ಪತ್ರದಲ್ಲಿ ಶೆಟ್ಟಿಗೇರಿ ಡಿಪೋಗೆ ಭೂ ಸ್ವಾಧೀನವಾಗಿರುವ ಜಮೀನಿನ ಅನುಭವದಾರರು RL ಅಶ್ವಥ್ ನಾರಾಯಣ್, SN ರಾಮಮೂರ್ತಿ, ಗುಟ್ಟಪ್ಪ ಇತರರು ಎಂದು ನಮೂದಿಸಲಾಗಿದೆ. ಆದರೆ ಸರ್ವೆ ನಂಬರ್ 79ರಲ್ಲಿ ಶ್ರೀ ಅಶ್ವಥ್ ನಾರಾಯಣ್ ಮತ್ತು ಇತರರಿಗೆ ಈ ಜಮೀನು ಮಂಜೂರಾದ ಬಗ್ಗೆ ಯಾವ ದಾಖಲಾತಿಗಳು ಇರುವುದಿಲ್ಲ. Kindly see, my lords, next page, the page 25 is the amount paid, my lords, under a public auction by me towards the sale of this property.
You purchased it under a public auction?
Public auction. Lords, Chiti, my lords, was given to me, Sagwali Chiti, in terms of Annexure C, page 28. Page 13, my lords, is the type copy which records the purchase by me, my lords, under public auction. My lords, the matter, in fact, my lords, the revenue records show, as can be seen from page 13.
No, but who approached this Tahsildar?
The authorities, my lords, of the BMRCL. That, my lord, will find at page Annexure K, page 108. ಬೆಂಗಳೂರು ಮೆಟ್ರೋ ರೈಲ್ವೆ ಯೋಜನೆ ಹಂತ ಸೋರಿಸುವುದರಿಂದ ಅಂತಾರಾಷ್ಟ್ರೀಯ ವಿಮಾನ ನಿಲ್ದಾಣದ ಜಮೀನು ಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳಲಾಗುತ್ತದೆ. ಸದರಿ ಜಮೀನುಗಳು ಸರ್ಕಾರಿ ಖರಾಬು ಜಮೀನುಗಳಾಗಿದ್ದು ಆಕಾರ ಬಂದ ಅನ್ವಯ ಕೆಳಗಿನಂತೆ ವಿಸ್ತೀರ್ಣ ಹೊಂದಿದೆ. ಆದರೆ ಪಹಣಿ ಪ್ರಕಾರ ಈ ಜಮೀನುಗಳಲ್ಲಿ ಹಲವಾರು ಜನರಿಗೆ ಭೂ ಮಂಜೂರಾಗಿದ್ದು ಅದರ ವಿಸ್ತೀರ್ಣ ಆಕಾರ ಬಂದು ಕೆಳಗಿನಂತಿದೆ. And they show, my lords, again 79, 20 acres RL Ashwath Narayan, the second person, lord, shown in that document. My lords, this matter in fact was examined by the Deputy Commissioner in terms of Annexure E at page 36, where he records a finding that these lands have been purchased by me in public auction. However, due to certain errors in the revenue records, it is shown as in page, as in survey number 78, as against 79. Page 49.
This order has been passed at Annexure A.
Yes,
without notice to you, is it?
It's an internal communication where he hands over without even notice to us. In fact, my lords, there is an order earlier made by this honorable court not to dispose me, my lords, when Tahsildar attempted to give effect to his assumption that this is a government land. Annexure H-102, my lords, is the interim order of this honorable court.
Yes.
Apparently, my lords, the issue is about the confusion created about survey number.
Allah, there is an order of the Deputy Commissioner on that issue.
Yes, my lord. Despite that, my lord,
if opportunity was given to you, you would have placed that order of the Deputy Commissioner before the Tahsildar.
Lord, may I make one submission, Lord?
Yes.
Lord, order dated 25 to 2013, my lords. of the deputy commissioner, my lords.
Page 49.
Page 69.
Para 23
All the
next
orders passed in between 10/10/2011 to 10/10/2014 have been nullified by the government, my lord, in pursuance of the order passed by this Honorable Court in public interest litigation in writ petition number 51551 of 2013, with order dated 26/8/2014, my lords. In pursuance
nullify ಮಾಡಿದ್ರೆ there would have been a direction to the competent authority to reconsider the matter.
ಅದೇ ಅದಕ್ಕೆ ಏನಾಗಿದೆ ಅಂತ I have to ascertain.
Kindly.
At any rate, how can the Tahsildar pass this order without notice to them?
Lord, thereafter, Lord, the deputy commissioners, the competent jurisdiction have passed the orders.
My learned friend may not.
Is there any reference to such an order passed by the deputy commissioner? And where is the notice to them?
I will take instructions, Lord.
No, kindly see page 70 for a moment. Kindly see page 70 for a moment. This is an order by the deputy commissioner dealing with other portions of this land as late as 24th September 2020. Lord, this order reiterates my right over the property, as can be seen at page 78. My learned friend.
No, at any rate, at any rate, that order could not have been passed without notice to you.
Lord, absolutely, it's very arbitrary. It's something, Lord, the Tahsildar takes upon himself to do.
Yes. Learned AGA takes notice for response number 1 to 4. Learned Counsel Sri N.N. Harish is directed to take notice for response number 5. Learned Counsel for the petitioner is directed to serve copies of the writ petition along with annexures on the Learned AGA and Learned Counsel for response number 5. Full stop. Next para. Learned Senior Counsel Shri Madhusudan R. Nayak, appearing for the petitioners, draws the attention of this court to an order dated 25/2/2013 passed by the Special Deputy Commissioner, Bangalore North and Bangalore North Additional Taluks in case number (1) RRT (2) CR2/2001-2002, wherein the appellant is the government of Karnataka, represented by its Tahsildar, and the respondents in ಯಾವುದು ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ನಿಮ್ದು?
I am concerned with survey number 78 and 79, my lords. Para 20.
ಅಲ್ಲ ಇಲ್ಲಿ ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಲ್ಲಿ there are so many cases. Which one is pertaining to you?
Lords, I am concerned with page 39, my lords, item 2, Ashwath Narayan, since deceased.
Yes. ಏನು ಹೇಳಿದೆ?
In a case number so wherein appellant is the government of Karnataka, represented by its Tahsildar, and respondent number.
And respondent number 2 in case number 9 is Shri R.N. Ashwath Narayana, the husband of the first petitioner and father of the other petitioners. So
this order was reiterated as late as on 24th September.
Learned Senior Counsel submits that the contention of the state government that the lands claimed by the respective respondents therein were government lands, and therefore their names should be deleted from the record of rights, was negatived by the Special Deputy Commissioner on noticing that Shri R.N. Ashwath Narayana had acquired ownership over 20 acres of land in survey number 78 under an auction sale and thereafter his name reflects in the RTC. Full stop. Elaborate orders were passed dismissing the appeal filed by the government of Karnataka.
Till 69, my lord, clause E is the specific direction issued by the DC, page 69. Capital E.
The Tahsildar Bangalore North Additional Taluk was also directed to initiate action for the Podi of survey number 78 and submit proposals to the Deputy Commissioner for change of spot in respect of 15 acres, 33 guntas of land from survey number 78 to survey number 79 in favor of Shri R.N. Ashwath Narayana. In terms of the government circular number RD 93 LGB 79 dated 23/1980 and thereupon initiate proposal for the Podi of the land in survey number 79.
Page 78, it is reiterated. Page 78 by the DC.
Further, at this stage, learned AGA next para submits that the orders passed by the Special Deputy Commissioner have been nullified on the ground that the Special Deputy Commissioners who are in the cadre of Karnataka Administrative Service were not competent to hold the proceedings under section 136(3) of the Act.
And 67(2), my lord.
And 67(2).
As per the government order dated 10/10/2014, my lord.
Stop. Government circular dated?
Government order dated 10/10/2014.
However, Learned Senior Counsel points out to a subsequent order dated 24/9/2020 passed by the Special Deputy Commissioner -1, Bangalore North Subdivision in RRT (2) (NA) bar CR bar 1 bar 2020-21, where the appellant is the government of Karnataka represented by the Tahsildar. Learned Senior Counsel submits that the Special Deputy Commissioner has once again reiterated the orders passed earlier in RRT (2) CR-2 2001-2002. Stop. Next para. At any rate, it is submitted that the respondent Tahsildar could not have passed the impugned order dated 15/10/2020 at Annexure A without notice to the petitioners, handing over the possession of the lands in question to the fifth respondent, BMRCL. Next para. There is substance in the argument of the Learned Senior Counsel. Full stop. Prima facie case has been made out. Full stop. Consequently, there shall be an ad interim order of stay of the operation and enforcement of the impugned communication bar order dated 15/10/2020 at Annexure A, until further orders.
I appeal for the petitioner in this case, Your Honor.
My lord, I appear for the caveat respondent, my lord. They have served me only yesterday late evening, my lord. I saw it only today morning. It is some 2 weeks time, my lord, to file objections, a lengthy writ petition.
Your Honor, the respondent number 4 to 8 has
No doubt you can file objections. But if the petitioner is seeking for interim relief, you will have to make your submissions.
Yes.
Some 2-3 days time, my lord. I will make my submissions after filing my objections.
Respondent number 4 to 8 are trying to allege the scheduled property, Your Honor.
At the request of learned counsel Shri A. Keshav Bhatt, appearing for the caveat respond number 6, release this matter on.
So me petitioners 4 to 8 they are trying to alienate the scheduled property, Your Honor.
8th of February.
Very well.
So the interim order may be passed, Your Honor. Meanwhile,
in the meanwhile, no precipitative action shall be taken by the respondents.
Okay. Till then, my lord. Till then, your lordship may.
In the meanwhile, ant heladnalla.
Yes. Much obliged, Your Honor.
Appearing for caveat respondent, my lord. Yes, for 1 week's time to file objections, my lord.
Yes, Mr. Baswaraj.
My lord, I'm for the petitioner, my lord. Kindly pass over this matter, my lord. Taken up at 2:30, my lord.
Allah, the learned counsel for caveator is asking for a short adjournment.
Kindly pass over this matter, my lord.
We will take it up at 2:30.
One submission, my lord.
Banni 2:30 banni. In the presence of the senior counsel, we will adjourn the matter.
Sorry for interruption, my lord. If your lordship could give me a minute's time.
Yes.
Serial number 5152 disqualification proceedings ನಲ್ಲಿ ತಾವು ಸ್ಟೇ ಕೊಟ್ರಿ. ಅವತ್ತೇ ಅವರು ಬೇರೆ ಕೋಪ್ ಮಾಡ್ಕೊಂಡಿದ್ದೇವೆ ಮಾಡಿದ್ರು. ಅದಕ್ಕೆ ನಾನು ಮತ್ತೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೆ. 3 ಸಲ ಬಂತು, ರೀಚ್ ಆಗ್ಲಿಲ್ಲ. 5152 ಇದೆ. there may be some difficulty because ಬಹಳ matters ಇದಾವೆ ತಮ್ಮೆದುರಿಗೆ. So
mention ಮಾಡಿ at 2:30 you may please mention. At 2:30 you kindly mention, we'll see.
Please.
Jaiprakash Reddy,
Court officer. Serial number 88 memo posting ಯಾವ ಡೇಟ್ ಕೊಟ್ರು ಸರ್? Court officers.
88 sir.
Serial number 88 memo posting ಯಾವ ಡೇಟ್ ಕೊಟ್ರು ಸರ್?
88 dismissal withdrawn sir ಅದು. ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ರ ಸರ್?
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 44 ಏನಾಗಿದೆ? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 44
ರೀಚ್ ಆಗಿಲ್ಲ ಸರ್.
ಎಷ್ಟು ನಡೀತಾ ಇದೆ ಇವಾಗ ಸೀರಿಯಲ್ ನಂಬರ್?
19 ಸೀರಿಯಲ್ ನಂಬರ್ 19
ಏನು ವಾಪಸ್ ಹೋದ್ರು ಇನ್ನು ಆಸೋರ್ ಮ್ಯಾಟರ್ ತಗೊಂಡ್ರ?
ಇಲ್ಲ ಸರ್, ಇವಾಗ ಕಂಟಿನ್ಯೂಷನ್ ಕರೀತಾ ಇರೋದಾಗಿ. 19
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 60 ಸರ್.
ಸರ್ ಯಾವ್ದು ಅರ್ಜೆಂಟ್ ಇಲ್ಲ ಸರ್. ನೋ ಅರ್ಜೆಂಟ್.
ಅದೇ ಸರ್, ಅದು ಒಂದು ಡಿಸಿಷನ್ ಅಲ್ಲಿ ಕವರ್ ಆಗಿದೆ. ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ಅದು ಬಂದಿದೆಯಾ ಸರ್ ಫೈಲಿಗೆ? ಕೋರ್ಟ್ ಸರ್
ಹೇಳಿ ಸರ್.
ಸರ್ ಒಂದು ಸೀರಿಯಲ್ ನಂಬರ್ 60 ಇರೋದು ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಕವರ್ ಆಗಿದೆ.
ನಂಬರ್ ಜಡ್ಜ್ಮೆಂಟ್ ಹೇಳಿ ಸರ್.
ಸರ್ ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀನಿ ಮೆಮೋ ಜೊತೆ, ಅದು ಬಂದಿದ್ಯಾ ಅಂತ ನೋಡಿ.
ಬಂದಿರುತ್ತೆ ಸರ್, ಬಂದಿರುತ್ತೆ.
ಇಲ್ಲಾಂದ್ರೆ ಜಡ್ಜ್ಮೆಂಟ್ ಅದು ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ ಕೊಡಿ ಸರ್.
ಕೊಡಿ ಸರ್, ಅದನ್ನೇ ಕೇಳಿದ್ವಿ ಕೊಡಿ ಅಂತ. ಇದ್ರೆ ಕೊಡಿ.
Okay, okay, 1 second.
What of it,
3
sir?
37163 of 17, sir.
37
163 of 17.
What is that?
Sorry, sir. 1 second. 3610, sir.
Repeat ಮಾಡಿ sir.
36170 of 17.
ಆಯ್ತು.
ಶ್ಯಾಮ್ ಪ್ರಸಾದ್ ಸಾಹೇಬ್ರು ಪಾಸ್ ಮಾಡಿರೋದು ಸರ್. ಅದು ಕವರ್ ಆಗಿದೆ, ಅದಕ್ಕೆ ಮೆನ್ಷನ್ ಮಾಡ್ಬೋದು ಸರ್ 230ಗೆ.
ಮಾಡಿ ಸರ್. ಇಲ್ಲ ಸರ್.
ಇಲ್ಲ ಅಲ್ಲ,
ಟ್ರೈ ಮಾಡಿ. ಟೇಕ್ ಯುವರ್ ಚಾನ್ಸಸ್.
ಆಯ್ತು. ಓಕೆ.
What of it, sir?
ನಡೀತಾ ಇರೋದು ಈಗ
ಈ ಕಡೆ ಬರಲಿ.
ಕೋರ್ಟ್ ಆಫೀಸರ್.
What of it, sir? What of it, sir?
ಹೇಳಿ ಸರ್.
Sir, serial number 42, 40.
ಸೀರಿಯಲ್ ನಂಬರ್
42 ಮತ್ತೆ 47. 42
ಸರ್,
ಮತ್ತೆ
ಯಾವ್ದು
47.
ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಆಗಿಲ್ಲ ಸರ್. ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಸ್ ಕೌನ್ಸಿಲ್ಸ್ ಆರ್ ಪ್ರೆಸೆಂಟ್, ಅವಾಗಲೇ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಸ್. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಈಗ ತಗೊಳ್ತಾರಲ್ಲ 230 ತಗೊಳ್ತಾರಲ್ಲ.
ಕೋರ್ಟಲ್ಲಿ 11ರಲ್ಲಿ ಯಾರು ಇದ್ದೀರಾ? ನಿಮ್ಮನ್ನೆಲ್ಲ ಕೋರ್ಟಲ್ಲಿ 11ರಲ್ಲಿ ಯಾರು ಇದ್ದೀರೋ? ಏನ ಊಟ ಮಾಡಿದ್ಯಾ? ಜಯಕುಮಾರ್, 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 ನಿನ್ನಲ್ಲಪ್ಪ. ಜಯ್,
ಹಾ ಹೇಳು.
ಏನು ಮಾತನಾಡೋದಿಲ್ಲ?
ಎಲ್ಲೋ
ಊಟ ಆಯ್ತಾ?
ಊಟ ಆಯ್ತು.
ಮತ್ತೆ ಏನ್ ಸಮಾಚಾರ?
ಏನಿಲ್ಲಪ್ಪ.
ಮತ್ತೆ ನಿನ್ನಿಂದ ಒಂದ್ ಕೆಲಸ ಆಗ್ಬೇಕಾಗಿತ್ತು.
ಹೇಳು ಏನು?
ಸೀನಿಯರ್ದು ಫೋನ್ ನಂಬರ್ ಏನು ಮನೆದು?
ಕಡೆಗೆ ನಾನು ನಿನಗೆ ಮೆಸೇಜ್ ಮಾಡ್ತೇನೆ.
ಆಯ್ತು, ಅಷ್ಟೊಂದು ಜ್ಞಾಪಕ ಇಲ್ಲ, ನೀನ್ ತಾನೇ ಏನ್ ಮಾಡ್ತೀಯ?
ಹ್ಮ್,
ವಯಸ್ಸಾಯ್ತು, ಜ್ಞಾಪಕ ಶಕ್ತಿ ಹೋಯ್ತು.
ನಾನು ಈ ಮೊಬೈಲ್ ಬಂದ ನಂತರ ನಂಬರ್ಗಳು ನೆನ್ಪಿಟ್ಕೊಳ್ಳೋದು ಅನ್ನೋದೇ ಹೋಗ್ಬಿಡು.
ಸರಿ, ಆಯ್ತು, ಓಕೆ. ಹೋಟೆಲ್ 11ರಲ್ಲಿ ಯಾರು ಇದ್ದೀರೇನ್ರಿ?
ಹೇಳಿ ಸರ್.
ಹಂಗಿದ್ರೆ ಥ್ಯಾಂಕ್ಸ್ ಬಂದ್ರಲ್ಲ ಹೆಂಗಾರಾಗ್ಲಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 62.
ಹಾ ಸರ್.
ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಸೀರಿಯಲ್ ನಂಬರ್ 62.
ಹಾ ಸರ್.
ಏನಾಗಿದೆ? ಏನಿ ಐಡಿಯಾ?
ಏನೂ ಆಗಿಲ್ಲ ಸರ್. ಇದೆ
ಸೀರಿಯಲ್ ನಂಬರ್ 62 ಲಿಸ್ಟ್ ನಂಬರ್ 1.
ಹೌದು ಸರ್, ಇದೆ.
ಇದೆಯಾ?
ಇದೆ.
ಈಗ ಏನು ಈಗ ಪಾಸ್ ಓವರ್ ತಗೊಂತೀರೋ ಅಥವಾ ಲಿಸ್ಟ್
ಯಾವ್ದು ಪಾಸ್ ಓವರ್ ಇಲ್ಲ ಸರ್. ಯಾವ್ದು ಪಾಸ್ ಓವರ್ ಇಲ್ಲ.
ಹೌದಾ
ಸರ್? ಒಂದು ಪಾಸ್ ಓವರ್ ಇದೆ ಸರ್. ಒಂದೇ ಒಂದು ಪಾಸ್ ಓವರ್ ಅನ್ಸುತ್ತೆ. 19 ಇನ್ನ ತಗೊಂಡಿಲ್ಲ ಅನ್ಸುತ್ತೆ.
19 ಅಂತ ತಗೊಳ್ಬೇಕಾಯ್ತು.
18 ನಿಂತು 18 ಇಂದ ಕಂಟಿನ್ಯೂ.
230 ತಗೊಂತೀವಿ.
ಹೌದು ಹೌದು.
ಏನು ಬೆಳಗ್ಗೆ 88 89 ಅಂತ ಕರಿತಾ ಇದ್ರಲ್ಲ, ಮತ್ತೆ ಏನದು?
ಸರ್ ಅದೆಲ್ಲ ಮೆಮೊ ಫಾರ್ ಪೋಸ್ಟಿಂಗ್ ಸರ್.
ಅಷ್ಟೇನಾ? ಸರಿ, ಓಕೆ.
ಸರ್ ಸೀನಿಯರ್ ಸರ್ ಜಯಕುಮಾರ್ ಸರ್.
ಹೇಳಿ ಸರ್.
ಸರ್ 2:15 ಬರ್ತಿದಂಗೆನೆ ಒಂದು ಹೇಳ್ಬಿಟ್ರೆ ಇದ್ ಮಾಡ್ತಾರೆ.
ಅದೇ 51 52.
ಹಾ ಸರ್. ಹಾ ಸರ್. ಮೊನ್ನೆ ಬಟ್ ಎಜಿ ಏನೋ ಬರ್ತಾರೆ ಅಂತ ಅವತ್ತು ಎಜಿ ಬರ್ತಾರೆ ಅಂದಿದ್ರು.
ಅಲ್ಲಲ್ಲ, ನಾನು ಈಗ ಏನ್ ಕೇಳ್ತೇನೆ ಅಂದ್ರೆ, ಈಗಾದ್ರೂ ತಗೊಳಕ್ ಆಗದೆ ಹೋದ್ರೆ ಸೋಮವಾರಕ್ಕೆ ಸ್ವಲ್ಪ ಮೇಲ್ಗಡೆ ಹಾಕೊಳ್ಳಿ ಲಿಸ್ಟ್ ನಲ್ಲಿ ಅಂತ.
ಆಯ್ತು ಸರ್, ಆಯ್ತು.
ಯಾಕಂದ್ರೆ 9ನೇ ತಾರೀಕಲ್ಲಿ ಮೀಟಿಂಗ್ ಇಟ್ಟಿದ್ದಾರೆ.
ಹಾ ಸರ್. ಹಾ ಸರ್.
ಇವತ್ತು ಅಥವಾ ನಾಳೆಗೆ ಸ್ವಲ್ಪ ಮೇಲ್ಗಡೆನಾರು ಲಿಸ್ಟ್ ಹಾಕೊಂಡ್ರೆ.
ಆಯ್ತು ಸರ್. ಆಯ್ತು ಸರ್.
ನನಗೇನೋ ಅದು ಒಂದು ಬುಕ್ಕುನು ಜೆರಾಕ್ಸ್ ಮಾಡಿ ಆ ಬುಕ್ ನಮೂನೆ ಮಾಡಿಕೊಟ್ಟದ್ದು ಐತಿ ಅಂತ ನೆನಪು.
ಅದು ಫಸ್ಟ್ ರಿಸರ್ವೇಶನ್ ಸಬ್ಮಿಟ್ ಮಾಡಿರೋದು. ಆಮೇಲೆ ಬುಕ್ 2 ಕಲರ್ಸ್ ಇದೆ. ಅದೆಲ್ಲ ನಂಬರ್ ತಿದ್ದಿರೋದು
ಅಲ್ಲ, ನನಗೇನು ಅವತ್ ಚಂದ್ರು ಬಂದಾಗ ಎಂತದ ತೋರ್ಸೋದಕ್ಕೆ ಅದಕ್ಕೆ ಇದಕ್ಕೆ ಅಂತ ತಗೊಂಡ್ರಲ್ಲ, ಅವ್ರೇನಾರು ಇದ್ಗಿದ್ರ?
ಇಲ್ಲ ಸರ್, ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್ ನಾನು. ಅವರು 3 ಸೆಟ್ ಮಾಡಿಸಿದ್ದಾರೆ ಜೆರಾಕ್ಸ್. ನಿಮಗೆ ಇದು 1 ಸೆಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್, ಅದು 1 ಸೆಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ. 1 ಸೆಟ್ ನಮ್ಮ ಹತ್ರ ಇದೆ. ಅದಕ್ಕಾಗಿ ಕಲರ್ ಕೊಟ್ಟಿದ್ದೆ ಸರ್. ಈ ಕಲರ್ ಒಂದು ಹೋಗಿದೆ. 3 ಸೆಟ್ ಮಾಡಿಸಿದ್ದೆ.
ಎಲ್ಲಿ ಬಿಡ್ರಿ. ಎಂದಾಯ್ತದು?
ಸೋಮವಾರ. ಈಗ ನಮ್ದು ಎಲೆಕ್ಷನ್ ಇಯರ್ಸ್ ಈಗ ನಾಳೆ ಅದು 109 ಮಂದಿ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಆಗಿರೋದ್ರ ಅವ್ರೇನ್ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಕ್ ಬರಂಗಿಲ್ಲ. ಅದನ್ನೇನ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ ಆಗ್ತದೆ ಸರ್.
ನಾವ್ ಏನೂ ಹೇಳೋದಿಲ್ಲ. ಈಗ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟರ್ ಅಪಾಯಿಂಟ್ ಮಾಡಿತ್ತು, 6 ತಿಂಗಳು ಮುಗ್ದತಿ, ಅದನ್ನೇನು ಕಂಟಿನ್ಯೂ ಮಾಡಿಲ್ಲ, ಮುಗಿಸ್ರಿ ಅಂತ ಹೇಳಿದಾರಂತೆ. ಮುಗಿಸ್ಲಿ, ಯಾರು ಬೇಡ ಅಂದಾರೆ. ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ರೆ ಅಥವಾ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು, ಆ ಆರ್ಡರ್ ಸ್ಟೇ ಆಗಿತ್ತು, ಈಗ ಮುಗ್ದತಿ.
ಮತ್ತೆ ಅಂತ ಬರ್ತಾ ಇದೆ.
ಸರ್ ಟೋಟಲ್ 11 50ನೇ ಮೀಟರ್ ಅರ್ಜೆಂಟ್ ಇದೆ ಸರ್ ಕೊಡಮ್ ಸರ್.
ಹೌದಾ? ನಾನು ಇಲ್ಲೇ ಕುತ್ಕೊಂಡು ಊಟ ಮಾಡ್ದೆ ಇವತ್ತು. ಊಟ ತಂದಿರ್ಲಿಲ್ಲ. ಫೋನ್ ಯಾವ್ದು ಬರ್ಲಿಲ್ವಲ್ಲ. ಹೌದಾ? ಆಮೇಲೆ ಎಲ್ಲ ಕೆಳಗಡೆ ಜುಡಿಷಿಯಲ್ ಹತ್ರ ಹೋಗ್ಬಿಟ್ಟು ಬಂದು ಹೌದಾ? ಯೂಟ್ಯೂಬ್ ಬರ್ಕೊಂತೀರ ಹೇಳಿದ್ರೆ ಯೂಟ್ಯೂಬ್ ಅಲ್ಲಿ ನಿಮ್ಮನ್ನ ಬರ್ಬೇಕು ಕೃಷ್ಣ ಅಂತ ಹೇಳಿ ನೋಡಿದ್ರಾ ಅನ್ಕಲ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಯಾವ್ದಾದ್ರು ಪಾಸ್ ಓವರ್ಸ್ ಇದೆಯಾ? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಕೇಳಿಸ್ತಿದೆ ಹೇಳಿ ಸರ್.
ಯಾವ್ದಾದ್ರು ಪಾಸ್ ಓವರ್ಸ್ ಇದೆಯಾ ಅಥವಾ ಡೈರೆಕ್ಟ್ ಆಗಿ ಸೀರಿಯಲ್ ನಂಬರ್ 20 ಇಂದಲೇ ಶುರುನಾ?
ಕಂಟಿನ್ಯೂಷನ್
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಸೀನಿಯರೇ ಇದಾರೆ, ಒಂದ್ ವಾರದ ಮಟ್ಟಿಗೆ ತೊಂದರೆ ಇಲ್ಲ.
ಅವ್ರು ಹೇಳಿದ್ ಕೇಳಿಸ್ ನಮಗೂ ಕೇಳಿಸ್ ಸೀನಿಯರ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ ಅವ್ರು.
ಯಾರು ಇಲ್ಲ
ಹೇಳಿದ್ದಲ್ಲಿ ಫೋನಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ರು ಜೆಪ್ ರೇಡಿಯೋ ಆಮೇಲೆ ನೀವೇ
My lords, serial number 60, my lords. I'm petitioner in this matter, my lords. This matter is covered by the judgment passed by this honorable court. The impugned order challenged by me is set aside by the coordinate bench of this honorable court, my lords. I produce the judgment also, my lords.
Mr. AGA, Srinivas, serial number 60. 16, huh?
60, my lord, 6060.
It is covered by which? It's covered by which judgment?
My lords, judgment passed by this honorable court, my lords. WP 3617017.
Sir, ಬರ್ಕೊಂತಾ ಇದೀನಿ.
36170 of 17, my lords.
What is this? The entire Darkas register is not placed on record. And in other ways,
My lords, I'll go through the said judgment and make my submissions, please, my lordship.
What is this? Covered and ಏನು?
My lords, challenged the impugned order, my lords. So initially, the land was granted to me, my lords.
No,
And,
what do you mean? What do you mean by covered?
my lords, the impugned order was the impugned order challenged before in this writ petition is set as.
Sir, there were suits filed and accordingly that was decided.
Please, my lords,
How can you say it is covered?
My lords, it's in a similar this, my lords. Impugned order is sort of same. Same
Anyway,
in relation to same survey number, my lords. It's
My lords, I'll take this.
Please take
copy
note of this. WP
Please,
number
my
36170
Please, my
of
lordship.
2017, dated 12th of July 2021.
Please, my lordship.
You make your submissions after going through that.
Please,
My
my
lord,
lordship. Please.
your lordship's kind permission, my lord.
Serial number
Serial number
60.
34.
Serial number 60. Learned counsel for the petitioner submits that the matter stands covered by a decision in WP number so and so, dated so and so. Learned AGA is requested to go through the order and make his submissions on the next date of hearing.
Serial number 34.
On 8th of February.
Serial number 34, my lord. Serial number 34. WP number 2338 of 2022, my lord.
Yeah.
My lord, the society it is registered under Societies Registration Act, my lord, and I have challenged the postponement of the election. It should have been classified as GM KSR, my lord.
Serial number 34 ಅಲ್ಲಿ learned counsel for the petitioner submits that this petition arises out of the provision of the Karnataka Societies Registration Act, and therefore this matter should have been classified as GM KSR. Full stop. Office to take note of the same and list this matter before the roster bench.
And 7th, my lord. And 7th, my lord.
Number 36, my lord.
On 7th of February.
Serial number 36.
Serial number 19, my lord. Serial number 19.
Serial number 36, my lord.
Yeah, but why are you people mentioning like this? Huh? Can't you wait? Orders matters will be called out. Yes, Jaykumar Patil.
Please, serial number 51 and 52 ಇದೆ. ಅದು ಈಗ 2 ಸಲ ಬಂತು, ಆದ್ರೆ ತಾವು ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಎಲ್ಲ ಬಹಳ ಇದ್ದಿದ್ದಕ್ಕಾಗಿ ರೀಚ್ ಆಗ್ತಾ ಇಲ್ಲ. ತಾವು ನಾಳೆಗೆ ಅಥವಾ ಮಂಡೇಗೆ ನಮ್ಗೆ
filed impleading applications in both the petitions, my lord, for the proposed respondents.
He is only saying you list it tomorrow or day after, so that it will be taken up. He is not asking for any orders.
Monday is convenient. With permission of the senior counsel. Monday, my lord. Monday or 10th.
10th ಅಲ್ಲ 9th ಮೀಟಿಂಗ್ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಹಾಗಾಗಿ ಮಂಡೇ ತಗೊಳ್ಳಿ.
Okay, Monday already. Monday.
No. Serial number 51.
51, 52.
51, 52. List these matters on 7th of February 2022 in the orders list.
Much obliged.
My lord, serial number 36, my lord. Serial number 36, my lord.
Yes.
For petitioners, my lord, we have furnished the PF. I kindly seek for adjournment of 2 weeks for hearing, my lord.
Serial number 36. Learned counsel for the petitioner submits that steps have been taken in respect of the proposed response number 7 and 8 on IA number 1 of 2021. List this matter after service of notice on response number 7 and 8. Yes.
Bearing for Keveter, my lord. For 10 days time to file my objections, my lord.
I'm appearing for petitioner, my
It will be taken on 9th or 10th, my lord.
lord, in which I have no objection to grant time. In the meanwhile, first respondent may be asked to take notice for respondent number 1, my lord. Let not government advocate be asked to take notice. However, caveator is there.
ತಗೊಂಡಿದಾರಲ್ಲ ಇಲ್ಲ ಮಾಡಿಲ್ವಾ
ಇಲ್ಲ ಅದು ಅಡ್ವಾನ್ಸ್ ಕಾಪಿ ಮೇಲೆ ಬಂದಿದೆ.
Learned AGA takes notice for respondent number 1. Learned Counsel Shri Jaiprakash Reddy M has entered appearance for response number 3 and 4.
Respondent number 4.
3 and 4.
No, only for 4. Only
I
for
may be permitted to take out hand summon to 2 and 3.
Respondent number 4. Issue notice to response number 2 and 3.
The hand summon.
The petitioner is also permitted to take out hand summons in respect of response number 2 and 3.
One date.
Release this matter on 10th of February.
Very well. I'm grateful.
Lord, in this case,
Your Lordship, serial number 20, appearing on behalf of the proposed respondent 1 and 9 and 10, Your Lordship.
My Lordship, we are appearing on behalf of Srinivas V. Needful has already done, my Lord. Kindly permit us to take a notice on behalf of the advocate.
On behalf of?
Your Lordship, in the interim, we may be impleaded as respondents in this case, Your Lordship. We have filed a pleading application where the LRs of the deceased in respondent 2 in annexure E of the writ petition, that writ petition which it was squashed, Your Lordship.
Lord, may I submit this, my lord?
Application ಇಟ್ಟಿದ್ದಾರೆ writ petition ಎಲ್ಲಿದೆ?
Lord, this writ petition has been disposed of long back. My lord, this application has been filed after considerable period of time.
My lord, I appear
directed.
I'm sorry, I appear for respondent in this case, my lord, serial number 20. My lord, I filed this application under section 152 of CPC on the ground that in the writ have been allowed in its entirety, my lord. It should not have been allowed in its entirety. It should have been restricted to only to the petitioners, because the order of the land tribunal was to the entire extent. Therefore, I filed a 152 application. Notice was ordered to the petitioner. Now the petitioner, I'll take today morning. I have taken steps, my lord. I have done the needful today, and I may also be permitted to serve the petitioner, the petitioner's counsel, who is representing them before the land tribunal, which is pending even before the Mysore land tribunal, my lord. I may be permitted to serve upon the counsel, my lord.
What is this? You are filing an application in respect of an order passed on 30th of January 2008.
Yes, my lord.
Yes, my lord. Yes, my lord. I'll convince. It's 152 application, my lord.
152 application.
My lord, I'm seeking 152, my lord, to review to clarify the order that 28/2003, which is at annexure 3, be set aside only to the extent of land belonging to the petitioners therein. Ashtayanandu contention.
Your Lordship, this application has been filed after 15 years of gap, Your Lordship.
Yes, my lord. My lord,
And
in
we
fact,
would
what
like
had
to be
happened is,
included
if your
in this
lordship
case,
can
Your Lordship,
kindly
because
come to. What's it, my lord? My lord, if your lordship can kindly come to the annex document number 2, the matter was remanded to the land tribunal wide order in the year 1979, my lord. And thereafter, my lord,
My land friend is arguing on merits. Lord, first of all, he has to serve notices.
Which is that impugned order that annexure E?
My lord,
Have you produced it along with your application? Which is that impugned order that was quashed and set aside? Because I have no the original papers are not here.
ವಿಶ್ವನಾಥ್ ಸರ್ ಮ್ಯೂಟ್ ಆಗಿದೆ ಸರ್.
I'm sorry, my lord. ಅದು ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ನಂಗೆ. I'm sorry, my lord. Document number 2, page number 11.
No, that is dated 28 2003.
2003. That was impugned before the learned single judge, my lord, and that was called in question in WP number 8196 of 2008, my lord. My lord, this order was challenged by the sons of one Trayambaka Swami, that is respondent number 1. Respondent number 2 never challenged the order of the learned tribunal, my lord. While this honorable court, while set asiding the order of the tribunal, have set aside the order to the entire extent.
One minute.
Yes, my lord.
Please read the operative portion, Adesha.
My lord, in document number 2, my lord.
Yes.
ಈ ಮೇಲೆ ವಿವರಿಸಿದ ಹಿನ್ನೆಲೆಯಂತೆ ಗೌರವಾನ್ವಿತ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ರೀತಿಯ ಭೈರಪ್ಪ ಮತ್ತು ಶಿವಣ್ಣ ಅವರನ್ನು ದಿನಾಂಕ 13/11/98 ಭೂ ನ್ಯಾಯ ಮಂಡಳಿಗೆ ಸಲ್ಲಿಸಿದ ಅರ್ಜಿಯನ್ನು ಗಣನೆಗೆ ತೆಗೆದುಕೊಂಡು ಪರಿಶೀಲಿಸಿ ಅವರನ್ನು ಪ್ರಕರಣದಲ್ಲಿ ಪಕ್ಷಕಾರರನ್ನಾಗಿ ಸೇರಿಸಲಾಯಿತು. ಕಾನೂನು ರೀತಿಯ ಅರ್ಜಿದಾರರನ್ನು ಹಾಗೂ ಸಹ ಅರ್ಜಿದಾರರ ಪ್ರಕರಣದಲ್ಲಿ ಅವರಿಗೆ ಇರತಕ್ಕಂತ ಹಕ್ಕುಗಳನ್ನು ಸಮರ್ಥಿಸಲು ಅವಕಾಶ ನೀಡಿ ಕಡತದಲ್ಲಿಟ್ಟ ದಾಖಲೆಗಳನ್ನು ಮತ್ತು ಉಭಯಸ್ಥರ ವಾದ ವಿವಾದಗಳನ್ನು ಆಲಿಸಿದ ನಂತರ ಅರ್ಜಿದಾರರು ಹಾಗೂ ಸಹ ಅರ್ಜಿದಾರರು ದಿನಾಂಕ 3/1/74 ಅಥವಾ ನಿಕಟ ಪೂರ್ವದಲ್ಲಿ ಒಟ್ಟು ಕುಟುಂಬದ ಸದಸ್ಯರಾಗಿಲ್ಲವೆಂದು ಒಮ್ಮತದ ತೀರ್ಮಾನ ಬಂದು ಅವಿಭಕ್ತ ಕುಟುಂಬವು ಪತನವಾಗಿ 1957ರಲ್ಲಿ ಕುಟುಂಬದ ಆಸ್ತಿಯನ್ನು ಪಾಲು ಮಾಡಿಕೊಂಡು ಪ್ರಕರಣ ಪ್ರಕರಣದ ಸಾಕ್ಷ್ಯದ ಕೂಡ ಅರ್ಜಿದಾರ ಯಾವುದೇ ವಿವಾದ ಹಕ್ಕನ್ನು ಸ್ಥಾಪಿಸುವಲ್ಲಿ ಸಹ ಅರ್ಜಿದಾರರು ವಿಫಲರಾಗಿರುತ್ತಾರೆ. ಅಲ್ಲದೆ ಸಹ ಅರ್ಜಿದಾರರು ಭೂ ನ್ಯಾಯ ಮಂಡಳಿಯ ಮಿಲಾಡ್ some disturbance, Milord. Am I audible, Milord?
Yes. ಸಹ ಅರ್ಜಿದಾರರು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ ಅಥವಾ ಯಾವುದೇ ವಿಧವಾದ ಹಕ್ಕನ್ನು ಸ್ಥಾಪಿಸುವಲ್ಲಿ ಸಹ ಅರ್ಜಿದಾರರು ವಿಫಲರಾಗಿರುತ್ತಾರೆ.
ದಿನಾಂಕ 11/3/74 ಸರ್ಕಾರದ ವಿನಿಯೋಗಗೊಳಿಸಿ ಭೂ ಸ್ವಾಧೀನ ಕಾಯ್ದೆ ಅರ್ಜಿದಾರರ ಪ್ರಕರಣದ ಜಮೀನು ಹಕ್ಕಿನ ವಿಚಾರದಲ್ಲಿ ತಕರಾರು ಇದ್ದಲ್ಲಿ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರದ ಮುಂದೆ ದಾವಾ ಸಲ್ಲಿಸುವ ಇತ್ಯರ್ಥಪಡಿಸಬಹುದಾಗಿರುತ್ತೆ. ಆದ್ದರಿಂದ ಕೆಳಗಿನಂತೆ ಆದೇಶ ಹಕ್ಕು ನೋಂದಾಯಿಸಿದೆ ಅಂದ್ಬಿಟ್ಟು ನಮ್ಮಿಬ್ಬರ ಹೆಸರಿಗೆ ರಿಜಿಸ್ಟರ್ ಆಯ್ತು. Now, my lord, this order was called in question by the first respondent.
One nimsha, sir.
Yes, my lord.
The applicants, Shivlingegowda, Ningegowda, Bhairappa, Shivanna.
Yes, my lord.
They filed application in form number 7.
Yes, my lord.
Trayambaka Swami and MC Nagaraju are the owners of the property.
Yes, my lord.
Indeed.
My lord, may log in from the other system. My lord, may log in from the other system. My lord, may log in from the other system.
Their application could have been rejected.
My lord, 1 second, my lord. 1 second, kindly pass over, my lord. I'll log in from the other system. I am unable to hear properly, my lord. I'll log in from the other system. 1 second,
Yes.
kindly pass over, my lord.
Yes. ಮಾಡಿ
Lord, in the meantime, may I submit this, my lord?
Yes.
My lord, when the matter came up before your lordship, my lord, your lordship specifically directed that notice on this IA should be taken on the petitioners because this is a matter where the application has been filed after considerable length of period. My lord, notices has been ordered, my lord. Now, the office has posted this case for issuance of fresh process, my lord. Because I have no instructions in this case and I have no papers in this case and nothing, I know nothing about this case, my lord. Because it's a long time, the matter has been disposed of and the papers have been taken away by the parties. My lord. May I request your lordship to look into the order sheet, my lord?
Yes, yes. It was made, it is made clear if process is not paid within 1 week, IA number 1 of 2001 shall stand rejected without further orders.
Yes, my lord.
My lord, I'm sorry, my lord.
Mr. Srinivas,
Yes, my lord.
on 29/11/2021,
Yes, my lord.
this was what was ordered. Learned Council for respondents number 2 to 7
Yes, my lord.
submit that they would take out process on petitioners number 1A and 1B and respond number 8 on IA number 1 of 2021 within 1 week.
Yes, my lord.
It is made clear if process is not paid within 1 week, IA number 1 of 2021 shall stand rejected without further orders.
Yes, my lord, I was paid. This is third time, my lord. On that day it was paid, my lord. This is for the third time it has come. This is for the third time, my lord.
Insufficient address anta vapas bantu.
Yes, my lord. My lord, they are not accepting, my lord. They are residing in the same address. Therefore, I sought for liberty of this honorable court to serve upon the council who is representing the petitioners in the land tribunal. I will serve again, my lord, but they will not accept. Therefore, I may be permitted to serve along with that, my lord, to the advocate representing the petitioners in the land tribunal, my lord.
ಯಾರು ನೀವು ಹೋಗ್ತಾರೆ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಅವ್ರು ಯಾರಿಗೋ ಕೊಟ್ರೆ SM Babu ಅವ್ರಿಗೇನೆ ಈ ಸೇಯಿಂಗ್ I have no contact with the petitioners.
Well, in fact,
you are talking about advocates who appeared before the land tribunal.
Well, even today, before the land tribunal case is pending.
No, you take out substituted service if you want. Yes. This is not this will not be permitted.
Your lordship may be allowed to make a submission, your lordship.
Yes.
Your lordship, I may be permitted to make a submission. I filed an IA for impleading respondent number 9 and 10 in this case, your lordship. The order that was quashed in Annexure E, I am the second respondent in that case, your lordship. I am the LS of MC Nagraj or Tirkondro, so I am the wife and the son of the MC Nagraj, your lordship. I
will oppose, my lord. I will file
as a respondent in this case, your lordship.
That copy have not served upon me. I will file the objection, my lord. My contention is that they were not party before the writ court, and therefore the order is not.
Serve the copy.
Respondent number?
Your lordship, the schedule 9 and 10, proposed respondent 9 and 10, your lordship.
But who are they, madam?
Your lordship, if you could see the annexure E of the writ petition, petition annexure E, I am the second respondent, your lordship, and the scheduled property 159 belongs to me, your lordship.
Second respondent.
Sometime back when senior was arguing,
MC Nagraj.
MC Nagaraj. MC Nagaraj is no more, Your Lordship. We are the LRs of MC Nagaraj, Your Lordship. So I filed an impleading application to be added as a party as R9 and 10, Your Lordship. I'll serve the copy of the impleading application to the petitioner, Your Lordship.
Petitioner andre yaramma ivaga? Petitioner is the clients of Mr. SM Babu.
Yes, Your Lordship. Apologies, Your Lordship. I'll serve the copy of the respondent, Your Lordship. Respondent 127.
What complications you are bringing into these matters? I can't understand.
Your Lordship, I predominantly have only 2 submissions with this regard, Your Lordship. I may be impleaded as a party provided if the matter, if 152 application.
Please wait. Learned counsel for the
respondent number 3.
Mr. Srinivas, you were a party to the proceedings, sir.
Yes.
Yes, my lord. I was a party to the proceedings.
Matte yenayitu? What happened then?
My lord, while the order of the tribunal, my lord, while the setting aside the order of the tribunal, the contention is only this, my lord, small contention, my lord. Your lordship can kindly come to document number 3 at page number 18, my lord.
Yes, that is the order dated 30th of January 2008.
My lord, this order was challenged. My lord, this order was passed at the behest of Trayambaka Swami, petitioner, my lord. Trayambaka Swami, represented by his LRs, MP Mallikarjuna, MP Prabhu. Now, my lord, the order of the land tribunal was pertaining to 2 respondents, my lord. One was Trayambaka Swami and one was MC Nagaraju. MC Nagaraju never challenged the order of the learned tribunal. So therefore, it has attained finality as against MC Nagaraju. Now, my lord, this honorable court, while setting aside the order of the land tribunal, had set aside the entire order, my lord, without restricting it to the Trayambaka Swami. So therefore, I am before this honorable court seeking a clarification that this order should be restricted only to the extent of Trayambaka Swami. This is my little case, my lord.
Allah, but I was wondering.
Yes, my lord.
This order dated 28/2003.
Yes, my lord.
Was in favor of Shivlinga Gowda and.
Yes, my lord. Yes, my lord. It was in our favor. It was in our favor. Now, my lord, that was called in question by the landlords. Trayambaka Swami was a landlord. He was.
But one nimisha. The order portion that you just now read out.
Yes, my lord.
The land tribunal is of the opinion that the application should not be allowed.
My lord.
Yes, my lord. It is in the nature of saying that the application cannot be allowed.
No, my lord. It was in favor of the petitioners, my lord. It is in favor of the my clients, my lord.
Allah, sir.
Yes,
you have read out ಅರ್ಜಿದಾರರು ಯಾವುದೇ ಸಂಬಂಧವಿರುವುದಿಲ್ಲ ಹಾಗೂ ಈ ಬಗ್ಗೆ ಯಾವುದೇ ಸಾಕ್ಷ್ಯಾಧಾರಗಳನ್ನು ಕೂಡ ಸಹ ಅರ್ಜಿದಾರರು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ ಅಥವಾ ಯಾವುದೇ ವಿಧವಾದ ಹಕ್ಕನ್ನು ಸ್ಥಾಪಿಸುವಲ್ಲಿ ಸಹ ಅರ್ಜಿದಾರರು ವಿಫಲರಾಗಿರುತ್ತಾರೆ. ಇಷ್ಟೆಲ್ಲ ಹೇಳಿದ ಮೇಲೆ ವೇರ್ ಇಸ್ ದಿ ಕ್ವೆಶ್ಚನ್ ಆಫ್ ಅಲೋವಿಂಗ್ ದೇರ್ ಅಪ್ಲಿಕೇಶನ್?
ತಕರಾರು ಇದ್ದಲ್ಲಿ ಸಕ್ಷಮ ಆದ್ದರಿಂದ ಹಕ್ಕು ನೋಂದಾಯಿಸಿದೆ ಅಂತ ಇಲ್ಲಿ ಒಂದು ಲೈನ್ ಇದೆ. ಆದಾಯ
ಹೆಂಗೆ ಸರ್?
ಇಲ್ಲಿ ಲಾಸ್ಟ್ ಲೈನ್ ಅಲ್ಲಿ ಕೈಯಲ್ಲಿ ಬರ್ದಿರೋ ಪೋರ್ಷನ್ ಅಲ್ಲಿ ಹಕ್ಕು ನೋಂದಾಯಿಸಿದೆ ಅಂತ ಬರೀತಾರೆ. ಇಲ್ಲಿ
there is something wrong then. There is something wrong. See, if you read the reasoning, it is very clear that the tribunal is of the opinion that you have not produced any material to allow your application. And therefore your application was required to be rejected.
One second, my lord. There were totally 4 applicants, my lord. Shivlinga Gowda, there were totally 4 applicants before the land tribunal. Shivlinga Gowda, Linge Gowda, K. Bhairappa, K. Shivanna. Now, my lord, this application was registered insofar as Shivlinge Gowda and Ninge Gowda only. The applications of Shivlinge Gowda and Ninge Gowda was considered. Rest of the application, that is the Baire Gowda Shivanna, was rejected. Badinal fullu ಹೇಳ್ಕೊಂಡು ಹೋಗ್ತಾರೆ. That was called in question before this honorable court in this writ petition, my lord.
Yes, anyway, you please,
My lord, I would like to further add, my lord, one second, my lord, I would like to further add, my lord. After remand, the matter is pending consideration even today before the Mysore Land Tribunal, my lord. Even today it is pending. And even today my clients are attending the matter, my lord. Therefore, I made a request that I may be permitted to serve the counsel who is representing the petitioners therein. That's why I made a request. I'll take paper publication. Along with that also I may be permitted, my lord. I'll make substituted service application and also I may be permitted to serve, my lord. Anyhow, today morning I have paid process, my lord.
Learned counsel for response number 2 to 7 submits that consequent to the directions issued by this court on 29/11/2021, steps have been taken to issue notice to petitioners number 1A and B and respondent number 8. So, however, the notices have returned to Shara insufficient address. Stop. The learned counsel has taken fresh steps in respect of petitioners number 1A and B and respondent number 8. Stop.
Today morning I have for 1A and B. 1A and B ಕೊಟ್ಟಿದ್ದೀನಿ 8 ಮಾರ್ಕ್ ಕೊಟ್ಟಿದ್ದೀನಿ 8 ಗೆ ಕೊಡ್ತೀನಿ ನಾಳೆ ಕೊಡ್ತೀನಿ
1A and B. Full stop. The learned counsel would further submit that steps will also be taken in respect of respondent number 8 by tomorrow. Full stop. At the request of the learned counsel for response number 2 to 7, a copy of IA number 1 of 2021 is permitted to be served on the learned counsels who are appearing for petitioners number 1A and B before the Land Tribunal, Mysore, before whom the matter is pending consideration after remand at the hands of this court. Full stop. Next para. Respondents number 2 to 7 are permitted to file their objections in respect of IA number 2 of 2021. So, yes.
Lord, I appear for the respondent number 15.
Appear for the petitioners.
Lord, this matter was heard at some length during the last date of hearing. Lord, and this honorable court was pleased to pass an order for directing the commissioner of the director of land records to measure the land and all, Lord, and to submit the report. Lord, the commissioner has submitted the report, my lord, that has not been placed before this honorable court.
My lords, I have filed a memo along with the survey sketch before the court, please, my lordship.
Avrige copy kottilva?
I appear for the petition, my lord. I have not received the copies of the survey sketch, my lord. Directed to serve, my lord, then we'll make submission on that.
A date may be fixed any time around the 10th or 12th, my lord. The physical hearing will start according to the new SOP.
Alla idu
my lord.
ಏನಿದು
survey sketch
ಇದೆ ರಿಪೋರ್ಟಾ
they have sent it through post also.
Letter Where is the report?
My lordship, a survey sketch is filed along with the survey sketch. Morning I have given the morning I gave it to the court officer, please, my lordship. Memo along with the survey sketch.
ಒಂದು ಕಾಪಿ ಕೊಡಬೇಕು ಇಬ್ರಿಗೂ, both sides.
Please, my lordship. I'll serve it, please, my lordship.
Learned AGA has filed a memo dated 1/2/2022 along with the copy of the survey sketch prepared as per the directions issued by this court, along with a report of the spot measure. So, Learned AGA is directed to serve copies of the same on the learned counsel for the petitioner as well as the contesting respondent.
Please, my lordship. I'll do it, please.
Release this matter on 10th of February.
Please.
Lord, 10th, Lord, 10th is, I have some inconvenience, Lord, anytime on 14th or any date after the.
14th.
Grateful. Great.
But I informed the petitioner. But I have taken steps on the next day of order. It is not yet appointment is not yet received. Insofar as respondent number 4 is concerned. Insofar as AGA is concerned, on the very same day, that is on 25/1, I was served 3 sets of copies, and acknowledgement was obtained on the presentation form. It was produced before the filing counter.
Learned copies ಬಂದಿದೆಯನ್ರಿ? Mr. Srinivas? Learned AGA submits that he has received copies of the writ petition along with annexures. Stop. List this matter after service of notice on respondent number 4.
May I make one submission? Considering the urgency or the date, a date may be given. Some urgency is there. It is change of Karta. Some urgency is there. Fix a date. Kindly see, my position is under threat.
No, sir.
Considering that only, you will fix a short date. That's why.
My lord, in this case, I am for petition. Appear for petitioners in this case, my lord.
Yes.
My lord, in this case, the office objection is with regard to the furnishing of the typed copies, my lord. Annexures C and D. D and E are the sale deeds.
ಎಂಟು objections ಇದೆ.
The main the translated is the typed copies, my lord. Seeking for a 2 weeks time to furnish that typed copy, and meantime I will comply that all the office objections.
ಆಯ್ತು ಮಾಡಿ at the request of learned counsel for petitioner 2 weeks are granted to comply with the office objections.
For petitioner, kindly place for week's time to comply.
A week's time is granted at the request of learned counsel for petitioner for compliance of office objection.
My lord, office objection is 2 objections they raised. One is interest of the petitioner. My lord, the Gram Panchayat road and road which is in use since several decades, I can say, that is in front of my house. Road which I am also using, others are also using. Now, some persons have caused an obstruction and they have put a barbed wire. I made a representation to this Jilla Panchayat, Deputy Commissioner, Assistant Commissioner, and police officers, everyone. Nobody is taking action. My lord, annexure B series, where the documents which pertain to this road, even the Honorable Lokayukta also issued a notice to give a report. There also they are not, this Gram Panchayat PDO has not replied it and has not taken any action. Well, the manner in which they have created this to say obstruction, my lord can find it at annexure E photograph where I have placed it. It is in front of my house. In front of my house.
Yes.
And
Annexure B series, annexure B series details to be stated in writ petition correctly.
B1, B2 that I have to state, I will state it, I will rectify it. So I will rectify it right now or tomorrow. I will rectify once when I am allowed to rectify it, my lord. My lord has seen this annexure E where photographs are produced.
At the request of learned counsel for petitioner, release this matter on 8th of February.
Monday,
8th of February. Tuesday.
I cannot come out from my house because it's a local.
So in the meanwhile, office objection at serial number 2 shall be complied with.
Serial number 1 is to be overruled, my lord.
Office objection at serial number 1 is overruled.
Obliged, my lord.
The petitioner in this, lords.
Yes.
The office object to produce typed copy, lords, for which lords have filed application seeking dispense. Lords, the case lords of the petitioners. Lords, the questioning the order lords of the deputy commissioner lords produced at annexure A, lords. Lords, the typed copy of the and survey sketch. Lords, the include lords order is that lords annexure A, lords.
Allah.
Lord,
type copy of annexure D, G.
Annexure D, lords, is a receipt having paid the amount, lords, and annexure G, lords, is a survey sketch. Dispensation lords, the relevant portion lords have furnished the typed copy. Relevant portion furnished. The horizontal.
Sorry,
Lords is the order lords. Wherein commissioner ordered to lords. Was reflected in my order to enter the name of the God.
Mr. Jasmith Zaveria, Mrs. Xavier. Jasmith Xavier.
Yes, my lord.
Please mute your mic, sir.
Yes.
Yes, really.
The land bearing survey 25. Measuring 20 acres lots was granted lots in favor of 1,000 lots as per annexure B. Subsequent to that lots, another extent lots of 9 acres 11 guntas was for in the name of lots annexure B C lots.
Annexure B 20.
20 granted lots in the name of Dasappa. Subsequent further 9 acres 27 kunta also granted.
Confirmation of excess area of 9 acres 27 kuntas.
Along with 20. For which lots the grant certificate was also issued lots as per annexure E. Subsequently, lots The 20 acres lots was renumbered as 33 and the 9 acres was lots continued in the survey number 25 only. Lots subsequently lots the joint family of Dasap have partitioned the property as per annexure.
Annexure?
H partition deed lots.
Page number?
Page number 35. Under which lots Dasappa lots has been granted. Our Dasappa has been lots partition lots 9 acres 11 kuntas in his name. The said extent lots he has sold in favor of lots 1 Veerappa under J, page number 47. Lots I have purchased lots based Veerappa lots terms in favor lots. The said land has been sold in my favor as per annexure K lots, page number 59. Subsequently, lots mutation was my name lots and the land has been lots acquired by KIDB. As lots annexure N lots, page number 89. Lots thereafter lots the Tahsildar annexure P may kindly be seen lots, page number 90. Tahsildar has
Petitioner's name is Ramanjanappana.
Ramanjanappa. Tahsildar confirmed to give lots compensation in my favor, along with the of position lots, and thereafter page number 95 may kindly be seen lots annexure S. Even the DC has also confirmed lots to give the compensation in my favor. Subsequently, lots the DC has initiated suo motu proceedings to give the details of the grant lots.
2010
ನಲ್ಲಿ ಸೊನ್ನೆ
ಯಾವಾಗ ನೋಟಿಫೈ ಆಗಿದ್ದು ಅಕ್ವಿಸಿಷನ್ ಗೆ
2007 ಸೊನ್ನೆ
2007
ಹೌದೌದು
ಆಮೇಲೆ
ಅದಾದ್ಮೇಲೆ DC has initiated suo motu proceedings lots and ordered to record the name of the government in the RTC lots. Mutation cancel ಮಾಡಿ
2007 ಇಂದ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ನೀವು
2012 ಇಂದ proceedings initiate ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
What about the compensation? ಏನಾಯ್ತು?
ಹಂಗೆ ಇದೆ ಸ್ವಾಮಿ, ಇನ್ನ ಕೊಡ್ಲಿಲ್ಲ ನನ್ನ ಫೇವರ್ ಆಗಿ. Because the proceedings has been initiated subsequent to that lots.
Lord, may I make one submission, Lords?
Yes.
Lords, your Lordship may kindly see partition deed is dated 7/7/1975. According to them, my Lord, land is granted in the year on 25/1/1979. 79 ಅಲ್ಲಿ ಗ್ರಾಂಟ್ ಆದ್ರೆ ಆ ಲ್ಯಾಂಡ್ 75 ಅಲ್ಲಿ ಹೆಂಗ್ ಪಾರ್ಟಿಷನ್ ಮಾಡ್ಕೊಳ್ಳೋಕಾಗುತ್ತೆ?
ಅದು ಹೆಂಗ್ರಿ?
Proceedings of the year 1966-67.
Is the Sagwal chip, my lords. According to them, my lord, 25/1/1979 grant certificate issue ಮಾಡಿರೋದು. ಮತ್ತೆ ಅದನ್ನ 7775 ಅಲ್ಲೇ ಪಾರ್ಟಿಷನ್ ಅಲ್ಲಿ ನಾವು ಬಂತು ಅಂತ ಹೇಳೋದು.
Lords may kindly see annexure C, my lords. The proceedings has been in the year 1966-67. It's
ಆಯ್ತು ಸರಿ ಆಯ್ತಪ್ಪ. ಸಿ at any rate the RTCs reflect the name of these persons.
Then what is the basis for that RTC?
ದಾಸಪ್ಪ, ಆಮೇಲೆ ವೀರಪ್ಪ, ಆಮೇಲೆ ರಾಮಾಂಜನಪ್ಪ, ಎಲ್ಲ ಎಂಟ್ರಿ ಇದೆ.
136(3) ಅಲ್ಲಿ my lords, 136(3) ಅಲ್ಲಿ what is there is no basis for the entry of name of ದಾಸಪ್ಪ.
ಅದನ್ನ so you want to take it away by initiating suo motu proceedings.
Yes, my lord, it is empowered under 136(3) my lords.
ನೆನ್ನೆ ತಾನೇ ನಾವು ಒಂದು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದೆ, ಕೇಳಿಸ್ಕೊಂಡ್ರ ತಾವು?
ಯಾವುದು my lords? ಅಲ್ಲ, ಇದರಲ್ಲಿ
under 136(2) and 3.
Yes, my lord.
It is only a power vested with the authorities to change the name or the entry made in the revenue records.
ಅಷ್ಟೇ ನಾವು ಮಾಡಿರೋದು ಅಷ್ಟೇ my lords. ಅಷ್ಟೇ ನಾವು ಮಾಡಿರೋದು ಅಷ್ಟೇ, ಎಂಟ್ರಿ ತೆಗ್ದಿರೋದು ಅಷ್ಟೇ.
Under whose instance?
Sumoto proceedings 136(3) my lords.
Sir, adikkene there are decisions which say it has to be taken first of all within reasonable time ondo.
Also.
Eradnedu, I have been telling, see, you people don't think you are the custodians of the government lands. If the government is aggrieved, government has to move the authorities. You are not the government. Neither the deputy commissioner nor the assistant commissioner nor the tahsildar is the government.
Under 136(3) my lord.
ಅದೇ ದಯವಿಟ್ಟು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ, ಸುವೋಮೋಟೋ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಂತಂದ್ರೆ ನಿಮ್ಗೆ ಇಷ್ಟ ಬಂದಂಗೆ ಮಾಡೋದು ಅಂತಲ್ಲ. There has to be a complaint made by the government asking you to look into the matter and remove the names. ಎಲ್ಲಿದೆ ನಿಮ್ಗೆ? where do you get all these powers? ಸುವೋಮೋಟೋ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಂದ್ರೆ ಅರ್ಥ ಏನು?
My lord, there is no, my lord, your lordship may kindly see 136(3) my lords.
That is what I have considered all that. Yesterday I passed an order.
ಅಲ್ಲಲ್ಲ, ಈಗ
you don't point to any of the communications or requests made by the government. Yalla ನೀವೇ one hand in 2010 but the deputy commissioner gives a endorsement that the land belongs to this person, you can give compensation anta.
In the proceedings,
suomoto proceedings are initiated.
Proceedings, why he is not participated, my lords? He has not participated in the proceedings, my lord. That is the observation.
Sir, first of all, you will have to explain under what authority have you started these proceedings.
My lord, the tahsildar, my lord, is returned to the deputy commissioner, my lords, on 28/3/2012.
Tahsildar, from where does he get this authority? If it is a government land, it is for the government to initiate action.
The legislature has given power to the deputy commissioner under 136(3) my lords.
Under the scheme of this Karnataka Land Revenue Act,
yes, my lords,
you should notice that the appellate powers are never vested with the state government.
Yes, my lords.
It is vested with the Karnataka Appellate Tribunal.
No,
you know why? Because
the authority should be independent.
If it is a claim made by the state government, the state government cannot decide its own case.
Yes.
So therefore, that is why an independent authority like the Karnataka Appellate Authority is established.
Yes, Lord.
Adondo.
Yes, Lord.
Like any other individual,
yes, Lord,
even the state government has to approach the civil court.
Yes, Lord.
If there is some person in occupation of the government lands, in accordance with law, action has to be initiated by the state government to recover possession of the property.
Yes, Lord.
ನೀವು 136 provision ಕೆಳಗಡೆ you may do anything only to remove the names of the person.
Yes.
But what about possession?
Possession, we are not disturbing the possession. Only we are removing.
Then what is the use of removing the name from the revenue records?
Lord, when the entry is there is baseless.
Indirectly, all of you are misusing this provision. The authorities are misusing this provision, saying no, we have only passed orders to remove the name in the revenue records. Subsequently, they will start evicting them from the lands.
That is,
how is it permissible, sir?
There should be.
How is it permissible? You please tell me.
Your Lordship may kindly appreciate this. Under section 128.
If the government says it is the owner of the land, is it not for the government to initiate proceedings?
That's what I am trying to my lords. Under 128, my lord, how the mutation and revenue entries have been affected is provided.
You will have to answer.
Yes, my lord.
For how many years, decades together, you maintain the names of these persons in the revenue records? All of a sudden, one fine day, you will wake up and say, one officer will come and say, no, I don't find any records with him, so I will initiate suomoto proceedings. Is that the reason for which the suomoto powers are granted?
My lord,
Is
even
there
under
any
the earlier-
complaint made by the state government? In none of these proceedings, the state government comes forward to claim its rights over the property.
Then, my lord, they are the instrumentalities of the state, my lord. The deputy commissioner,
They are only
state government means, my lords.
They are the instrumentalities of the state. They can use powers only in the manner known to law.
Yes, my lord. What I am trying to submit is
They
this,
are
my lord.
only custodians to maintain the records.
Yes, my lord. That's what I am saying, my lord.
Therefore, unless there is a request made by the state government that the entries made in the land records are not correct, because this land belongs to the government, it is in occupation of some person. So action has to be initiated in accordance with law. Should there not be a request from the government?
Blood, when there is when legislature is directly empower the deputy commissioner, lad, where is the question of state government authorizing, my lads? When the
Authorizing
legislature
Allah.
itself,
Authorizing Allah.
Empowering, my lads.
Empowering to take suo action antandre.
Yes, my lads.
It is only in respect of maintenance of the records aste. All the deputy commissioners, assistant commissioners, tahsildars, in the guise of making a change in the revenue records, they are directing eviction of the persons from the lands.
By virtue of other provisions, not under 136(3), my lord. By virtue of operation of other law, my lords, they will take in possession. Land Revenue Act tells me there are other certain provisions how to take possession and all.
103, 104 you are referring to.
Yes, my lords.
Please read 103, 104. We will see. One not four. Summary eviction of person unauthorizedly occupying land.
Notwithstanding anything contained in the Karnataka Public Premises Eviction of Unauthorized Occupants Act 1961, any person unauthorizedly occupying or wrongfully in possession of any land which is not transferable by virtue of any condition lawfully annexed to the tenure under the provisions of section 91, section 98 or section 99 may be summarily evicted by the tahsildar, and any crop including trees raised in this land shall be liable to forfeiture, and any building or other construction erected thereon shall also, if not removed by him, up written notice as the tahsildar may deem be liable.
It is referable to lands which are not transferable.
Yes, my lords.
By virtue of any condition lawfully annexed to the tenure.
Yes, Lord.
Under the provisions of section 91, 98 and 99.
99, Lord.
Huh?
Yes, Lord.
91, 98, 99.
Yes.
Let us
Yes,
see
Lord.
91. Subject to such rules as may be made by the state government in this behalf, the deputy commissioner may require the payment of a price for unalienated land or sell the same by auction and annex such conditions to the grant as he may deem fit before permission to occupy such land is given under section 93. The andre unoccupied land it is permissible to be alienated under certain conditions.
Yes, Lord. The grant certificate under land grant rules, my lord, the grant certificate to be issued, my lord. Where, my lord, the rule 29 of the grant rules, my lord, empowers the authority to issue sagwali kit under section 91.
Correct.
Yes, my lord.
Now, there are entries in your revenue records
and some
maintained for decades together.
Yes, my lord.
Showing that this land has been granted to so and so.
Granted, Uncle Torsilla. That's why I am saying this. There is no reference to grant.
Mr. Srinivas.
Yes, ma'am.
David.
Yes, please.
From your own, Ivaga, what is the action sought to be taken to remove the name of this person from the revenue record?
Because, my lord,
Andre, his name is found in the revenue records.
Yes, that's why I may be permitted to read section 136(3), my lords. ಅದರಲ್ಲಿ ಏನು ಹೇಳುತ್ತೆ ಅಂದ್ರೆ, the deputy commissioner may the deputy commissioner may on his own motion or on application of a party call for and examine any records made under section 127 and section 129 and pass such orders as he may deem fit. Lord, here, my lord, what the deputy commissioner is required to see, my lord, while entering the mutation or revenue records under section 127 and 129, what is the basis for the authorities to enter revenue records? If there is no basis, my lords, the statute empowers the deputy commissioner to review that entries, my lords. By exercising this power, my lord.
So, Nodi, you have also come across decisions, not only of this court, but also of the Honorable Supreme Court, that I have passed orders referring to 2 decisions of the Honorable Supreme Court. Even in case where there is power for suo motu proceedings, it has to be initiated within reasonable time. If you read this provision very carefully,
yes, ma'am.
There are, of course, there is a provision for own motion or suo motu motion.
Yes, ma'am.
Or at the instance of a party.
Yes, ma'am.
Andre, illi the power granted to the deputy commissioner to initiate suo motu proceedings.
Yes, ma'am.
Can it be totally arbitrary?
It is not arbitrary.
Without giving any reasons.
No. Therefore, opportunity is to be given to the person whose entry is found in the records. Opportunity is given to this person.
Can it be initiated anytime, whenever you want?
Why big state is my lord. State is a state. State is a state, my lords. Everybody is to protect the state, my lords.
That is why we have passed several orders saying if the person continues in occupation of a land for decades together,
for a moment, my lord, I have given one.
Without following due process of law,
yes, ma'am.
You are aware that under the Limitation Act,
yes, ma'am,
there is a special provision for the
government,
state.
Yes, ma'am.
In other cases, it is 12 years. For the state, they have given 30 years.
Yes, ma'am. Yes,
for what reason?
From the date of knowledge.
Correct. Therefore, you are required to follow due process of law. Andre, you will have to approach the civil court for getting a declaration. If some person in occupation of the government land, can the state government make use of its own machinery to evict a person?
In that context, my lord, His Lordship Justice Ravindran rendered a judgment. Yes. I have given it to my lord, court officer, my lord, your lordship may pay. Our Anumaya versus state, my lords. Supreme Court how the government land is to be protected, how my lord, the officers have in collusion with the other parties for their own benefits, have misused their powers, and all that is discussed, my lords.
Yes.
Government is, my lord, government is everybody's.
Now we have been witnessing.
Yes, that's why, lads. Wherever
witnessing. I have functioned for more than 9.5 years as a government advocate.
Yes,
I know.
Yes, lads.
I know what is taking place and what kind of allegations are being made.
Yes, lads.
Against our officers.
Yes, lads.
In the guise of protecting government lands,
yes,
these officers,
yes,
are exercising these suo motu powers.
Yes, sir.
Only to extract money from these persons.
That is also, I will agree with you.
They don't have real interest in protecting.
That is, I will also agree. I will also 100% totally agree with your lordship, my lords. Wherever we found, my lords, wherever we found, it is genuine. then we have to my lord, stand up, my lords, to protect the government land. My lord, I will agree with your lordship, my lord. So far as the action of the authorities, I am not justifying, my lords. Wherever we found, my lord, we have to, my lords.
Sir, I will also go through that decision. If you have passed it on to the court officer, I will look into it also.
Yes, my lord.
But I am of the opinion that unless there is an information received from the government that these are government lands, please look into the matter and initiate action. I don't think your officers are entitled to make use of this suo motu powers.
Lord, in this matter, Lord, 2012 in the proceedings pending ಇದೆ. ಇವರು ಹೋಗಿಲ್ಲ ಅಂತ ಹೇಳಿ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. Opportunity is not given to these persons, or else they are not utilizing the opportunity. Your lordship may kindly page number 15, my lords. ಒಂದನೇ ಪ್ರತಿವಾದಿ ಪರ ವಕೀಲರು ದಿನಾಂಕ 24/11/2012 ವಿಚಾರಣೆಗೆ ಹಾಜರಾಗಿ ವಕಾಲತ್ನಾಮೆಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಅಂದಿನಿಂದ ಈವರೆಗೂ ಪ್ರಕರಣವನ್ನು ತಮ್ಮ ಪರವಾಗಿ ಸಮರ್ಥಿಸಿಕೊಳ್ಳಲು ಅವಕಾಶ ನೀಡಲಾಗಿರುತ್ತದೆ. ದಾವಾ ಸತ್ತು ಸರ್ಕಾರಿ ಗಮನ ಜಮೀನಾಗಿದ್ದು ಪ್ರತಿವಾದಿ ದಾವಾದಲ್ಲಿ ದಾಖಲಿಸಿರುವ ತಮ್ಮ ಹೆಸರಿಗೆ ಪೂರಕವಾದ ಮಂಜೂರು ದಾಖಲೆ ಹಾಜರುಪಡಿಸಿರುವುದಿಲ್ಲ. ಈವರೆಗೂ ಪ್ರಕರಣವನ್ನು ತಮ್ಮ ಪರವಾಗಿ ಸಮರ್ಥಿಸಿಕೊಳ್ಳಲು ಲಿಖಿತ ತಕರಾರು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. They are not utilized the opportunities. Therefore, let them go and whatever they want to say, let them say before the deputy commissioner.
Okay.
That page 19, Lords, annexure P, Lords, Tahsildar himself has
Nagaraj Reddy avare.
Please, Lords.
I don't know. See, whether you are appearing for this party for the first time or from 2007,
Lords,
they are in litigation and they don't know. They do not know how to prosecute their case. Compensation ತಗೊಳ್ಳದೇನೆ ಸುಮ್ಮನೆ ಕೂತಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತೀರಾ ನೀವು?
Please, Lords.
Is it only the question of entry in the revenue records, or is it the establishment of the title of the parties on the land?
Lords,
is it whether compensation is given to a party only based on the names mentioned in the revenue records?
No, Lords, the document.
Should you not establish your title over the property?
Yes.
You can do it.
What are you doing then from 2007?
Lords, in 2010 also, Lords, the deputy commissioner has recommended, Lords, for.
Why have you not gone before the civil court, sir?
Yes, yes.
Or you should at least ask for a reference.
Yes, yes.
There is section 30.
Yes, yes.
Providing for a reference. Yes, if there is a dispute in respect of the title, should you not ask for a reference? ಏನ್ ನಾವ್ ಇದನ್ನ ಹೇಳ್ಕೊಡ್ಬೇಕಾ ನಿಮ್ಗೆ?
ಇಲ್ಲ sir.
Merely because our deputy commissioner passes some order, it does not confer any title, my lords.
Lords may kindly remand at least to be given. Produce all these documents before the deputy commissioner and Lords.
ಮತ್ತೆ ಅದೇ ಮಾಡ್ತೀರಾ ನೀವು?
ಇಲ್ಲ Lords, ಅಲ್ಲಿ
you want to go before the deputy commissioner. And what he will do?
Lords, Lords, the Lords, that I have not produced any documents, Lords.
ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು. ನೀವು ಏನೇ ತಗೊಂಡು ಹೋಗಿ ತೋರಿಸಿದ್ರು they will write something. You should be able to advise your clients properly, sir. Why are you fighting with this deputy commissioner?
Yes, Lords.
Why don't you seek a reference under section 30?
Yes, that should have been done.
You try to establish your title over the property before the reference court.
Yes, Lords. Remind
for all the respondents. Next para. It is the contention of the petitioner that he has acquired ownership in respect of
annexure K, my Lords, page number 59.
Memorandum of writ petition ಏನು ಬರ್ದಿದ್ದೀರಿ ಹೇಳ್ರಿ?
Please. The first instance, the land was granted to Dasa in the year 19.
What is the extent of land on which you have acquired rights? First, adan heli.
Lords, the dispute is only in respect of 2 acres, Lords. But in the sale deed of
how much? In sale deed kagade ಎಷ್ಟು land ತಗೊಂಡ್ರಿ ನೀವು?
Lords, 2 acres, Lords. 7 ಎಕರೆ ಒಂದು 2 ಎಕರೆ ಒಂದು ಸ್ವಾಮಿ.
ನಿಮ್ಮ ಮೆಮೊರಾಂಡಮ್ ಆಫ್ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಏನು ಬರೆಯಲ್ವಾ?
ಬರ್ದಿದ್ದೀನಿ ಸರ್.
ಎಲ್ಲಿದೆ? ವಿಚ್ ಪ್ಯಾರಾಗ್ರಾಫ್?
ಪುಸ್ತಕದಲ್ಲಿ 15/11/1948 ಅಲ್ಲಿ 25 ಸರ್ವೆ ನಂಬರ್ 25 20 ಎಕರೆ ಗ್ರಾಂಟ್ ಮಾಡ್ತಾರಂತೆ ಅವ್ರಿಗೆ.
Yes, yes.
ಮತ್ತೆ 9 ಎಕರೆ 27 ಗುಂಟೆ ಗ್ರಾಂಟ್ ಮಾಡಿದಾರಂತೆ.
ಏನ್ ಹೇಳ್ದಮ್ಮ?
It is the contention of the petitioner that he has acquired ownership
in respect of 2 acres 11 guntas in old survey number 25 and new survey number 33 and 2 acres in survey number 25 with the specified boundaries, comma, under registered sale deed dated 17/8/1994. Full stop. The title of the property is traced to Sri R. Dasappa, who was in cultivation of cultivation of 9 acres 27 guntas along with 20 acres of land which were earlier granted in his favor. Stop. It is contended that R. Dasappa acquired right over the portion of the land by paying upset price in proceedings bearing LRP number 112/1966-67, and after receipt of the said price, the grant certificate bar Sagoli chit was issued in favor of Sri R. Dasappa on 25/1/1979. Full stop. Sri R. Dasappa sold
Page number 47.
Subsequently, in a partition between the family members, comma, under a registered partition deed dated 7/7/1975, comma, two items of the property bearing survey number 25, measuring 7 acres 11 guntas and 2 acres fell into the share of Sri R. Dasappa. Full stop. One Sri Veerappa purchased the said 2 items of property from R. Dasappa under a registered sale deed dated 16/8/1988. Stop. It is submitted that the names of the petitioner have been entered in the revenue records, and for that purpose an RTC. For that purpose, RTCs have been produced along with the memorandum of writ petition. Stop. At annexure M, comma, for the in the RTC for the year 1995-96, the names of Shri R. Dasappa is found rounded off in column number 9. Thereafter, the name of Shri K. Veerappa also is rounded off against MR number 2 of 2093. And thereafter, the name of the petitioner has been entered in MR number 2 of 1995-96. Stop. Next para. When things stood thus, a notification was issued by the state government for the purpose of acquisition of the lands along with the other neighboring lands for the benefit of the Karnataka Industrial Area Development Board for formation of industrial area, comma, industrial area, full stop. ಯಾವಾಗ ನೋಟಿಫಿಕೇಶನ್ ಇಶ್ಯೂ ಆಗಿದ್ದು?
17/5/2007 lords, ಗೆಜೆಟ್ ನೋಟಿಫಿಕೇಶನ್
ಎಲ್ಲಿದೆ?
ಪೇಜ್ ನಂಬರ್ 89 lords, annexure N ನೋಟಿಸ್ ನಲ್ಲಿ ಬರೆದಿದ್ದಾರೆ. 4th line.
Page number
89 lords, annexure N.
Notice.
ಎಸ್ ಅದರಲ್ಲೇ ಬರೆದಿದ್ದಾರೆ ಸರ್. ಅಧಿಸೂಚನೆ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಪತ್ರದ ದಿನಾಂಕ 17/5/2017 ಪ್ರಕಟಿಸಲಾಗಿರುತ್ತದೆ. 4th line.
The notification under section 28(4) of the Karnataka Industrial Area Development Act, 1966 was issued on 15/5/2007, and the final notification under section 28(5) was issued on
9/7/2007. That is the notice which has been issued.
Final notification ಯಾವಾಗ?
Final notification only 15/5/2007.
ಹಂಗಾರೆ preliminary notification
ಅದಕ್ಕೆ ಮೊದಲೇ ಆಗಿರ್ಬೇಕು ಮಿಲಾಟ್ಸ್. ಇದಕ್ಕೆ ದಿನಾಂಕ 15/5/2007 ಪ್ರಕಾರ ಭೂಸ್ವಾಧೀನ 28/4 ರೆಡಿ ಅಂತಿಮ ಅಧಿಸೂಚನೆ ದಿನಾಂಕ ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ 0. ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್ ಇಸ್ ಆನ್ 15.
ಇದು preliminary notification ತೆಗೆದಾಕ್ಬಿಡಿ. Final notification under section 28(5) of the Karnataka Industrial Area Development Act, 1966 was issued on 15/5/2007, proposing to acquire 2 acres of land in survey number 25/P10 belonging to the petitioner. Stop. Notice dated 9/7/2007 was also issued under section 28(6) of the Act to the petitioner, Stop. However, thereafter it appears that although the Tahsildar, Devanhalli Taluk had written to the Special Land Acquisition Officer of the KAADB stating that the records would show that the petitioner is the owner of 2 acres of land which is sought to be acquired, and therefore compensation may be paid to him. And the same having been reiterated at the hands of the Deputy Commissioner in his communication dated 16/1/2010 made to the Special Land Acquisition Officer, KADB, however, suo motu proceedings were initiated by the respondent Deputy Commissioner by invoking the powers under Section 136(3) of the Karnataka Land Revenue Act, 1964. In proceedings bearing number revision petition 13/2012-13. Full stop. The impugned order dated 20/12/2021 is passed by the Deputy Commissioner declaring that the land in question, which was notified for acquisition by the state government, is a government land, and therefore the entry of the name of the petitioner from the revenue records is directed to be removed, and the name of the state government is directed to be entered in the revenue records. Full stop. Next para. Learned counsel for the petitioner submits that it is clear from the impugned order dated 20/12/2021 that no opportunity of hearing is given to the petitioner. Full stop. Moreover, it is submitted that on an earlier occasion, the Tahsildar and the Deputy Commissioner have themselves communicated to the Special Land Acquisition Officer, as seen at annexures R, bracketly, dated 21/10/2009, and annexure S, bracketly, dated 16/1/2010, stating that the petitioner is the owner of the 2 acres which are notified for acquisition in survey number 25/P10 and recommended payment of compensation. Full stop. Next para. Per contra, learned AGA seeks to support the impugned order dated 20th of December 2021, passed by the respondent deputy commissioner. Stop. However, the learned AGA would accept the fact that opportunity of hearing was not granted to the petitioner. Full stop. Next para. Having heard the learned counsel for the petitioner, the learned AGA, and on perusing the petition papers, this court finds that the acquisition notification having been issued in the year 2007, the petitioner should have sought for a reference under section 30 of the 30 and 31 of the Land Acquisition Act, 1894. Stop. The issue is not about the entry in the revenue records. Stop. The issue is regarding the ownership of the land in question. Stop. If there are rival claimants, even if it is a claim made on behalf of the state government, the competent authority is the civil court, which is required to decide the title of the property which is sought to be acquired. Full stop. For this very specific purpose, provision is made in sections 30 and 31 of the Land Acquisition Act. Full stop. Next para. Consequently, while setting aside the impugned order dated 20th of December 2021, passed by the respondent deputy commissioner, this court directs the special land acquisition officer of the Karnataka Industrial Area Development Board,
under section 30, 31 and 31 and there are time limits,
Huh?
there is a time limit.
That's all right. That's all right. That is for enhancement of compensation.
Yes.
Enhancement of compensation.
18.
Adike there is a
yes, sorry, my lord, sorry. Yes, sorry.
There is a special land acquisition officer, the
KDB, to refer the dispute between the petitioner and the first respondent state government in the matter of ownership of 2 acres of land in survey number so and so, situated at Baladimmanhalli,
Chandrayapatna
Hobli, Devanahalli Taluk, Bangalore rural district, to the reference code under sections 30 and 31 of the Land Acquisition Act. Stop. The reference shall be made as expeditiously as possible and at any rate within a period of 4 weeks from the date of receipt of a certified copy of this order. Stop. Next para ordered accordingly.
Petitioner may be directed to serve this certified copy to this land acquisition officer because they are not the party.
The petitioner shall serve a certified copy of this order
along with the representation.
ಏನ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಬೇನ್ ಬೇಕಾಗಿಲ್ಲ
ಅಲ್ಲ, ಈ ತರ ಕೋರ್ಟ್ ಈ ತರ ಹೇಳಿದೆ, ದಯವಿಟ್ಟು ರೆಫರ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ ಅಷ್ಟೇ.
ಅಲ್ಲ that SLAO will take note of the directions given and he will refer the matter.
Petitioner shall serve a copy of this order, certified copy of this order
on the special land acquisition officer, KADP. Within a period of 2 weeks.
Yes, from the date of receipt.
From the date of receipt of a certificate copy of this order.
That's reference time frame may be granted. Lords, ಆಗಲೇ 13 ವರ್ಷ ಆಗೋಗಿದೆ, 14 ವರ್ಷ ಆಗೋಗಿದೆ.
ಹೌದು, ಇವಾಗ ಎತ್ತೆಚ್ಕೊಂಡ್ಬಿಟ್ರಿ.
ಅಲ್ಲ, ಹೈಕೋರ್ಟ್ ಇಂದ ಲೀಗಲ್ ಅಡ್ವೈಸ್ ತಗೊಂಡು ಹೋಗಕ್ ಬಂದಿದ್ದಾರೆ.
ಅದೇನೆ ಹಂಗೆ ಆಗಿದೆ ಇವಾಗ.
Reference time frame kindly.
No, sir. Mr. Fayaz Saab. Mr. Fayaz Saab. ಏನಿದು ಶ್ರೀನಿವಾಸ್?
They have sought for the writ of mandamus, Lord.
ಏನಂತ
ಅಂತ ಅದೇ ಅದು ಅವರು ವಕೀಲ್ ಡೆವಲಪರ್ಸ್ ಮಾಡಿದ್ದಾರೆ. ತಹಸೀಲ್ದಾರ್ ಇಸ್ ಇನಿಷಿಯೇಟಿಂಗ್ ಸ್ಟೆಪ್ಸ್ ಟು ಮಿಲಾಡ್ ಎವಿಕ್ಟ್ ದೆಮ್.
ಇವರೆಲ್ಲ ಸೈಟ್ ಓನರ್ಸ್
ಸೈಟ್ ಓನರ್ಸ್ ಅಂತ ಮಿಲಾಡ್. ಇದು ಅದೇನೋ ವಕೀಲ್ ಡೆವಲಪರ್ಸ್ ಏನೋ ಸ್ವಲ್ಪ ಇಶ್ಯೂಸ್ ಇದೆ ಅನ್ಸುತ್ತೆ. ಯಾಕಂದ್ರೆ ಖರಾಬ್ ಲ್ಯಾಂಡ್, ಅಕ್ಕಪಕ್ಕ ಇರೋ ಖರಾಬ್ ಲ್ಯಾಂಡ್ ಗಳಲ್ಲಿ ಎಲ್ಲ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಆನೇಕಲ್ ತಾಲೂಕಲ್ಲಿ. ಸೊ ಲಾಸ್ಟ್ ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ಮಿಲಾಡ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಇಸ್ ಗ್ರಾಂಟೆಡ್ ಎಂಟ್ರಿ ಮಾಡರ್. Malad, in respect of survey number 27, Malad, they are developing the land. Tahsildar is taken steps to protect the survey number 28. It is totally a government land.
Whatever it is, nothing can be done without notice to the affected party.
Yes.
Opportunity of hearing should be given to the affected party.
Yes.
And action can be taken only in a manner known to law.
ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ ಈ ಸರ್ವೆ ನಂಬರ್ 28 ಮೆಜರ್ಮೆಂಟ್ ಮಾಡಕ್ ಹೋದಾಗ ಅದನ್ನ ಒಂದು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ. ಆ 28 ಸರ್ವೆ ನಂಬರ್ ಮೆಜರ್ಮೆಂಟ್ ಮಾಡೋದಕ್ಕೂ ಅಬ್ಜೆಕ್ಷನ್ ಇರುತ್ತೆ.
ಅಲ್ಲ, ಮೆಜರ್ಮೆಂಟ್ ಮಾಡೋದಕ್ಕೆ ಅಬ್ಜೆಕ್ಟ್ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ.
ಆ ಕೇಸಲ್ಲಿ ಅಷ್ಟೇ.
ಇವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ, ಹೋಗ್ಬಿಟ್ಟು ಮಾರ್ಕ್ ಮಾಡ್ತಾರೆ
ಅಷ್ಟೇ.
ಇಲ್ಲಿಂದ ಇಲ್ಲಿ ಡೆಮಾಲಿಷ್ ಮಾಡ್ಬಿಡ್ತೀವಿ ಅನ್ಬಿಟ್ಟು
ಅದಕ್ಕೆ ಎದುರ್ಕೊಂಡು ಇಲ್ಲಿಗೆ ಬರ್ತಾರೆ.
Learned AGA takes notice for all the respondents. Learned counsel for the petitioner is directed to serve copies of the writ petition along with annexures on the learned AGA. Next para. ಅದು ಇನ್ನೊಂದು ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ ಕೊಡ್ತೀರಾ ಆಮೇಲೆ? Court of sir. Under similar circumstances, in WP number so and so, by an interim order dated so and so, this court directed the respondent Tahsildar not to precipitate the matter consequent to the impugned. ಏನಿಲ್ಲ, ನೋಟಿಸ್ ಏನಿಲ್ಲ.
ಅಪ್ರೆನ್ಷನ್ ಮೇಲೆ
precipitate the matter, till the next date of hearing. Full stop. Similar directions are issued in this matter also, directing the fourth respondent, Tahsildar, not to precipitate the matter till the next date of hearing. Matter is called out. ಬೆಳಿಗ್ಗೆಯಿಂದ ಇಲ್ವಾ ಬಂದ್ರಿ ಅವರು? Matter is called out. There is no representation for the petitioner. Relist this matter on 8th of February.
For the petitioner's case, Your Lordship, a press week's
Yes.
time to comply the office subjection, Your Lordship.
A week's time is granted at the request of learned counsel for petitioner for compliance of office objection.
Grateful, Your Lordship.
My lords, appearing for petitioner, my lords, I have to serve a copy to the KVS petition.
Rachit Kumar.
Release this matter on 10th of February 2022.
May I request this honorable court to tag one more matter, my lords, along with this.
In the meanwhile, a copy of the petition along with annexures shall be served on learned counsel Sri V.R. Prasanna, who has entered caveat on behalf of respondent number 2.
Please, my lords, FR number 16526 of 2021 may kindly be tagged this along with this, my lord.
FR number ಹೆಂಗ್ರಿ ಟ್ಯಾಗ್ ಮಾಡಕ್ ಬರುತ್ತೆ?
ಅದು ರಿಟ್ ಆಗುತ್ತೆ ಸರ್, ಅದರಲ್ಲಿ ಅದು ಪೋಸ್ಟ್
list FR number so and so
16526 of 2021
along with this matter. Yes.
Oblige, my lords.
Number 32, Ramamurthy Devi. 32. 32.
Matter is called out. There is no representation for the petitioner. Release this matter on 9th of February. In the meanwhile, office objection should be complied with.
33, Amit ZDRC.
Same order. 9th.
34 order passed. 35 giving internal clarification. 35 CGP.
Srinivas. Revision petition. Serial number 35 AGA.
Yeah. My lord, additional advocate general is on line, I think.
My lordship, AAG is not keeping well, my lordship. I request for a week's time. Statement of objection for applications filed by the petitioners have been filed. May I request for Monday or Tuesday, please, my lordship?
At the request of learned AGA, release this matter on 8th of February.
Please, my lordship. My lordship, serial number 35, interim order has to be extended, please, my lordship. My lordship, in serial number, interim order not to precipitate has to be.
Interim order granted earlier. Stands extended till the date of hearing. Nodre.
Not to precipitate the contempt.
Right.
Please, my lordship.
Yes. 37 anyway, government advocate.
For the petitioner in the second matter.
For the respondent, my lord.
ಏನಿದು?
Grant
ನಾವು ಲಾಸ್ಟ್ ಟೈಮ್ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ರಿ. Now that the physical hearing is starting, if my lords were to give a date for final hearing, now that all the objections have been complied by all the petitioners.
There is a batch of matters, sir. The others are there. I am ready in the batch.
ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಮಂಡೇ ಇಂದ ಫಿಸಿಕಲ್ ಹಿಯರಿಂಗ್ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ, ಅವಾಗ ಹಾಕೊಳ್ಳಿ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
Lordship, I have no objection.
Lordship, kindly
pressing not for a hearing for some time.
Huh?
My lord, 37.8, my lords. Your lordship has directed me to file a memo regarding service of notice, my lord. Last occasion order, my lords.
With
In
your
respect
lordship.
of service of notice to respond number 21A, respond 44C, my lord, I filed memo to that effect, my lords.
With your lordship's serial number 35.
35.
35 nalli, I have filed the detailed objections for continuation of delay and all, which has been filed by the state government. And
I have not passed any orders. I have adjourned the matter. Yes.
I was in the other court and all in Sweden because simultaneously it was coming. So by the time
additional advocate general ಅವರು ಬರಕ್ ಆಗಿಲ್ಲ ಇವತ್ತು ಅಂತ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳಿದ್ರು. I have adjourned the matter.
Very well, ma'am.
Yes.
37.8 ಅಲ್ಲಿ ಮೆಮೊ ಹಾಕಿದ್ದೀನಿ.
ಆಯ್ತು. Now it has to be heard and disposed of finally ತಾನೆ.
ಅದಕ್ಕೆ ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್ ಬಗ್ಗೆ ಮೆಮೊ ಹಾಕಿದ್ದೀನಿ.
ಆಯ್ತು.
ಪಬ್ಲಿಕ್.
So first petition is the government's petition, not so they have to.
Plus 37.8 ನು ಅವರದೇನೆ.
ಅದು ನಮ್ದು.
I'll list these matters on 9th of February.
9th ಬೇಡ ಸ್ವಾಮಿ. Other than second week ನಲ್ಲಿ ಮಾಡಿ. There are some number of second week of February.
Start on 9th. There are other matters also. The lordship may fix it on 9th. Start the hearing.
Other than 9th, any other date, 9th, some inconvenience for me. I appear in 3-4 matters for a petitioner also. Connected matter only.
Sorry, na 10th. 9th agila andre 10th.
Very good.
10th of February.
One matter which has to be connected. Not it's a 58596 of 2015.
List WP number
58596 of 2015.
Along with these matters.
5859.
Much of it. Yes. Yes.
I am appearing for petitioner in this case, my lord.
Appearing for respondent number 68.
Petition number 12 and 13 has died, my lord. I will take steps against petition number 12 and 13, my lord. 2 weeks time may be granted, my lord.
There is no respondent number.
Respondent alla petitioner.
Please.
Idunnu I have heard for some time.
Yes, my lord. My grant is of the year 1993 and 2004.
Yes. Learned Counsel for petitioner submits that petitioner's number
12 and 13, my lord.
12 and 13. Srimati Siddhamma
and Krishnappa
are no more. Stop. Learned Counsel prays for a short accommodation to file necessary application to bring the legal representatives on record. Stop. A week's time is granted to do the needful.
I appear for the applicants, my lord. The applicants are the legal heirs of the deceased petitioner. Application is in time. I have produced the death certificate. Therefore, kindly allow the applicants to come on record as the legal representatives of the deceased petitioner, my lord.
My lords, this is 79A and B. The original petitioner has passed away and an LR application has been filed, my lords.
But matter was pending.
Yes, my lords. 38893 of
So
16.
it has to be directly allowed.
Yes, my lordship. The IA for the LR application has to be allowed and petition has to be allowed.
Yes. Order on IA number 1 of 2021. This application is filed to bring the legal representatives of the sole deceased petitioner on record. So,
next month,
petitioner died on 22/9/2021, and this application is filed within time. It is stated in the application that the petitioner has left behind
The applicants as his legal representative.
the
Paragraph 3, my lord.
applicants as his surviving legal heirs, and the right to sue survives on them. Stop. Next para. Consequently, the application is allowed. The applicants are permitted to be brought on record as legal representatives of the sole deceased petitioner. Full stop. Learned counsel for the petitioner shall carry out the amendment in the cost title. Full stop. Amele same as 79AB.
Same as 38893 of 2016, my lords.
38893.
Yes, please, my lordship.
Same as 38893 of 2016. Yes.
I may be permitted to carry out the amendment 1 week.
You please do it, sir. Please do it. Yes.
I am the petitioner in this case, Miller. I file the LR application. During the pendency of the petition, the petition has died.
The application is within time, huh?
Moment. Yes, Miller.
Huh?
Yes, Miller.
Is within time.
Yes, Miller.
So same order, ma. Huh? Sole deceased petitioner died on.
Sorry, 12/2/2020, my lord. Sorry, 12/2/2020.
12/2/2020.
20.
But angry, how are you saying it is within time?
ಅಲ್ಲ ಸಾರಿ ಮಲಾಡ್ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಈಗ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡ್ಬೇಕು ಅಂತ
ಅಲ್ಲ ಸರಿ ಅದಲ್ಲ I asked you whether there is any delay.
ಸಾರಿ ಮಲಾಡ್ 12/2/2020 ಸಾರಿ ಮಲಾಡ್
ಮತ್ತೆ ಎಷ್ಟು ದಿವಸ ಡಿಲೇ ಇದೆ
ಅದಕ್ಕೆ 12/2/2020 ಮಲಾಡ್ ಐ ಫೈಲ್ಡ್ ದಿ ಎಲ್ಲರ್ ಅಪ್ಲಿಕೇಶನ್ ಮಲಾಡ್ ಅಂತ 3rd December 2021.
ಏನ್ರಿ ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಏನು ಪ್ರೇಯರ್ ಇಲ್ಲ
ಮಲಾಡ್ ದಿ
where is the prayer for continuation of delay, setting aside abatement?
ಇದ್ರಲ್ಲಿ earlier ಏನಾಗ್ಬಿಡ್ತು ಸ್ವಾಮಿ 3 ಅಪ್ಲಿಕೇಶನ್ ಮಾಡಿದ್ವಿ ಇವಾಗ
ಹೌದ್ರಿ you can file only one application.
Yes,
but should you not make the prayer?
Yes, I will make
ಏನಪ್ಪ ಇದು
ಇಲ್ಲ ಸಾರಿ ಸ್ವಾಮಿ ಇಲ್ಲ ಫೈಲ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ಹೇಳಿಲ್ಲ
ತೆಗೆದಾಕ್ಬಿಡಿ.
Yes.
Learned counsel for the petitioner submits that he may be permitted to file a better application.
Yes.
While withdrawing IA number 1 of 2021. Stop. Leave is granted. The application, a fresh application may be filed within 1 week from today.
Petitioner in this case, 41. 41, I am for petitioner. Notice may be added to the so notice has to go to the LS of the deceased R3 Manas.
R3.
Yes,
Issue notice on IAS number 1 to 3 of 2017 on the proposed respondents.
Lords kind of appear for the pleading applicant number IA number 2 of 2007, my lords. Needs a week's time to remove the office objections raised on IA number 2 of 2007. Office objection ಇದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Appear by the
IA number 1 of 2017 ಯಾರು ಫೈಲ್ ಮಾಡಿರೋದು?
ಅವರು ವಿ ಆನಂದ್.
I am for the applicant number IA 1 of 17 filed by the we are.
ಏನಿದು? Why are you trying to implicate in this matter?
What happened, my lords, the same property was the subject matter in one more writ petition, which was disposed of on 23rd of December in WP number 38-305 of 2012. So, the subject matter of the same writ petition was that the land was the Karnataka Public Property Corporation, or the proceedings were initiated under the proceedings of the Public Lands Committee. So, collected matter was disposed of on 23/12/2021, so 38,305. Now the present writ petition is filed seeking a mandamus in connection with the earlier order passed by this honorable court. Other the civil suits are also pending between the parties. Since there is a direction in the above petition 38/305, so our ಬಂದು ಹೇಳಬೇಕು ಸರ್, our petitioner appear ಆಗ್ತಿಲ್ಲ. ಈಗ our property is also involved.
The petitioner submits that land bearing survey number 5/2 measuring 4 acres granted under Gromor Food Scheme by the government and issued permanent grant certificate. Though RTC entered in the name of the original grantee since 1969, thereafter stood in the name of his sons as per division. And then there was a error committed by Revenue Authority in RTC. And the petitioner got acquired the land in question as legal heir of the family through will, which is not disputed. And the respondent still today, in spite of undertaking in the WP number so and so to comply the application of petitioner. An application?
ಏನು ಹೇಳಲ್ಲ ಸರ್, vague ಆಗಿದೆ. The government has to say whether the proceedings have been.
ಹೌದ್ರಿ, why is this impeding application filed?
Because they have ಈಗ ಅಲ್ಲಿ ಏನಾಗುತ್ತೆ ಸ್ವಾಮಿ ಅಂದ್ರೆ RRT 2 of CR 9 2008-9 ಅಲ್ಲಿ the original grant ಇವ್ರು ಹೇಳೋರು ಅವರು the state government has initiated the proceedings against Munivirama who got the property survey number 5/2 ಅಂತ ಹೇಳ್ತಾರೆ ಸರ್. some in another writ petition. Because 5/2 held and possessed by me. With that in context, I have filed the impeding application.
5/2, you say it's your property?
How do, sir? I have produced along with my application all the relevant documents I have produced. Since the office has raised objection again insofar as IA number.
ಈಗ ಅವರು ಇನ್ನೊಬ್ರು IA number 1 of 2017 ಅವರೇನ್ ಹೇಳ್ತಾರೆ?
Mr. V. Anand is appearing for one.
Lordship, I am for the 1 of 7 IA filed by the 1 of 17. What happened is, my lord, survey number 5/2 was originally allotted to Munira, Lordship. So Muniraಗೆ 5 ಜನ ಮಕ್ಕಳು ಇದ್ದಾರೆ ಸ್ವಾಮಿ. 5 ಜನ ಮಕ್ಕಳಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಆಗುತ್ತೆ. OS number 68 of 1998 ಅಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ. ಕಾಂಪ್ರಮೈಸ್ ಅಲ್ಲಿ 1 ಎಕರ್ ಐ ಮೀನ್ ಸೂಲಪ್ಪಗೆ ಅಲರ್ಟ್ ಆಗುತ್ತೆ, 1 ಎಕರ್ ಚಿಕ್ಕಣ್ಣಗೆ, 1 ಎಕರ್ ಮುನೀರಾಗೆ ಅಲರ್ಟ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ. So no way connected in this land lordship. So simply they are creating the deeds. So connected matter also disposed before the Honorable Court on 23rd Lordship.
ಅದು ಕಾಪಿ ಹಾಕಿದ್ದೀರಾ ಇಲ್ಲಿ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಕಾಪಿ ಹಾಕಿಲ್ಲ. I will furnish that copy and tomorrow by time. Meanwhile, I may be permitted to remove the office suggestion raised on.
ಯಾವುದು?
Swami, 38,305 of 2012, sir.
38,305
Swami.
of
2012. Disposed of on 23rd.
Councils. Disposed of on
23/12/2021.
Councils for the impleading applicants in IA number 1 and 2 of 2017 submit that in writ petition number 38,305 of 2012, which was disposed of on 23/12/2021, the dispute has been resolved. Full stop. Learned councils are requested to furnish a copy of the order dated 23/12/2021, passed in WP number 38,305 of 2012.
Please.
Full stop. Release this matter on 10th of February. In the meanwhile, office objections raised on IA number 2
Please, 2 of
2017 shall be complied with.
43, I appear for the petitioner. This is the matter pertaining to restoration of Pada. It was heard for some time last occasion, my lords. My lords were to fix a date. Restoration of Pada, my lords. The last time our government or file illa anta andru. I am ready, my lords. If my lords were to kindly fix a date in next day, week, my lords.
Yenappa sikta file?
Yes, my lords, I have the file.
Release this matter on 8th of February.
Macho.
Andaramu.
44, I appear for the respondent bank, my lord.
So in the last occasion, your lordship has said whether it's a commercial loan or a domestic. I also produced the copy of the brochure issued by the respondent bank, my lord. And I filed it before the Honorable Court on 20th January 2022 along with the decision. The decision is there, my lord. Our own High Court 2003 NOC. Copy of the judgment is also produced along with the brochure issued by the respondent bank, my lord. It is only 4% from the date of this one after the decree, my lord.
Allari, this is not a commercial transaction anadike. That is what was required.
This amount is loan was taken for the purpose of purchase of the site because he is residing in a rented house.
Adanna torsi sir, please show that one.
Page number 8 may kindly be permitted to take.
Page number 8.
Page number 8, only 8, 7 and 8. May submit, my lord. The top start to reject the claim of the petitioner.
Yavu 7 and 8 yavaga hakidira neevu?
Writ petition some. I'm sorry, my lord. Writ petition serial number 8, page number 8.
Page number 8.
Page number 8 of the writ petition. To reject the claim of the petitioner, the summation conjecture. Sorry. The order of the. Sorry, ma'am. Page number 21 may order of the trial court, ma'am. 21. Sorry, ma'am. Page number 21. Order of the registrar. Wadi Bankina. Page number 21. Top first line, ma'am. ವಾದಿ ಬ್ಯಾಂಕಿನ ಪರ ಸಾಕ್ಷಿ ಹೇಳಿಕೆ ಮತ್ತು ಹಾಜರುಪಡಿಸುವ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಒಂದನೇ ಪ್ರತಿವಾದಿಯವರು ನಿವೇಶನ ಖರೀದಿಯ ಉದ್ದೇಶಕ್ಕಾಗಿ 1 ಲಕ್ಷ ರೂಪಾಯಿಗಳು ಜಾಮೀನು ಸಾಲ ಪಡೆದಿದ್ದು ಸದರಿ ಸಾಲ ಬದ್ಧತೆಗೆ so that is taken for the purpose of purchase of the site because there is a shortage, because he is residing in a rented house, and the brochure is there produced at 20th January 2022, my lord. The brochure issued by the bank, my lord.
What are the amount you took for loan?
1 lakh.
Only 1 lakh.
Only 1 lakh for the shortage of the purchase of the site. For the purpose of purchase of the site, they have stated there. They also in the application is also there. It is for the purpose of purchase of the site. The application is submitted by the. May I request, my lord. 28th January, the brochure issued by the bank is also produced. First column, my lord. In the first column, seal number 4.
Griha Sala.
Vayaktika Sala. Group advance. The 3 persons have joined together and they have given a surety for him, and this man is also given a surety for other 2 persons. Seal number 4. 14% they have given it. 14% and generally 17 point so and so. So my submission only request is from the date of the decree only 4% has ordered to be by the registrar as well as the appellate tribunal also. In this regard, I produced the decision of our own High Court, AR 2003 NOC, recent decision of our own High Court, my lord.
ನಾವು ಫ್ಯಾಕ್ಟ್ಸ್ ಮೇಲೆ ಕೇಳ್ತಾ ಇದೀವಿ, ನೀವು ಡಿಸಿಷನ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಾ.
It is only, it is not for the commercial. It is only for the purpose of purchase of the site, my lord. It is not a commercial. Only.
Where is your application, sir?
Exhibit D, Exhibit 5. I could not able to produce. I get it recently, my lord. He is also filed this one document.
Yaro?
The bank advocate.
Ellide?
Exhibit 5, my lord. P5.
P5.
Whereas the parties to be first party.
Members of bank, whereas bank has agreed to sanction loan of ₹1 lakh for the purpose of site purchase.
Site purchase and pay the sum.
Yes, Learned Counsel.
My lord.
Eli, what is your submission?
My submission, my lord, it is in the down. If you come down in that same document, Exhibit P5, the members of the first party has agreed the bank for the principal debtor will repay the same or taken by the overdraft facilities.
Adalla, sir, adarದೇನು ಡೌಟ್ ಇಲ್ಲ. There is an agreed rate of interest. ಅದರ ಮೇಲೆ ಅದ್ರ ಬಗ್ಗೆ ಏನು ಡೌಟ್ ಇಲ್ಲ.
Yes, my lord.
ಆದ್ರೆ there is a specific provision under the CPC.
Yes, my lord. This is for the purchase of site, my lord. As a commercial transaction.
ಅದಕ್ಕೆ so
this is purchase of site. Is a commercial
we have noticed.
If it is for the commercial.
Section 34.
Yes, 34 of CPC.
Section 34.
It is for the purchase of site.
ಹೌದು.
Site purchase ಮಾಡಿದಾಗ commercial.
It is not a commercial transaction.
No, my lord. In fact,
it's not a CPC ಕೊಟ್ಟಿಲ್ಲ.
Residential purpose.
Section 34 of the CPC, my lord.
Yes. Section 34.
Proviso of subsection 1, my lord. I will read
yes,
it.
Yes.
Submission.
Yes.
Provided that where the liability in relation to the sum so adjudged arisen out of the commercial transaction, the rate of such further interest may be exceed 6% per annum, but shall not exceed the contractual rate of the interest, or where there is no commercial contractual rate. Here there is a contractual rate, and the rate of which the monies are lent, advanced as nationalized banks, are relation to the commercial transactions.
Provided
proviso
that where the liability in relation to the sum so adjudged has arisen out of a commercial transaction.
Yes, my lord. It's a commercial only. We are not given any for the, because we have taken the
For the purpose of purchase of a site.
Yes, my lord.
That is not a commercial transaction. Please understand.
Yes, my lord.
If it is for a commercial transaction, allu kuda commercial transaction alli the rate of such further interest may, provided that where the liability in relation to the sum so adjudged has arisen out of a commercial transaction, the rate of such further interest may exceed 6% per annum, but shall not exceed the contractual rate of interest or where there is no contract rate. So all this pertains to commercial transaction.
Yes, my lord.
Alli kelgade they have given an explanation.
Yes, my lord.
What is a commercial transaction?
National
explanation to
explanation for the purpose of relation to the transaction of a commercial transaction if the concerned with the industry, trade or business of the party in the liability.
Only those will be considered as a commercial transaction. Now you read the substantial provision.
Yes, my lord.
Subsection 1 you read now.
Where and so far as the decree is for the payment of money by the court may in the decree or order interest at the rate of such court deems fit to be paid on the principal sum adjudged from the date of the suit to the date of decree, in addition to any interest adjudged on such principal sum for any period prior to the institution of the suit, within further interest of such rate not exceeding 6% per annum as the court deems reasonable on such principal sum, from the date of decree to the date of payment of such earlier date of the court thinks fit. So
therefore
there are three parts, my lord. Till the date of suit, from the date of suit to date of decree,
correct,
from date of decree to payment.
Correct. So your contractual rate is applicable only till the date of filing the suit. Alluvargu same rate will be given.
Yes, my lord.
After that, the section 34 will take over. Except if it is a commercial transaction, then it may exceed 6%. But since it is not a commercial transaction, it cannot exceed 6%.
But from the till the realization from the date of the final order passed by this honorable court, it should be in the contractual rate.
We can only go by the provision of law.
Yes, the judgment what they have given. Adralle heltare Swami.
Section 34 does not say anything whether there is a contract between the parties in respect of interest payable or not. Adar bagge enu illa. It takes for granted that there is an agreed rate of interest. That will be applicable only till the date of filing the suit.
Yes, my lord.
Please read it.
Yes, I read it, my lord. There are three parts till the date of the decree filing of the suit.
So therefore, if there is a contract agreed upon, that will be applicable only till the date of filing the suit. Adadmele henge anbuttu it says there are three portions, as you rightly said.
Yes.
Accordingly, we'll have to do it.
But only thing is, my humble request is, my lord, the judgment which they have given in Union Bank of India versus Parshuraman, 2003 Karnataka 333, number 333, where it says that in the result the appeal is allowed, the part holding that the respondent plaintiff is entitled with an interest of 18% per annum from the date of suit till the date of decree, and 6% per annum from the date of decree till the realization.
Correct.
That is our case.
ಅದೇ ಮಾಡ್ಬೇಕಾಗತ್ತೆ.
That's our
date
case.
of suit in the till the decree has been realization. But for this,
Correct.
for the purpose of this adjudication in the pendente late, that has to be considered, man.
May I submit my one submission, well. After filing
Yes.
of this suit, I've deposited the amount with the respondent bank 1,29,150. The decreased amount is that has to be taken into consideration by them.
Correct. How's of course. Adralli
After
doubt
this-
illa.
That will be subject to calculations.
Adra ಬಗ್ಗೆ ಏನು doubt ಇಲ್ಲ sir. If you have deposited any money, that should be taken into consideration.
Only one submission, madam.
Yes.
The decreased amount is 97,679 on this 6% interest, and also deduct the amount what I have paid 1,29,150. If any amount is due, I'm ready to pay it, madam. Subject to calculation
that is how it is.
Also what is available there amount in the bank along with what I have paid it, you have to take into consideration. And if any excess amount is to be paid, I'm ready to pay it after calculating interest 6%.
Yes.
That's all my submission, man. Page number 22, may kindly see.
Although the prayer in this petition is to set aside, to quash and set aside the impugned order dated 28/3/2018 passed by the Karnataka Appellate Tribunal in Cooperative Appeal number 311 of 2014, at the outset, learned counsel for the petitioner submits that the petitioner would restrict his prayer for appropriate direction in the matter of payment of interest to the second respondent cooperative bank, having regard to the provisions of section 34 of the Code of Civil Procedure, 1908. Full stop. Learned counsel, next para, submits that it is clear from section 34 that in a suit for money recovery, the court is empowered to pass an order, to pass a decree ordering payment of interest at such rate as the court deems reasonable to be paid on the principal sum from the date of the suit to the date of the decree, in addition to any interest adjudged on such principal amount for any period prior to the institution of the suit. Stop. Further, section 34 also provides that the rate of interest shall not exceed 6% per annum on such principal sum from the date of the decree to the date of payment, or to such earlier date as the court thinks fit. Full stop. Next para. However, learned counsel for the second respondent bank contends that where there is a agreed rate of interest, comma, the court is required to decree the suit along with interest as agreed upon. Stop. Learned counsel for the petitioner seeks to rely upon
Memo along with the 20th I have filed along.
ಎರಡು ಹಾಕಿದಿರ ಇಲ್ಲಿ?
ಅಲ್ಲ ಇದೊಂದು ಕಳ್ಸಿದ್ದು ಸ್ವಾಮಿ ಈಗ ರೀಸೆಂಟ್ ಆಗಿ 2003 NOC.
ಅವತ್ತು ತೆಗೆದಿಟ್ಕೊಂಡಿದ್ದೀವಲ್ರಿ ನಾವು.
ಅಲ್ಲ along with the brochure I have filed. Along with the brochure of the bank, I filed it on 20th January, my lord, this year. Filed it in the counter.
ಅಲ್ಲ ನಾವು ತೆಗೆಸಿಟ್ಕೊಂಡಿದ್ರಲ್ಲ ಅವತ್ತು. AR 1987 Karnataka 236 semicolon ILR 2003 Karnataka 2236 and that
And ಮೊನ್ನೆ ಫೈಲ್ ಮಾಡಿದ್ದು AR 2003 NOC. Page 2241, my lord, operational portion of the order.
Section 34 of CPC reads as follows. Extract ಮಾಡ್ತೀನಿ. ಅದು ಪೂರ್ತಿ with explanation. In Union Bank of India, Dharwad, bracket ಅಲ್ಲಿ Supra, ILR 2003 Karnataka 2236. This court noticed that The provision refers to interest in respect of 3 stages. One relates to interest prior to and till the date of suit. Semicolon. The second stage is current or pendente interest from the date of suit till the date of decree. Semicolon. The third stage relates to interest from the date of decree till recovery or earlier date to be fixed by the court, which cannot exceed ₹6% per annum unless the liability for the payment of money arises out of a commercial transaction, in which event, as per the proviso to section 34(1) of CPC, it may exceed 6% per annum, but shall not exceed the contractual rate of interest and if there is no such contractual rate of interest, the rate at which monies are lent or advanced by nationalized banks in relation to commercial transactions. Stop. Reference was also made to a decision of a division bench of this court in the case of Canara Bank versus B. Sheshagiri Prabhu and others, 1984(1) KLJ 121, wherein it was held that so far as the current or pendente interest is concerned, it is wholly within the discretionary jurisdiction of the court, and that discretion operates even though there be an express agreement between the parties stipulating a particular rate of interest till the date of decree, should the matter go to court. Full stop. It was clearly held that the contract between the parties will not circumscribe that discretion of the court. Full stop. It was held that section 34 puts the matter in the area of judgment and takes it out of the area of contract. Full stop. Adverting to the provisos that were inserted by way of an amendment in the year 1976, the division bench also held that the further interest or interest from the date of decree till the date of realization, which otherwise under the terms of section 34 bracket 1 would exceed 6% only in a commercial transaction. Stop. Next para. Having regard to the said decisions, this court directed the learned counsels for the petitioner as well as the second respondent bank to point out to the type of transaction in the present case. Stop. Learned counsel for the petitioner draws the attention of this court to Exhibit P5, which was produced as Annexure R1, along with the statement of objections filed by the second respondent bank. So, this is the document or contract entered into between the petitioner and the second respondent bank. Stop. It clearly shows that a sum of rupees 1 lakh was sanctioned to the petitioner for the purpose of site purchase full stop. Next para. Explanation 2 provided under section 34 makes it clear that a commercial transaction is a transaction connected with an industry, trade or business of the party incurring the liability. Full stop. Therefore, it is clear from the material available on record that the transaction between the parties is not a commercial transaction. Full stop. That being the case, the interest payable by the petitioner from the date of decree till realization cannot exceed 6%. Full stop. Next para. Learned counsel for the petitioner submits that the petitioner has made
1,29,150 after the filing of the decree. So
made payment of a sum of rupees
1,29,150.
1,29,150.
150 to the bank. Paid. This deposit.
Yavaga?
Responded after the filing of the decree. After filing of the suit. Suit before the assistant registrar. After filing of the suit.
Before the assistant registrar.
ಅಲ್ಲ ಸೂಟ್ ಫೈಲ್ ಮಾಡೋದು ಅಸಿಸ್ಟೆಂಟ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಮಾಡೋದ್ಮೇಲೆ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ವಿ ಸರ್ ನಾವು.
ಹೌದು, ಹಂಗಾದ್ರೆ ಇಲ್ಲಿ ಕೆಎಟಿ ಮುಂದೆ ಇಲ್ಲಿ ಇಂಕ್ ಪೇಜ್ ನಂಬರ್ 22 ಅಲ್ಲಿ why it has not been it was not brought to the notice of the KAT.
It was brought to the notice of the KAT, they have not taken into consideration.
Nodi illi
vouchers also produced.
ಏನು ಹೇಳಿದ್ನಮ್ಮ?
My lord.
After.
My lord, with kind request, my lord, whatever the amount that they have paid, that will be considered.
No, I just wanted to know why it was not brought to the notice of the KAT. Because KAT could have taken that also into consideration.
Para number 11 ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ, judgment para number 11 ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ.
ಸರಿ ಸುಮಾರು 51,000 ಪಾವತಿ ಮಾಡಿರುತ್ತಾರೆ.
Subsequently I have paid. I have got all the vouchers.
ಸರಿ, ಹಂಗಾದ್ರೆ 51,000 ಬಗ್ಗೆ ಏನ್ ಹೇಳ್ತಾರೆ?
ಅದೇನು ಹೇಳಿಲ್ಲ ಸರ್.
ಅಲ್ಲ, if you read the operative portion, paragraph number 3. ಓದಿ.
ಎರಡನೇ ಎದುರುದಾರರು 19/9/2013 ದಾವಾ ಸಂಖ್ಯೆ ಸೋನ್ಸಲ್ ಮಾಡಿದ ಆದೇಶವನ್ನು ಎತ್ತಿಡಿಯಲಾಗಿದೆ. ಆದರೆ ಸದರಿ ಆದೇಶದ ಮೊತ್ತದಲ್ಲಿ ಮೇಲ್ವರೆದ ದಾವೆ ಚಾಲ್ತಿಯಲ್ಲಿದ್ದಾಗ ಪಾವತಿ ಮಾಡಲ್ಪಟ್ಟ ಹಣದ ಮೊತ್ತವನ್ನು ಲೆಕ್ಕಾಚಾರ ಮಾಡಿ ಅಷ್ಟು ಹಣವನ್ನು ಕಡಿತಗೊಳಿಸಲಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಕರೆಕ್ಟ್ ಹೇಳಿದ್ದಾರೆ.
But the bank is still it is adjusted towards interest ಅಂತ ಹೇಳ್ತಾರೆ. That amount is
ಗೊತ್ತಾಯ್ತು. ಏನ್ ಹೇಳಿದ್ನಮ್ಮ?
Submits that the petitioner has made payment of a sum of rupees also
after the suit was filed at the hands of the second respondent. Stop. Then counsel further submits that although the Karnataka Appellate Tribunal noticed the fact that the petitioner had paid a sum of rupees 51,000 as on the date when the order was passed by the KAT on 28th of March 2018. However, he directed that the same shall be taken into consideration. Firstly towards payment of interest. Full stop. Next para. Mr. Venkatramana.
Yes, my lord.
Is there any need to take note of your further submissions? I don't think it is necessary.
Not necessary. And the court can pass, my lord.
Alva? Yes.
My request is pendent late iddaga interest has to be considered.
ಅಲ್ಲ, ಅದಕ್ಕೇನೆ ಅದ್ರ ಬಗ್ಗೆ ನಾನು I have not interfered. Only after the decree is passed.
Pendent late iddaga ಅಷ್ಟೇ ಇರಲಿ ಸುಮ್ಮನೆ.
ಆಯ್ತು. For the reasons stated above, this court proceeds to pass the following order. 1. The writ petition is allowed in part. 2. While the impugned award passed by the first respondent, joint registrar of cooperative societies, and the Karnataka Appellate Tribunal regarding liability of the petitioner to repay the amount is not interfered with. However, the impugned orders are modified to the extent that from the date of the decree or award dated 19/9/2013, the petitioner will be liable to repay the outstanding loan amount with interest calculated at the rate of 6% per annum till the date of realization. Stop. Next. The total sum paid by the petitioner till date shall be taken into consideration. Shall be taken into consideration.
After calculating the 6%.
Stop. The second respondent bank shall calculate the amount payable by the petitioner in terms of the directions issued by this court. And inform the petitioner if there is any outstanding amount to be paid. Full stop. The intimation shall be given to the petitioner within a period of 2 weeks from the date of receipt of a certified copy of this order.
Yes, ma'am.
Stop. The petitioner shall pay the said sum without any further delay.
Yes, ma'am.
Yes, ma'am.
And at any rate within a period of 4 weeks
For
from
date
the
of
date of receiving
intimation.
the intimation from the second respondent bank.
Yes, ma'am.
Stop. Ordered accordingly.
Much obliged. Much obliged.
But the next matter I am withdrawing, my lord, with liberty to file fresh petition.
Why liberty?
But there is nothing in the writ petition. My friend who had filed the writ petition earlier did not make any pleadings, nor averments, nor documents. Court would be handicapped to do justice. My lord. That's the reason why I am withdrawing. Absolutely nothing, Lord. I examined the papers also, Lord. Some papers which I also got it from the party I found.
Learned counsel for the petitioner has filed memorandum of application under Article 226, bracket 3, read with Order 23, Rule 1 of the Code of Civil Procedure, seeking leave of this court to permit the petitioners to withdraw the writ petition, with liberty to file a fresh petition on the same cause of action. Stop. Next para. It is stated in the application that the writ petition was filed on the basis of information given in regard to the land on the basis of annexures A, B, and C. Stop. There are insufficient annexures in the writ petition containing little explanation. Stop. The writ petition was filed the memorandum of writ petition does not contain sufficient facts and grounds which would handicap the petitioner to go on with the matter under such circumstances. We'll stop. Next para. The said order. Stop. Espera. It is stated in the application that since the petitioners were not happy with the learned counsel on record who had filed this writ petition, the petitioners had requested the learned counsel to give NOC so that they could engage the services of another counsel. Full stop. However, in the meanwhile, the impugned order was passed. The order dated 24th of August 2021 was passed. Stop. Next para. Learned counsel, Shri B.B. Shivkumar, who has entered appearance for the petitioner, subsequently submits that along with the application, he has also filed along with the application for recall of the order dated so and so, he has also filed another application seeking leave of this court to withdraw the writ petition and to file a fresh petition on the same cause of action. Full stop. Next para. The submission of the learned counsel for petitioner is accepted. the order dated so and so is hereby recalled, full stop. The petition is restored to its original file. Yes.
My lord,
ಮುಗಿತಲ್ಲ ಆಯ್ತಲ್ಲ.
my lord, divisional bench of this court is in next.
ಇದಕ್ಕೆ for recalling the delay in filing the application for recall is condoned. ತಾನೆ? ಅದು ಬರ್ಲಿ ಫಸ್ಟ್ ಅದು ಬಂದು ಆಮೇಲೆ recall. Yes. All other matters will be listed next week.
Actually, one serial number 50, there's an urgency because of some interim order being read direction for non. Serial number 50, Lords. My request, Your Lordship, to have it tomorrow, Your Lords.
Tomorrow.
The urgency is that there is a special, there is a direction to act in a certain manner to the respondent number 2 and 3 Tahsildar, but still they have acted in contrary to the same. I've produced the documents before the Your Lordship also.
Let us see.
Serial number 84, my lord.
Interim orders to be extended, Lord.
Wherever interim orders have to be extended, you please mention it to the court officer. It will be extended. All other matters will be listed next week.
My lord, serial number 84 can be listed on 84.
My lord, one submission, my lord. Lord, one submission, my lord. Serial number 85, my lord, listed today. It is a fresh matter, my lord. It is listed as a B group. Lord, there is some urgency and the interim order is prayed for.
Sir, government advocate. Sir,
tomorrow or day after tomorrow.
You know, sir.
Sir, court officer. Sir, serial number 57, sir, on the next week. Next week 57.
Court officer, serial number 84.
Sir, serial number 27.
Next week, how on date court, sir?
Sir, serial number 27, government advocate, sir. A number ilbekalla, sir, WP. 27, fire staff, BG. Similar WP.
57.
Iri, sir. 27. 27 number ilbekalla, sir, ado. Serial.
Sir, adu Srinivas Gaudru ಹೇಳ್ತಾರೆ. ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ತೀನಿ.
ಹೌದಾ? ಆಮೇಲೆ
serial number
83, sir.
84. One second, sir. ಮತ್ತೆ ಇದು ಚಂದ್ರಣ್ಣ ಇದಾರ ಸರ್ ಇಲ್ಲಿ? ಆರ್ ಚಂದ್ರಣ್ಣ ಅಡ್ವೊಕೇಟ್.
Court officer, serial number 84.
Sir,
79.
Sir, court officer, serial number 57, sir.
Sir, serial number 39, R Chandran advocate online.
Sir. Sir, serial number 57.
Sir,
57, either 10th or 11th.
ಹೇಳಿ ಸರ್. serial number adjournment ಏನು ಹೇಳಿ ಸರ್?
57 ನಲ್ಲಿ ಡೇಟ್ ಯಾವ ತರ ಒಂದು 11th or 12th, sir.
ಸರ್, ಸ್ಟೇಟ್ಮೆಂಟ್ 57 ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ ಸರ್. ಅದೆಲ್ಲ
ಅಲ್ಲ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂದ್ರೆ ಡೇಟ್ ಕೊಟ್ಬಿಟ್ರೆ ದಯವಿಟ್ಟು.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಹೇಳಿ
ಆಗುತ್ತಲ್ವಾ
ಸರ್? ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಹೇಳಿ ಸರ್.
serial number 70.
serial number 70. ಹೇಳಿ.
serial number 50.
Sir, 70 ಅಲ್ಲಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಬೇಕು.
ಓಕೆ, ನೆಕ್ಸ್ಟ್ serial number 70.
Serial number 85, sir, 85.
serial number 83 ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
ಇಂಟ್ರಿ ಮಾಡೋರ್ ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ಬೇಕು.
ಡೇಟ್ ಕೊಡಕ್ ಬರಲ್ಲ ಸರ್. ಎಂಟ್ರಿ ಮಾಡಿರೋದು ಹೇಳಿ ಸರ್.
ಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್, serial number 61 ಅಲ್ಲಿ ಅಂಟಿಲ್ ಫರ್ದರ್ ಆರ್ಡರ್ ಇದೆ. ಮತ್ತೆ
84 serial number 84 11th ಇಟ್ಕೊಳ್ಳಿ
ಸರ್. ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಯಾವ್ದಲ್ಲಿ ಇದೆ ಅದನ್ನ ಹೇಳಿ ಸರ್ ಫಸ್ಟ್ ದಯವಿಟ್ಟು.
70 ನೋಟ್ ಮಾಡ್ಕೊಂಡ್ರಲ್ವಾ?
70 ಒಂದೇನಾ? ಓಕೆ, ಇನ್ನೆಲ್ಲ ಮಿಕ್ಕಿದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ ಸರ್. ಆಲ್ ಮ್ಯಾಟರ್ಸ್ ವಿಲ್ ಬಿ ಲಿಸ್ಟೆಡ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದ್ರೆ ಹೇಳಿ ಅಷ್ಟೇ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ನಂಬರ್ 50 ಸಬ್ಮಿಟ್ ಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್
ಇದೆ, ಅರ್ಜೆನ್ಸಿ ಇದೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್, serial number 61 ನಲ್ಲಿ ಅಂಟಿಲ್ ಫರ್ದರ್ ಆರ್ಡರ್ ಇದೆ. ಅದು ಎಕ್ಸ್ಟೆನ್ಷನ್
serial number 61 ಅದೇನ್ ಬೇಡ ಸರ್. ಅಂಟಿಲ್ ಫರ್ದರ್ ಆರ್ಡರ್ಸ್ ನೆಸೆಸರಿ ಇಲ್ಲ.
ಸರಿ.
serial number 50
ಮಾತ್ರ ಹೇಳಿ ಅಷ್ಟೇ.
serial number 50 ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ವಲ್ಲ ಇಳಿಬೇಕಾರ ಸಾಹೇಬ್ರು. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಡೇಟ್ ಕೊಡಿ ಸರ್. ಅದು ಎಂಟ್ರಿ ಮಾಡ್ರಿದೆ.
ಡೇಟ್ ಕೊಡಕ್ ಬರಲ್ಲ ಸರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಅವೆಲ್ಲ ಥ್ಯಾಂಕ್ ಯು.
84 serial number 84 11th ಇಟ್ಕೊಳ್ಳಿ. serial number 84 11th.
Court officer, this was request. Court officer. Serial number 84 ದಯವಿಟ್ಟು 11th ಅಥವಾ 14th ಇಟ್ಕೊಳ್ಳಿ.